your name.
Yes, madam.
They will assign a new number and they will retain your name.
Yes,
Your name will be deleted only if there is an inquiry
yes.
in the manner
and-
known to law.
Only-
That we can't inject.
ಹಾ,
That
ಅಲ್ಲ,
we can't.
136(3) ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಬಿಕಾಸ್ ಮಿಲಾಡ್ ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್ ದಿಸ್ ಮಿಲಾಡ್. ಅವರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ when the petition was pending and contempt was pending, they have issued an endorsement. Your lordship, I read out the endorsement in the last occasion where they have admitted my grant. Now in the statement of objections they are denying.
Show it very.
Yes, my lord. Kindly see the statement of objections ಅಲ್ಲಿ ಅವರೇ ಹಾಕಿದ್ದಾರೆ annexure R1. ಅವ್ರು ಸುಮ್ಮನೆ they are trying to, my lord, make me run from pillar to post. Kindly see annexure R1, my lords.
ಹಾಗಾದ್ರೆ ಇದು ಪ್ರಿಲಿಮಿನರಿ ಆದ್ಮೇಲೆ ತಗೊಳ್ಳೋಣ ಸ್ವಲ್ಪ.
ಆಯ್ತು.
I'll wait, just I'll pass over.
ಆಯ್ತು.
Immediately after preliminary.
ಆಯ್ತು.
We'll note that also.
ಆಗ್ಬೋದು.
Pass over. Yes, 3. What is this, madam?
Column 3 and 9. We will consider that. There is mismatch between column 3 and 9. After rectifying the same, after holding the inquiries, because that title is considered the representation.
ಏನ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು? ರೆಕ್ಟಿಫಿಕೇಶನ್ ಏನಾಗಿದೆ? ತಪ್ಪೇನಾಗಿದೆ ಮೇಡಮ್?
Grant excess ಆಗಿದೆ.
ಹಾ.
Actually available land is very less. Grant is more. So after rectifying all those mistakes, after holding an inquiry, then we will consider the representation.
ಈಗ ಏನ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವ್ರು ಮ್ಯಾಂಡಮಸ್ ಅಲ್ಲಿ?
For implementation of the article.
To make correction of extent in column number 9 of the computerized notice. ನಿಮ್ ಪ್ರಕಾರ ಏನು, there are too many grants? ಅಲ್ಲಿ ಗ್ರಾಂಟ್ಸ್ ಜಾಸ್ತಿ ಇದ್ರೆ ಹೇಗೆ ಮಾಡ್ತೀರಾ ನೀವು?
They will hold proper inquiry.
ಏನು, what is the procedure adopted by you?
All the RTCs are put into consideration. If it is excess, either it may be divided equally or it may be grant. If it is fake grant.
ಏನ್ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಮಾಡಿದೀರಾ? Are there any guidelines? How are you doing it? ಈಗ see, if there are 10 grantees, 10 acres of land ಇದೆ, 10 grantees.
There are guidelines. Only after rectifying the mismatch and AC.
ಇಲ್ಲ, ಒಂದೇ ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ಒಂದು, ಬೇರೆ ಸಪರೇಟ್ ಡೇಟಿಗೆ ಆರ್ಡರ್ ಆಗಿದ್ರೆ then you have to go on protecting the earlier grants.
Is eligible as per if is there in the
ಆಗಲ್ಲ. 1990ದಲ್ಲಿ ಒಬ್ರಿಗೆ 2 ಎಕರೆ ಕೊಟ್ರು, 92ದಲ್ಲಿ ಒಬ್ರಿಗೆ 3 ಎಕರೆ ಕೊಟ್ರು, 96 ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಕೊಟ್ರು, 2002ದಲ್ಲಿ ಬಂದಾಗ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಇರಲಿಲ್ಲ ಅಂದ್ರೆ ದಟ್ ಗ್ರಾಂಟ್ ಹ್ಯಾಸ್ ಟು ಗೋ. ಸೇಮ್ ಡೇ ಒಂದೇ ಕಾಮನ್ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ನೀವು ಈಕ್ವಲ್ ಮಾಡ್ಬೋದು.
different period ಅಲ್ಲಿ grants ಗಳಾಗುತ್ತೆ.
ಬಟ್ ಅದನ್ನೇ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ? ಮತ್ತೆ ನೀವು ಅಲ್ಲಿ ಪೊಸೆಷನ್ ಅವ್ರದ್ದು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿದೆ ನೋಡೋದನ್ನ ಮಾಡಿ.
How to handle?
No madam, no grant is based on spot inspection. ಎಲ್ಲ ಫ್ರಾಡ್ ಅಲ್ಲ ಮತ್ತೆ?
sketch ಮಾಡಿರ್ತಾರೆ.
ಅಲ್ಲ, ರೆಗ್ಯುಲರೈಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಮಾಡ್ತಾರೆ.
then unless extent is known, how you secure a spot inspection? ಎಲ್ಲ fundamentally flawed. If you go deep, your officers are
followed by proper procedure. Grant ಆಗಿ 20 ವರ್ಷ ಆದ್ರೆ ಅವರು ಕೋಡ್ ಮಾಡ್ಕೊಂಡಿರಲ್ಲ.
What is the total, madam? What is the total extent now of this land? Idea ilva? Is it a larger extent?
endorsement.
ಈಗ ಯಾರೋ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಲ್ರೆಡಿ ಎಂಕ್ವೈರಿ ಮಾಡಿದಾರಂತಾರಲ್ಲ ಅವರು, ಏನಂತ?
Page D, page 20.
ಯಾರು ಇವ್ರು ಬರ್ತಾರಾ? ಆನಂದ್ ಎಚ್.ಸಿ. ಯಾರು ಇವ್ರು? ಯಾರ್ರಿ ಗಿರಿ?
23 ಆದ್ರೆ ಇವಾಗೆ ಬರ್ತಾರೆ.
ಹಾ?
23 ಬಂದಿದ್ದು ಮತ್ತೆ ಇವಾಗೆ ಬರ್ತಾರೆ.
List it in B group. List it in B group.
Serial number 4, I'm appearing on behalf of the petitioners council, my lords.
Yes.
It's a very short issue.
File wakalat. For,
Because all the lands have been given to different departments. Getting the application.
no, let the private respondent, you appear for whom, madam?
Let's say the state, I don't know whether the state has filed their objections or not. So they will first have to have the courtesy of us sharing the copy of the objections before they start on this. Because I've been asking him whether they have served the copies. It appears he's called them. They said that they'll serve the copies, not serve the copies. They want to come here and say that we have moved the matter. At first, copies code.
Copies coding,
Ah.
madam, hand over copies. So and so accept notice to R8. Raised it to show his name. London DGA, has brought to the notice of this court that a statement of objection is sent, by way of email,
Email.
our counsel appearing for petitioner,
No, she's
submits.
I'll submit, my lords, the entire email
not
extract.
received
They are
the
not.
statement
Yes.
of objection. London DGA is hereby called upon to serve a hard copy of the statement of objection. Let this matter preliminary.
good.
Thursday happen in order. Yes, sir.
Date may find.
Thursday, Guruvara.
13th, I am not available, my lords. Either 14th or 12th. 13th, one day, my lords, there is
You are
some
not there.
inconvenience.
All right.
12th or 14th.
13th ಯಾವಾಗ ಆಗತ್ತೆ ಈಗ?
13th is Thursday, my lords.
17, we'll list it on Monday.
Very well.
Yes. Yes, interim order granted, release extended till next date. Next. Why?
Appearing for petitioner in this case, Mel. We are filed in this
Ah.
case. Writ of Mandamus, Miller.
Mandamus. Yes, madam. What mandamus?
The petitioner is the expropriated person on the account of acquisition of Sharavati river. They are the land losers, Miller. The government has assured to give alternative lands, Miller.
Yes, madam. Fresh matter ಇದು.
Available in any of the talukas, madam.
Ah.
At one branch, they say that the displaced person, they are not the land in Sharavati Mulagada Yojana. They made an application in Sagara Taluk office.
Ah.
And then they give representation to the Shivamoga district. We are following their application, madam. It is not start raising out their applications or requests. And the acquisition is up to get 62 long back, they are not.
But in your sequence section, list it in B group. Next.
Petition. And the petition is connected to the petition event.
ಏನಿದು?
Lords, it's an order passed by the respondent authorities, my lords, mutating the name of the respondent in respect of the property which has been allotted in the share of the petitioners here in Malad.
ಅಲ್ಲ, is it a preliminary matter or it requires consideration?
So far as my lord, the petitioners are claiming the right based on my lord, the wrong mutation entries, though they are not the members of the joint family. But anyhow, my lord, the Bhavati Khata has been affected in favor of the petitioners here. That order has been called in question after came to know that my lord, we are the members of the family. We challenged before the assistant commissioner. Assistant commissioner, my lord, rightly set aside the order and restore our name. That order has been called in question in the revision and dismissed, and present writ petition has been filed. Their main ground of attack is that, my lord, they are so far as respondent number 5 and 6 here in this.
My lords, shall I submit, my lords, before that? Because, my lords,
I asked
let
whether
him
this
not,
can be heard in B
let
group
him
or-
not mislead this court.
Ah.
The suits have been filed by very same petitioner.
Partition.
My lords, very rare. 1 minute, sir. My lords, kindly refer to page.
ಏ ನಂದೀಶ್ ಇತ್ತಿದ್ಲಾಗೆಲ್ಲ
Connection
ಜಗಳನ ಎಲ್ಲದ್ರಲ್ಲಿ ಜಗಳ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹಂಗೆ ಆಗಿದೆ. ಇದ್ರಲ್ಲೂ my lords, there is a
Hey.
fraud is being played.
Why Nandish is fighting in all the cases?
fraud
ಯಾರ್
is being.
ಹಾಕಿದ್ದಾರೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಯಾರು ಹಾಕಿದ್ದಾರೆ ಈಗ?
One ನಿಮಿಷ. Partition suit was filed by the impleading applicant. Now, my lords, after I filing this writ petition, my lords, prior to that, there is a declaratory suit filed by the respondents herein, contesting respondents herein, restricting their claim to an extent of 4 acres, 18 guntas. The total extent of the land is, my lords, 10 acres, 4 guntas, out of which, my lords, 8 acres, 36 guntas is the cultivable land. My lords, 1 acre, 8 guntas is the kharab land. This 8 acres, 36 guntas has been divided among 2 brothers. That is 4 acres, 18 guntas, to the branch of the,
ಡಿಗ್ರಿಯಲ್ಲಿದೆ.
my lords, not, oral partition is there. It has been acted upon. Sale deed has been executed. Confirmation deeds have been executed by the respondents themselves, accepting the title held by allotment of share in favor of Patalappa. My lords, kindly refer to the family tree, my lords,
ಎಲ್ಲಿದೆ?
page 36, annexure B, my lords.
Yes, sir.
Page 37, my lords. Your lordships, refer to page 37. My lords, Venkat Swamappa, my lords, in his wedlock, he had 2 sons. That is Muni Hanamaya and Chikhanmantappa. My lords, in this, Muni Hanamaya had 2 daughters. That is Muni Maraka and Muni Venkamma. My lords, the Patalappa, my lords, what the now 4 acres, 18 guntas, whose name has been mutated in the revenue records prior to, my lords, 80s, even prior to that. My lords, 4 acres, 18 guntas have been allotted to the share of Patalappa. That is the branch of Muni Hanamaya. My lords, now, right side, my lords. Chikhanmantappa, my lords, his son is Venkat Swamappa, Muni Hanumakka.
ಆ ಬ್ರಾಂಚ್ 4 acres ಬರುತ್ತಾ?
Aurang 4 acre, 18 guntas has been allotted. My lords, out of this 4 acres, 18 guntas, he alienates to an extent of 2 acres and odd, and only retains to an extent of 32 guntas.
ಯಾರು? ಶಿವಣ್ಣ.
That is Venkatramappa.
He only sells.
Yes, my lords, he himself has sales in 2 sale deeds. Subsequently, my lords, in the branch of my lords, that is Muni Hanamaya, 4 acres, 18 guntas have been divided among two family members. That is Muni Maraka and Muni Venktamma. Muni Venktamma executes a sale deed in respect of 2 half share. That is 2 acres, 9 guntas in favor of 1 Galappa. That is confirmed by the other family members of Venkatramappa.
ಅವರು
Yes, my lords.
ಕನ್ಫರ್ಮೇಶನ್.
Yes, my lords. Now, yes, as the facts stood at the stage, my lords, now the revenue records have been mutated in the names of both the family members from time immemorial. Now, my lords, in respect of 32 guntas, what Venkatramappa has retained after alienating, my lords, her daughter-in-law, his daughter-in-law, that is Anita alias Lalitamma, that is wife of Shivanna, files a proceedings, initiates proceedings against the so-called the name whose name was mutated in the revenue records. She restricts her claim to an extent of 4 acre, 18 guntas, and specifically states that 4 acres, 18 guntas has been allotted to the share of the family members of Patalappa, that is Muni Maraka, and sought for mutating her name to an extent of 32 guntas. Kindly refer to that order, my lords. My lords, it is at annexure D, page 58. Anitamma, that is the wife of Shivamana, now who is the respondent herein, files an appeal under 136(2). My lords, kindly refer to facts of the case, my lords, page 59. The appellant submits the land was totally measuring to an extent of 10 acres, 4 guntas, including 1 acre, 8 guntas, Karab. It is submitted that land was granted to one Patalappa and Venkat Swamappa, 4 acres, 18 guntas each. My lords, it is on affidavit before the authorities. That is 4 acre, 18 guntas in favor of Patalappa, 4 acres, 18 guntas in favor.
You said that there is a partition between.
My lords, that has been forthcoming in the revenue records, my lords.
Muni Hanumantaya and.
Yes, my lords. My lords, what has happened? Muni Hanumaya dies. My lords, after his death, this Patalappa's branch he is the male member, my lords. He has been representing for the branch of
Muni
Muni
Hanamaya.
Hanamaya. And the Venkat Somappa, my lords, he represented the branch of,
Who are you? You have purchased 2 acres, sir.
my
You
lords,
have purchased.
I am the branch of Manamars Patalappa.
Correct. ಅಲ್ಲ
Yes.
ನೀವು 2 acre
My lords, ನಮ್ಮ ಚಿಕ್ಕಮ್ಮ ಮಾರಿದ್ದಾರೆ. My lords, 2 acres, 9 guntas.
So you are holding 2 acres.
2 acres,
18 guntas.
2 acres, 9 guntas.
9 guntas.
Yes, my lords. Now, my lords, kindly refer to this, the proceedings before the Assistant Commissioner, my lords, where she has filed an appeal against one Srinivas Murthy.
ಯಾರು ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಯಾರು?
My lords, some third party whose name was mutated in the, to an extent of 32 guntas.
ಆಲ್ರೆಡಿ ಏನಾಗಿದೆ ನಿಮ್ದೀಗ? ವಾಟ್ ಇಸ್ ದಿ ಡಿಸ್ಪ್ಯೂಟ್ ಈಗ?
Now, my lords, even the waters, the share allotted to the share of my lords Patapalappa's branch is claimed a right over this property also
ಯಾರು? ಬೈ whom now?
by Shivamma. Very appellant before the Assistant Commissioner. My lords,
ಯಾರು? ಶಿವಮ್ಮನ್ನ?
yes, my lords,
ಲಲಿತಮ್ಮ
Lalitamma alias Anitamma, sorry.
ಅವ್ರಿಗೆ ಮತ್ತೆ 4 ಎಕರೆ.
Yes. My lords, how fraud been played, my lords kindly refer to that, my lords, facts of that case. 4 acres, 18 guntas each. The Patalappa along with the Katedar brother.
ಗೊತ್ತಾಯ್ತು ರಮೇಶ್, ಗೊತ್ತಾಯ್ತು. ಈಗ ವಾಟ್ ಇಸ್ ಇಟ್ ಅಂಡರ್ ಚಾಲೆಂಜ್ ನಾವು? ಎಸಿ ಮುಂದೆ ಯಾರು?
My lords, Assistant Commissioner ಮುಂದೆ ಅವರೇ ಹೋಗ್ತಾರೆ. That is the order at.
ಅಲ್ಲಿ ಹೋದಾಗ ನಿಮ್ಮ ಹೆಸರಿತ್ತ 4 ಎಕರೆ ನಿಮ್ದಿತ್ತ?
Yes, my lord, that has been set aside.
ಅದು ಎಲ್ಲಿ ಪಟಾಲಪ್ಪ ಮತ್ತೆ
ಹೌದು.
ವೆಂಕಟ ಶಾಮಪ್ಪ ಅವರು
Yes, my lords.
under mutation they got it divided.
Yes,
Which is that MR number?
my lords, that is. My lords, page 29. Page annexure A, my lords. Page 28. '27 only, my lords, is the index of land. My lords, it can be seen at first alene 10 acres ali 4 acres 18 guntas Patalappa, 4 acres 18 guntas Venkat Somappa. Page 29, my lords.
ಇದು ಟ್ರೈಪಡ್ ಅಲ್ಲಿ ಇದೆ, ಟ್ರೈಪಡ್ ಇಲ್ವಾ?
Typed it. My lords, I will produce that. Annex page 33, my lords.
ಎಲ್ಲಿ ಏನಿದೆ 33 ದಲ್ಲಿ?
Beginning to 6 of 83-84. That order itself has not been passed. Without there being an order, mutation has been registered. This is the findings recorded by the Assistant Commissioner.
Nandish, as of now, in mutation proceedings, in your appeal, you admit that both branches have 4 acre
I
each.
specifically denied, my lord, he is the member.
It is your appeal.
For the, in this regard, yes,
So-
my lord, in this regard, 2 suits for the relief of declaration and partition is pending for consideration. The findings recorded by the Assistant Commissioner is that, my lord, I have seen 6 of 83.
Tell me that how, just a minute, just a minute,
Endorsement has also.
just a minute. What is your right? How we can sell?
It is my ancestral property. my
Ah,
lord.
go on,
88
based on-
acres, 36 quintas.
Based on what? Based on what?
Records,
Huh?
Revenue records.
ಮತ್ತೆ?
ಇಲ್ಲಿ, he is not a member, may not so far as petitioner here in whatever rights he is claiming, he is not a members of the family.
Where to decide, where to?
Based on that, based on that, I had seen, my lord, the 6 of 83-84. 2 acres, 9 guntas, my lord, he has already entered into an agreement, though he is not the owner of the property.
ಅಲ್ಲ ನೀವು ಅವ್ರ ಓನರ್ ಇಲ್ಲ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ? ನೀವು ಓನರ್ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತಾ ಇದೀರಾ?
My lords,
Let that be decided in a partition.
my lords, a suit for declaration has been filed by the very respondents before the learned trial judge to an extent of, my lords, 1 acre 16 guntas. ನಾನು ಹೇಳ್ತೀನಿ ಒಂದ್ ನಿಮಿಷ.
22 ಗುಂಟೆ
ಒಂದ್ ನಿಮಿಷ sir. My lords, 1 acre 18 guntas. My lords, in those proceedings, my lords, this Venkat Somappa had 3 wives. Kindly refer to that family tree. my lord.
ಇವತ್ತೇ ಬಂದಿದೆ, ಏನ್ರಿ ಇದು? ಸ್ಟೇ ಇದೆಯಾ?
Stay there.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಸ್ಟೇ ಇದ್ರೆ
Stay there.
why are troubling this court in preliminary?
Sorry.
ಅದನ್ನೇ ಕೇಳಿದೆ ಫಸ್ಟ್, ಅವ್ರಿಗೂ ಅದನ್ನೇ ಕೇಳಿದೆ. It requires
Hey.
consideration, entry order ಇದೆಯಾ?
Entry model.
Why have
Entry model.
entry order granted early is extended. Absolute ಇದೆಯಾ? ಬರೀ ಇಲ್ಲಿವರೆಗಿದೆ.
Till date ಅಂತ ಇದೆ.
Till date, The matter requires deeper examination at the hands of this court. Therefore, the interim order granted by this court is made absolute pending consideration of the caption petition. Let this matter in big requirement.
My lords, one, they have, I think, my lords. That is, she is none other than the daughter of respondent number 4 and 5, who has filed a suit during pendency of these proceedings.
All right, it will be there, you'll be entitled to contest. Impleading application to be heard along with the main matter,
Much of.
connected with it. Yes, next.
Lords, my application for grant of occupancy rights, that is form number 7A, has been rejected by the tribunal as well as the first respondent KIT, my lord. The original, the landlord, that is Shamanna.
Why did you miss the bus in 1974?
Pardon me.
Why you missed the bus in 1974? Why you didn't file a form number 7? In
Form number
1974?
7 was not filed by me, but for the remaining extent which was cultivated by my paternal uncle, he had filed a application and that land has been granted. My lord, at that time, the landlord has given a statement before the tribunal that the remaining 1 acre 28 guntas has been cultivated by this petitioner here.
There is a statement.
Yes, there is a statement. Now the respondent, the contesting respondents claim that the landlord's wife has executed a will in their favor in the year 2003. And based on that will,
Oh, they are not, they are the legatees.
legatees, the original landlords, they do not have any
They are not
issues.
contesting.
They are dead. They have no issues.
No issues.
No issues. The landlord as well as his wife, both have given statement before the tribunal. The landlord's wife, that is Jayamma, she has filed an affidavit before the tribunal.
ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ಯಾರ್ರಿ ಮಾತಾಡ್ತಾ ಇರೋದು ನಿಮ್ ಹಿಂದ್ಗಡೆ? ನಿಮ್ ಹಿಂದ್ಗಡೆ ಯಾರು ಮಾತಾಡ್ತಾ ಇದಾರೆ ಸ್ವಲ್ಪ ಸರಿರಿ. Where is the statement?
Statement, page 63, typed copy of the statement, that is Shaman or
Page 63.
63, typed copy. Annexure Jmail.
Your uncle filed to
Yes,
half.
yes, yes.
What is the total extent?
3 acre 28 guntas.
3 acre.
5 acre, the total extent is 5 acres 8 guntas.
Ah.
3 acres. 3 acres he has filed an application. 3 acre 20 guntas. My paternal uncle has filed an application.
Oh, he filed a form. number seven.
Our farm number 7.
Balance 1 acre 28 guntas in.
The
ಅದು ಮೇಲೆ ನಿಮ್ಮ
third Kempan's son has filed the
ಈ
application.
ಜಮೀನು ಪೈಕಿ 3 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನು ಸರ್ವೆ ಗಿಡ್ಡ
ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ ಫಸ್ಟ್.
ಕಂಪಯ್ಯ ಇಲ್ಲಿದ್ದು
3 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಮತ್ತು ಉಳಿದ 1 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನನ್ನು ದೊಡ್ಡ ಕಂಪನಿಯವರೆಗೂ ಕೊಡಬಹುದೆಂದು ಹೇಳಿಕೆ ಇಟ್ಟಿರುತ್ತೇನೆ. ಇದರಲ್ಲಿ ನನ್ನ ಅಭ್ಯಂತರವೇನು ಇಲ್ಲ. He has no objection. He has stated that my father was cultivating my paternal.
ಎಲ್ಲಿ ಓದ್ರಿ ಅದು ಎಲ್ಲಿದೆ?
ಓದ್ತೀನಿ ಸ್ವಾಮಿ. ಯಲಹಂಕ ಹೋಬಳಿ ಲಕ್ಷ್ಮೀಸಾಗರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 13 ಖರಾಬು ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 8 ಗುಂಟೆ ಜಮೀನು ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಇರುತ್ತದೆ. ಈ ಜಮೀನನ್ನು ಹೀಗೆ ಸುಮಾರು 15 ವರ್ಷಗಳ ಹಿಂದೆ ನಾಗದಾಸೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಚಿಕ್ಕ ಕೆಂಪಯ್ಯ ಬಿನ್ ಚಿಕ್ಕ ಆಂಜಿನಪ್ಪ, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್ಸ್ ಫಾದರ್ ಮೈ ಲಾರ್ಡ್, ವಾರ ಸಾಗುವಳಿ ಕೊಟ್ಟಿರ್ತೇನೆ. ಈ ಜಮೀನು ಪೈಕಿ 3 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನಲ್ಲಿ ಸರ್ವೆ ಗಿಡ ಚಿಕ್ಕ ಕೆಂಪಯ್ಯ ಇಲ್ಲಿದ್ದು ಹೀಗೆ 4 ವರ್ಷಗಳ ಹಿಂದೆ ಸರ್ವೆ ಗಿಡಗಳನ್ನು 6,900 ರೂಗಳಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಅದರಲ್ಲಿ 1,405 ರೂಗಳು ಮಾತ್ರ ನನಗೆ ಸಂದಾಯವಾಗಿರುತ್ತದೆ. ಬಾಕಿ ಉಳಿದ 1 ಎಕರೆ 28 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಸರ್ವೆ ಗಿಡ ದೊಡ್ಡ ಕೆಂಪಯ್ಯ, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್ಸ್ ಫಾದರ್, ಇಟ್ಟಿದ್ದು. ಆದರೆ ಇವುಗಳು ನೋಡಿ ಇದರಿಂದ ಬಂದ ಹಣವನ್ನು ನನಗೆ ಕಳಿಸಿರುವುದಿಲ್ಲ. ಸರ್ವೆ ಗಿಡ ನೋಡಿ 4 ವರ್ಷಗಳಿಂದ ಈಚೆಗೆ ಅಂದರೆ ಚಿಕ್ಕ ಕೆಂಪಯ್ಯ ಮತ್ತು ದೊಡ್ಡ ಕೆಂಪಯ್ಯ ನನ್ನ
ವಾಟ್ ಇಸ್ ದಿಸ್ ಲ್ಯಾಂಡ್? ಕಲ್ಟಿವೇಟೆಡ್ ಲ್ಯಾಂಡ್ ಆರ್ ವಾಟ್ ಇಸ್ ದಿಸ್?
ಕಲ್ಟಿವೇಟಿಂಗ್ ಲ್ಯಾಂಡ್ಸ್. ಅದರಲ್ಲಿ
ಮರಗಳು ಏನದು?
ಮರಗಳು ಇವರು ಹಾಕಿದ್ದು.
ಆಲ್ ರೈಟ್.
ಹೀಗೆ 4 ವರ್ಷಗಳಿಂದ ಚಿಕ್ಕ ಕೆಂಪಯ್ಯನವರು ಬಂದು ಮೇಲೆ ಮಾರಾಟ ಮಾಡಿದೆ.
RTC of 19.
RTC, your honor, at page typed copy of the RTC, page 89. 85 ಇಂದ ಇದೆ. 86, 87 is the typed copy. Page 89. Page 89 ಅಲ್ಲಿ typed copy is at page 91. 70, 71 ಅಲ್ಲಿ ದೊಡ್ಡ ಕೆಂಪಯ್ಯ, ಚಿಕ್ಕ
ಹಾ.
ಕೆಂಪಯ್ಯ,
ದೊಡ್ಡ ಕಂಪೈಸ್
ಚಿಕ್ಕ ಕೆಂಪಯ್ಯ, ದೊಡ್ಡ ಕೆಂಪಯ್ಯ petitioner's
Get
father.
ready, sir, final hearing. All right. That's all.
That's all.
Yes, sir.
Here, Dodda company, we have not given the land. The total land was given to Chick company. That is what the board says. ಈ ಜಮೀನು 15 ವರ್ಷಗಳಿಗೆ ಚಿಕ್ಕ ಕೆಂಪಯ್ಯನವರಿಗೆ ಸಾಗುವಳಿಗೆ ಕೊಟ್ಟಿದೆ. ಫಸ್ಟ್ ಲೈನ್.
ಈ ಜಮೀನು ಬಗ್ಗೆ ಸುಮಾರು 15 ವರ್ಷಗಳ ಹಿಂದೆ
ಚಿಕ್ಕ ಕೆಂಪಯ್ಯನವರಿಗೆ ವಾರ ಸಾಗುವಳಿ.
ಗ್ರಾಮದ ಚಿಕ್ಕ ಕಂಪಯ್ಯ ಬೆನ್ನು ಚಿಕ್ಕ ಅಂಜನಪ್ಪನವರಿಗೆ ವಾರ ಸಾಗುವಳಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. Total extent is 5 acres 8 guntas.
Yes. Total was given to him.
Ah.
There were two brothers, Chikka Kampaya and Putta Kampaya.
Ah.
This Chikka Kampaya, 3 ಗುಂಟೆ 20 ಗುಂಟೆ ಜಮೀನು ಚಿಕ್ಕ ಕೆಂಪಯ್ಯ ಇಟ್ಟಿದ್ದು ಈಗ 4 ವರ್ಷಗಳ ಹಿಂದೆ ಇದನ್ನು ಮಾರಿ ನನಗೆ 1405 ರೂಪಾಯಿಗಳು ಮಾತ್ರ ಸಂದಾಯವಾಗಿದೆ. ಬಾಕಿ ಉಳಿದ 28 ಜಮೀನಿನಲ್ಲಿ ಕರಿವೆ ಗಿಡ ಇದ್ದು ಅಂತ ಬರೆದು ಹೊಡೆದಾಕಿದ್ದಾರೆ.
ಗಿಡ ದೊಡ್ಡ ಕಂಪಯ್ಯ ಇಟ್ಟಿದ್ದು
ಇದ್ದು ಅನ್ನೋದು ಹೊಡೆದಾಕಿ ದೊಡ್ಡ ಕಂಪಯ್ಯ ಇಟ್ಟಿದ್ದು ಅವ್ರ ಹೇಳಿ ಬರ್ಸಿದ್ರು.
What do you mean ಹೇಳಿ ಬರ್ಸಿದ್ರು?
ಅಲ್ಲಿ ಮೆಂಬರ್ಸ್
You can't make such statement before High Court, sir.
I was there.
No, what do you mean? You were there. You were ಅಂದ್ರೆ ಏನು? Who are you?
I was.
We have court has to trust your test. Sir, statement is there. Statement is there and his name is found in 1340.
Okay, I'll not dispute. Next, Dodda Kampaya.
No, I'm not hearing it finally. This matter requires consideration. You file statement of objection. This fresh matter, we'll list it in B group.
I've already filed statement.
It will come in B group, 2024. We are not deciding today. Barcodry, the counsel for petitioner and Leonard, AGA appearing for state and party in person. Review the records. Petitioner is agreed by the order. Order passed by the Assistant Commissioner.
Deputy Commissioner.
Additional deputy.
Annexure
Original order ಯಾರು ಮಾಡಿದ್ದಾರೆ?
N, annexure N.
Second time it is coming to the court.
Petitioner is agreed by the order. Order the second respondent Deputy Commissioner will decline to grant the land, petition land under section 77 capital A of Karnataka Land Reforms Act. This order is confirmed by the appellate tribunal. Matter requires deeper examination in the light of the statement made by original landlord on an application filed by petitioner's uncle before the land tribunal, where he admits the tenancy rights of petitioner's father to an extent of 1 acre 28 guntas. This court has also consciously taken cognizance of the RTC of the year 1374.
1 minute. This
Petitioners-
RTC is fabricated.
We'll see, petitioner's father name is found in the cultivators column as on 1/3/1974. Referring to these two significant details, the orders passed by the second respondent and the appellate tribunal needs consideration. Accordingly, these two orders, ಏನ್ stay ಕಳಿದೀರಾ?
Stake.
Since petitioner is able to substantiate that his ancestor prima facie possessed tenancy rights, this court deems it to grant some protection pending consideration of the caption petition. What stay reject ಆಗಿದೆ, ಏನ್ stay ಮಾಡ್ಬೇಕು?
Let the
ನಾವು
revenue
ಮಾಡಿದ್ರೆ
status quo may let be made.
parties are there, therefore parties are hereby directed to maintain status quo in regard to entries.
Please.
Leave this matter in B group. London DGA to secure original records.
One para is this.
ಅದು ನೋಡೋಣ B group, final hearing ಅಲ್ಲಿ ನೋಡೋಣ. Yes. Next.
Are seeking a writ of mandamus against the respondents. Lords, the land in question have been granted in favor of petitioners under
Provide notice to private respondency dispense.
ಇಲ್ಲ ಅದು ಡಿಸ್ಪೆನ್ಸ್ ಆಯ್ತು, ಅದು ಬೈ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದು, ಆಮೇಲೆ ಮೆಮೊ ಹಾಕಿ
Yes, madam.
Already been given to Panchayati. Authorized.
ಅಲ್ಲ, ದಟ್ ಈಸ್ ರಾಂಗ್. ನಂದು 1981 ನಲ್ಲಿ 1971 ನಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅಫಿಷಿಯಲ್
ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಆಯ್ತು ಸರ್,
ಅದು ಇಮಿಡಿಯೇಟ್ಲಿ ಅದನ್ನ ಕಟ್ ಮಾಡೋದು.
ಆಯ್ತು ಸರ್. Sorry.
ಇಲ್ಲಿ ಟ್ರೈನಿಂಗ್ ನಿಮ್ನ ಎಲ್ಲ ಯಾವ ಸೀನಿಯರ್ಗಳು ಟ್ರೈನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ.
I'm sorry.
You should hold back,
ಆಯ್ತು.
allow it to complete, then seek leave and you
ಆಯ್ತು.
counter it.
Sorry.
ಪ್ರತಿ ಕೇಸಲ್ಲಿ ಗಲಾಟೆನೆ. Yes, madam.
5% which has been given to Panchayat for Authorized. And they have their applications is a baked applications.
ಈಗ ನೀವು ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಪ್ಲೇಸ್ ಇಟ್ ಫೈಲ್ ಮಾಡಿ ಹಾಗಾದ್ರೆ.
They are also necessary parties.
ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದೆ, ಇಲ್ಲಿ ನೋಡಿದೆ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ, ಬರ್ಕೊಡ್ರಿ. London DG contains that private respondents are necessary parties. Petitioner cannot proceed with the case by seeking dispensation.
May I make a submission? My lords.
She also seeks a leave to file statement of objection. At her request, 2 weeks' time is granted. Yes,
May I make a message? My lords, this land contains 45 acres. They have given only 3 acres add to the Ashraya scheme. Originally 1979 ಅಲ್ಲಿ ಅಫಿಷಿಯಲ್ ಮೆಮೊರಾಂಡಮ್ ಮುಖಾಂತರ ಇವರಿಗೆ ಗ್ರಾಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. We have filed Darakast application. Based on Darakast application, the government has passed official memorandum. Based on official memorandum, they have collected amount from petitioners. Thereafter, they issued Saguvali cheat. Now they are saying that it is given to some other purpose. That is wrong, my lords.
ಕೊಟ್ಟಿದ್ದು 2 ಎಕರೆ 3 ಎಕರೆ.
16 ಎಕರೆ 20 ಗುಂಟೆ ಸ್ವಾಮಿ 5 ಜನಕ್ಕೆ ಒಂದೇ ಅಫಿಷಿಯಲ್ ಮೆಮೊರಾಂಡಮ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರತಕ್ಕಂಥದ್ದು. ಮೇ ಕೈಂಡ್ಲಿ ಜಸ್ಟ್
ಏನು ಮ್ಯಾಂಡಮಸ್ ಏನ್ ಕೇಳ್ತಾ ಇದೆ?
ನಮ್ಮ ಹೆಸರಿಗೆ ಪಾಣಿ ಮಾಡ್ಕೊಡಿ ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನು ಕೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ವಿ ಆರ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಟು ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು mutate my name in the revenue records based on grant records and official memorandum. ನಾವ್ ಇನ್ನೇನು ಕೇಳ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಅವರು 3 ಎಕರೆ ಯಾವ್ದಕ್ಕೂ ಕೊಟ್ಬಿಟ್ಟು ಇವಾಗ ಎಲ್ಲಾನು ಇದ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ದಟ್ ಈಸ್ ರಾಂಗ್, ಮೈ ಲಾರ್ಡ್. ಯಾಕೆಂದ್ರೆ ನಂದು ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಲಿ, ಅದರ್ವೈಸ್ ಹೋಲ್ಡ್ ಎನ್ ಎನ್ಕ್ವೈರಿ ರಿಗಾರ್ಡಿಂಗ್ ಮೈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ವಾ, ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬಿಟ್ಟೆ ಮಾಡ್ಲಿ ಬಿಡಿ ಸ್ವಾಮಿ.
ಈಗ ಯಾರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ? ವಾಟ್ ಇಸ್ ದ ಗ್ರಾಂಟ್?
My lord, may kindly peruse petition number 1 to 5 have been granted wide annexure A to E. Those are Sagwali cheat.
Date of grant?
Date of 1981, my lord.
81
81 ಗಿಂತ ಮೊದಲೇ official memorandum has been issued, dated annexure T and U may kindly peruse for a kind moment, my lords. Page number 123. 22nd June 1979 ನಲ್ಲಿ ಅಫಿಷಿಯಲ್ ಮೆಮೊರಾಂಡಮ್ ಆಗುತ್ತೆ.
ಗ್ರಾಂಟ್ ರೇಟ್ ಇದು ಬೇರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ, ಇದು ನೋಡಿದ್ರೆ ಮರ್ತು ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಅದ್ರಾಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಬರ್ದಿದ್ದಾರಾ?
ಬರ್ದಿದ್ದಾರೆ, ಅದ್ರಲ್ಲೇ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಸೊ ಹಾಗಾಗಿ ತಾವು ಜಸ್ಟ್ ಫಾರ್ ಎ ಕೈಂಡ್ ಮೂಮೆಂಟ್ 123 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲಿ ತಾವು ಪರಿಶೀಲನೆ ಮಾಡಿ ಸ್ವಾಮಿ. ಸೊ ಆಲ್ 5 ಪಿಟಿಷನರ್ ನೇಮ್ಸ್ ಹ್ಯಾವ್ ಬಿನ್ ರಿಫ್ಲೆಕ್ಟೆಡ್. ಪೇಜ್ ನಂಬರ್ 124 ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ತಾವು ಗಮನಿಸ್ತಾ ಸ್ವಾಮಿ. ವಿಜಯಪ್ಪ, ವೆಂಕಟಮ್ಮ, ಸಾವಿತ್ರಮ್ಮ, ಜಯಮ್ಮ ಅಂಡ್ ಯಶೋದಮ್ಮ. ಸೊ ಇವ್ರ 5 ಜನಕ್ಕೂ 16 ಎಕರೆ 20 ಗುಂಟೆ ಮಂಜೂರು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ದೇರ್ ಆಫ್ಟರ್ ದೇ ಹ್ಯಾವ್ ಕಲೆಕ್ಟೆಡ್ ಅಮೌಂಟ್ ವೈಡ್ ಅನೆಕ್ಷರ್
ಯು.
ಸೊ ಅಮೌಂಟ್ ಅನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಸ್ವಾಮಿ. ಆನ್ ಕಲೆಕ್ಷನ್ ಆಫ್ ಅಮೌಂಟ್, ದ ರಿಕ್ವಿಸಿಟ್ ಅಮೌಂಟ್, ದೇ ಇಶ್ಯೂಡ್ ಅನೆಕ್ಷರ್ A to E ಇನ್ ಫೇವರ್ ಆಫ್ ದೋಸ್ ಗ್ರಾಂಟೀಸ್. ಅಂಡ್ ಇದರಲ್ಲಿ ಸರ್ವೆ ಸ್ಕೆಚ್ ಸಹ ಸಮೇತ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅನೆಕ್ಷರ್ ಎಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಪೆರೋಸ್ ಸರ್ವೆ ಸ್ಕೆಚ್ ಮಾಡಿದ್ದಾರೆ, ನಮ್ಮ ಎಲ್ಲೆಲ್ಲಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ. ಅನೆಕ್ಷರ್ ಎಸ್ 122 ಅದರಲ್ಲಿ ನೇಮ್ಸ್ ಆಲ್ಸೋ ರಿಫ್ಲೆಕ್ಟೆಡ್. ಇದರಲ್ಲಿ ಯಾವ್ಯಾವ ಬ್ಲಾಕ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಮೂದ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಇದೆಲ್ಲ ಮಾಡಿ ಇದು ಈಗ ಇವ್ರೇನೋ ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ವಿತೌಟ್ ಕ್ಯಾನ್ಸಲಿಂಗ್ ಮೈ ಗ್ರಾಂಟ್, ಇವ್ರು ಈ ತರ ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಈ ತರ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ ನಮ್ಗೆ ಕೊಟ್ಟಿರೋ ಅಂತ ಇದೇನಾಗ್ಬೇಕು ಸ್ವಾಮಿ? ಅವ್ರು ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ. ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಗ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ, ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್.
But that Sagulu cheat was not acted upon. Your name was never mutated to the
ಈ
artist.
ಬಂದೇ ಇಲ್ಲ ಸ್ವಾಮಿ,
Entry ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. ದಿಸ್ ಇಸ್ ಒರಿಜಿನಲ್, ವಿ ಹ್ಯಾವ್ ಒರಿಜಿನಲ್ ಸಾಗುವಳಿ ಚಿಟ್ಸ್ ಆಲ್ಸೋ.
Don't place it, you.
Keep it.
Annexure 125. He claims that his application is of the years 1918. 1918 ಅಲ್ಲಿ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಆಫ್ ಅನಾಥರೈಸ್ಡ್ ಕಲ್ಟಿವೇಶನ್ ಕಾನ್ಸೆಪ್ಟ್ ಇತ್ತು. ಆ ಕಾನ್ಸೆಪ್ಟ್ ಬಂದಿದೆ 91 ಇಂದ. These are all fake, official memorandum ಅನ್ನೋದು before 90 ಏನು ಇರ್ಲಿಲ್ಲ. These are all created documents.
ಅಲ್ಲ ಬಟ್ ನೀವು ಎಂಕ್ವೈರಿನೂ ಮಾಡ್ತಾ ಇಲ್ಲ.
Inquiry is pending. That's why last occasion I have filed AC ಮುಂದೆ cancellation pending ಇದೆ. Their applications are not at all before the authority. And regularization of unauthorized cultivation of concept ಬಂದಿದೆ 90 onwards. Good application 80 ಅಂತಾರೆ. ಅಲ್ಲಿ official memorandum ಯಾವ್ದು ಇರ್ತಾ ಇರಲಿಲ್ಲ. ಅವ್ರದ್ದೆಲ್ಲ ದರಖಾಸ್ತು ಗ್ರಾಂಟ್ ಆಗಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇಶ್ಯೂ ಸಾಗುವಳಿ ಚೀಟಿ ಇಶ್ಯೂ ಆಗ್ತಾ ಇದೆ. These are all created documents. That's why I need to file my statement of objection. And moreover, the AC is still before AC, it is pending.
Inquiry is pending.
For cancellation of grants. Their applications are not at all before the authority. Registrar ಇಲ್ಲ application.
ಈಗ ತಮ್ಮ ಮುಂದೆ ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಇಟ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಅಂತ AC ಅವ್ರ ಮುಂದೆ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಮಂಜೂರ್ ಆಗಿದೆ ಅಂತ. ನೋ ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್
ಎಷ್ಟು ನೋಡೋಣ ಇರ್ಲಿ. You at least place on record that there is an inquiry. We'll say that subject to inquiry. Secure instruction.
a date may be.
Date, ಕೊಡ್ರಿ. Very. ಕೊಡ್ರಿ, first week ಅಲ್ಲಿ ಕೊಡ್ರಿ. Next. Next,
Much.
9.
My lords, in this matter, I appear for the petitioner, my lords. My lords, on the last occasion, my lords had directed me to serve upon K. Krishna, panel advocate for respond number 5 BMTC, my lords. My lords, we've served upon him. He's not part of the panel.
ಯಾರು?
My lords, I've
ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ? ಸರ್ವ್ ಮಾಡಿದಾರೆ ಈಗ. ಕೊಡ್ರಿ.
my lords, may I seek one small indulgence, my lords?
Yes,
My
yes,
lords,
madam.
ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದು writ petition is filed by BMTC, my lords. ಅದ್ರಲ್ಲಿ for BMTC, Mr. BL Sanjeev sir has appeared, my lords. Same, the question is involved. Therefore, may I request notice may be out.
No, Surana is accepting notice. Why you want? Let there be two lawyers. They are not connected on identical cases. It
Please.
doesn't mean that they should go to the same standing council.
Please, my
Surana,
lords.
you are instructed. So and so is instructed to appear on behalf of respondents 5 to 7. Registry to delete the name of K. Krishna and show the name of Surana. A copy of writ petition is served in the open court on Sri Surana advocate. At his request, relate this matter in preliminary.
My lords, a date may be fixed, my lords. There's
Yes.
some urgency.
Yes,
17th or 18th, any day convenient to my lords.
24. Yes, next.
Grateful, my lords.
For the petition discuss, my lord.
Yes, sir.
In this case, the petitioners are seeking writ of Mandamus to the respond number 1, my lord. To comply the
Huh?
order as per Annexure F, my lord.
Directions of
Is the order
Mysore
passed by
Revenue
the-
Tribunal. ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು ಮಾಡಲ್ಲ. ಕಾಲ ಒಂದ್ ಬರುತ್ತೆ ಎಲ್ಲ 100 years 150 years ಇದೆಲ್ಲ ಬರುತ್ತೆ ಈಗ the way you are going. But there is an order, madam. ಇದೆಯಾ? Ask them to look into that order.
That's all, my lord.
And what is that order, sir?
Order,
Page.
Annexure 61 page number, running page 61, my lord.
Page?
61, my lord. The type copy at 66. The relevant page, the para at para number 2, my lord. Of the impugned order.
ಏನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ? ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್?
Land reforms. Idರಲ್ಲಿ land revenue, my lord. The land was granted to an extent of 15 acres, 14 guntas was granted in favor of 5 different persons, my lord. The petitioners herein are the legal heirs of the original grantees. Thereafter, some of the villages objected for the grant. That was challenged before the Mysore Land Appellate Tribunal, my lord. The direction was
ರಿಮಾಂಡ್ ಆರ್ಡರ್.
remand ಆಗಿದೆ.
Why you kept quiet for house?
Because, my lord, these petitioners are the legal heirs of the original grantees. ಅವರೆಲ್ಲ ಅವಿದ್ಯಾವಂತರು coming from very downtrodden
We
families.
seek instruction, madam. We will not issue a directions. We don't know. For ಕೊಡ್ರಿ. Learned DGA, petitioners, ಒಬ್ರನಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, 1 to 5 ಇದ್ದಾರೆ.
Petitioners are seeking direction at the hands of this court to hold a fresh inquiry in the light of directions issued by the then Mysore Revenue Appellate Tribunal, Bengaluru, This remand order is dated 28/7/1966. Petitioners have now knocked the doors of the court seeking direction at the hands of this court. This court is of the opinion that Learned AGA has to secure instruction as to whether post remand any orders are passed. To enable her to secure instructions, release this matter. Yes.
Much of it.
Next.
Sir, not where your lordships are directed to
Ramesh.
restore Raj Kalve. Technical report, technical persons were present. Even today, my lords, they are not.
ಮತ್ತೆ ನಮ್ಮಂದೆ ಬಂತಿದ
ಈಗ ನಿಮ್ಮ ಮುಂದೆನೆ ಬಂತು ಇವಾಗ. My lords, even till today, my lords, they have not done. My lords, because on 3/12/2024, there was a heavy rain. My lords, I have filed an impleading application. Along with that, my lords, I have filed the photographs. Kindly refer to those photographs, my lords. My lords, the nature of. My lords, Tahsildar specifically says that the matter is seized before this court, you seek for a direction. My lords,
ಅವ್ರು ನೋಡಿ ಅದು ಎಲ್ಲ ಕೋರ್ಟ್ ಮೇಲೆ ಹಾಕ್ಬಿಡೋದು.
Petitioner has been already directed to make Hennagara Gram Panchayat.
I have made an application, my lords.
They are allowed to construct a temple on the blocking the Rajakala. That is not they are doing, not doing. We are.
ಆ
ready to
ಟೆಂಪಲ್
do
ಶಿಫ್ಟ್
it.
ಮಾಡ್ಲೇಬೇಕು, ರಾಜ್ ಕಾಲುವೆ ಇದ್ರೆ ಮಾಡ್ಲೇಬೇಕು.
ಅಲ್ಲ, ಇದನ್ನ my lords kindly refer to the photographs along with the impleading application.
ಮಳೆಗಾಲ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಮೇಡಮ್ ಸಿ.
ಹೌದು.
Let them make Hennagara Gram Panchayat.
Lords, I have filed an application.
ಈಗ ಹಾಕಿದಾರಂತೆ, ಟೇಕ್ ನೋಟಿಸ್.
ಹಾಕಿದ್ದೀನಿ, ಅದನ್ನೇ my lords. I'll take out handsome as my lords. Kindly fix a date next week, my lords. I'll see that.
Take notice, issue notice on impleading application. Impleading application filed in I number.
My lords,
I
1
number
of 2025, my lords.
2025. Yes.
My lords, handsome as may be ordered, my lord.
ಇಲ್ಲ ಅಥಾರಿಟಿ ಇದಾರೆ, ಎಮರ್ಜೆನ್ಸಿ
ಅಲ್ಲ,
ನೋಟಿಸ್.
ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ನಾನು.
Simultaneously, petitioner is also reserved with liberty to take steps to serve impleading applicant by way of hand summons returnable by 10 days ಆದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ. Yes, next.
It may be taken up in preliminary hearing itself, my lord.
ಆಯ್ತು ಪ್ರಿಮೇರ್.
Much of.
But the Mangalore University is the petitioner.
Who appears for petitioner, sir? Yes, Kiran. ಅಲ್ಲ ಬರ್ಲಲ್ಲ, ವೇರ್ ಇಸ್ ಕರ್ನಾಕರ್? ಹಾ, ನಿಮ್ದೇ ರೀ. Yes, sir. What is this vacating application?
And the grantee, Lord, I'm respondent number 5.
My lords, survey number 149 measures 44 acres, non.
On vacating, Ravi Shankar.
Vacating ಆಯ್ತು ಮಾಡ್ಲಿ. Not beef. It's as good as the matter getting disposed of, my lords. If your lords.
ಅಲ್ಲ, is it a short matter or it requires consideration?
My lords, it's a very, very short matter, my lords.
Let him argue on vacating.
May I make one
Very well.
suggestion? Lord? There are certain records which I would like to place on. I'll file my statement of objections. A week's time may be granted. It's with
Now
regard to
you're
the,
supporting both or you're not supporting both.
no, my lord, I'm
They are
taking
supporting
instruction, my
petitioner.
lord. I'm taking
They are supporting
instructions.
No,
I-
petition
I
is a
will place-
university.
I'll place documents, my lord,
Mr.
which may be necessary to
I'll fix a
adjudicate.
date. I'll fix a date.
Yes. All
I'll
that
ensure your rights are also protected.
Lord, all that I'm saying, Lord, is what is the scope of this writ petition may kindly be seen around the.
ಅದು ನೋಡೋಣ ಅವ್ರು.
Aye.
The thing is,
Don't know why additional advocate general wants time.
grant is made to Mangalore University some years ago, some 50 odd acres. 2 acres is granted to me. Now, not, they took, the assistant commissioner wants to cancel it. He took steps to cancel it. I challenged with writ petition, that order is stayed. Okay. Now, my lord, they don't want, so Mangalore University, at the instance of some political people, have stated so in the petition. He issues, my lord, they filed this writ petition suppressing those facts. And my lord, there's an interim order granted of status quo. That what is the extent, not if grant is made in favor of two entities, that cannot be decided in writ jurisdiction. Whoever is agreed will have to go to civil court. That's only.
Lords, if I really am, I'm really startled with the submission made, my lords. If the government has already parted with the entire extent of property, government did not have even a square inch of property in the concerned survey number. If somebody wants to come and claim that the government has granted one more extent of property, which is
Not
not.
your grant is in earlier.
Lords, my grant is earlier at point of time. No, I will, my lords, overlapping, my lords, I am really, not survey number 149 in 1970 was
Government
bifurcated.
wants to place on record.
Very well. Lords, it's bifurcated into 149 bar 1, 2 and 3. Now grant is made in his favor in 149. Where is 149? It's already ported in 1970 as 1, 2, and 3.
Order. Release that.
I'll place a few records
Please,
which may
please,
help
please.
to adjudicate.
Yes, at the request of Leonard Additional Advocate General, matter is urgent and order to be released on so and so date. Was date what?
Interim order.
Interim order granted earlier is extended till next date.
Lordships.
Next. 13.
Petitioners, my lord. My lord, may I request for weeks time for this reason, my lord.
Weeks
The
time.
petitioner's request has already been rejected, my lord. I have to secure that records and order, my lord. Weeks time.
And in this case, what has happened, my lord, as many as 15 persons were there by filing application.
Let him place.
All the 10 persons have been granted long back.
The order ನಿಮ್ against ಆಗಿದೆ ಅಂತ produce ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ I'll grant you, I'll pass orders.
That's not only writ of Mandamus to consumer apprentice.
ಅಲ್ಲ, ಈಗ order ಮಾಡ್ಬಿಟ್ಟಿದಾರಂತೆ. Let him produce it. List it on so and so date. Next.
18 to 82 itself is.
Yes, 14. Yes, Mr. Gautam.
My lords, the writ of certiorari. Lords, the petitioners. The petitioners have challenged the order passed by the deputy commissioner. The petitioner have challenged the order of the deputy commissioner, that is the second respondent, with respect to the revenue entries, which is in favor of the respondent number 5, my lords. My lords, the property bearing survey number 22 measuring 2 acres 14 guntas. It was a granted land in favor of the grandfather of the petition.
What's the extent? 2 acre 14 guntas.
2 acre 14 guntas, 14 guntas is a Karab.
14 and grant.
Grant. In the year 1948, my lords. After that, he was in peaceful possession and he died in the year 1991. What?
Whether respondent for number 5 is related to you?
Yes.
How you are related?
Respondent number 5, she is the husband of one Mr. Narsimha.
Can't be a husband. She has to be wife.
Oh, sir. She is the wife of one Narsimha, who is the brother son of my grandfather.
Your brother's son, very complicated. That family tree is not there.
Yeah, I've produced the family tree, my lords, at page.
All right, now she has set up a will.
Yeah, she has set up a will claiming,
yeah.
claiming that it has done in the year 1994, wherein the said Salappa was died in the year 1991, my lords.
He died. Barkodri.
Yes.
Had the counsel for petitioner. For you the records, respondent number 5 is asserting title based on a will. Based on a will. Alleged to have been executed by a testator on 5/8.
5/8/1994.
5/8/1994. Petitioners are seriously disputing this petition, this disputed will on the ground that
The said Salappa
said Sallappa died in
on 4/8/1991.
4/8/1991. This court has consistently held that legatee based on a will cannot get cannot seek change of khata. The full bench in the case of so and so Singh has squarely addressed this issue. Now, who has ordered to mutate the name of R5?
The respondent number 2, deputy commissioner.
Assistant commissioner refused.
Assistant commissioner ಅನ್ಪರವಾಗಿ order ಮಾಡಿದ್ದಾರೆ. She has challenged before the deputy commissioner.
Before the deputy commissioner's order, wide annexure.
Wide annexure A.
Annexure A requires consideration in the hands of this court. Accordingly, state till next date of hearing. Leonard is directed to accept notice to 1 to 4. Issue a major notice to R5.
Please.
Where is that full bench judgment? Where is that full bench judgment? You have to get it in half an hour, otherwise I will vacate interim order. It is your job. Go inquire and come back. Do a little bit of research. Yes.
15, maybe Shivkumar.
15.
In this case, my
15.
lord,
I appeal for petitioners, my lord.
searching
Kindly
for
pass forward, my
records,
lord.
my lord.
Huh?
We are searching for the earlier record. Somehow it is not finding. in the
Urgency there, ma?
Can you, yes, my lords, kindly pass over, my lords.
There is urgency, madam.
Yes, my lords.
She wants time. All right, pass on, madam. Get your seat.
Yes, ma'am.
ಬರ್ಲಿ ಮೇಡಮ್, ಬಂದ್ಬರ್ಲಿ. Next,
16, Srinivas DC.
Srinivas.
This matter, my lord, will not endorsement. 209 annexure, my lord. Record ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು, but now we will treat this petition as a representation along with annexure. Not we will give some reasonable time may be granted, my lord, we will consider.
ಹೌದಾ, ಏನ್ ಪ್ರೇಯರ್ ಇದೆ ಮಂಜುನಾಥ್?
ದುರಸ್ತಿ ಕೊಡಿ.
Code and duress,
Based on what?
based on the land tribunal order.
Land tribunal.
1981 ಆರ್ಡರ್ ಆಗಿದೆ, ಆಕ್ಯುಪೆನ್ಸಿ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಆಗಿದೆ 1981 ಅಲ್ಲೇ.
Records.
ರೆಕಾರ್ಡ್ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ದುರಸ್ತಿ ಮಾಡೋದಿಲ್ಲ ನಾವು ಅಂತ ಆರ್ಡರ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ರೆಕಾರ್ಡ್ಸ್ ಈಗ ಸಿಕ್ಕಿದ್ಯಾ?
ಅಲ್ಲ, ಇದನ್ನೇ ಟ್ರೀಟ್ ಮಾಡ್ತೀವಿ, ಇದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲ, ಅದು ಅಲ್ಲಿ ಸಿಕ್ಕಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಇದನ್ನೇ ಟ್ರೀಟ್ ಮಾಡ್ತೀವಿ represent.
ಈ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಸಿಗ್ಬೇಕಲ್ಲ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ.
90
ಇದೆಯಾ ಸರ್ಟಿಫಿಕೇಟ್?
my lords, yes, annexure K, my lords, 149 page number.
ಯಾಕೆ ಇಷ್ಟೆಲ್ಲ RTC ಹಾಕಿದ್ದೀರಾ? ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
My lords, ಅದು 1946 ಇಂದ ಗಿಫ್ಟ್ ಡೀಡ್ ಆಗಿರೋದ್ರಿಂದ ಅವಾಗಿಂದ ಇದೆ my lords. RTCs ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ.
ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದೇನು problem ಅಂತ sale deeds guarantee ಇಂದ.
Registered sale deeds.
Survey number entry, sale deeds ಅಲ್ಲಿ. ಅದೊಂದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರನೇ ಈಗ ಇದನ್ನೇ ಯೂಸ್ ಮಾಡಿರೋ sale deeds ಅಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲೂ
Based on
ಯು ಪರ್ಚೇಸ್ ಫ್ರಮ್ ದಿ ಗ್ರಾಂಟಿ.
subsequent grantees ಒಂದ್ 2 ಸೇಲ್ ಆದ್ಮೇಲೆ ನಾವು ಪರ್ಚೇಸ್ 2006 ಅಲ್ಲಿ ಪರ್ಚೇಸ್ ಆಗಿರೋದು.
ಇನ್ನೊಂದು ಪ್ರಿಂಟ್ ಕೊಡಿ ನೋಡೋಣ.
ವೇರ್ ಇಸ್ ದಟ್ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್?
Annexure K, my lords,
ಪೇಜ್
149.
ಫಾರ್ಮ್ ನಂಬರ್ 10 ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
My lords,
Try to trace out all records.
yes.
You have to do it.
Yes.
ಅವರು ಭಾಳ ಆದ್ರೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. This is the land tribunal order.
Yes, my lords.
ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ 15 ಪೇಜ್ ಅಲ್ಲಿ ಆದೇಶ.
ಇಲ್ಲಿ ಒಂದೇ ಪೇಜ್ ಇದೆಯಲ್ಲ, ಪೇಜ್ 149.
Second page ಇದೆ ಮುಂದೆ ಇದೆ.
Second page ಅಲ್ಲಿ
Operative portion.
ಹೇಳ್ರಿ, ಸೆಕೆಂಡ್ ಪೇಜ್ ಇಲ್ವೇ ಇಲ್ಲ. ಒರಿಜಿನಲ್ ಯು ಪ್ರೊಡ್ಯೂಸ್ ಓನ್ಲಿ ಒನ್ ಪೇಜ್ ಅಟ್ ಪೇಜ್ 149.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ.
How did you look? You are the third purchaser or fourth purchaser?
Fourth purchaser, my lords.
Both.
Some reasonable time may be granted.
So can you take 5 months time?
Yes. Time fix ಆಗ್ಬಿಡ್ಲಿ, ಅವ್ರು 5 months ತಗೊಂಡ್ಲಿ 6 months ತಗೊಂಡ್ಲಿ, but time frame fix ಆಗ್ಲಿ, my lords.
Secure all the records.
Because since 2022 we have given representations after representations, almost 4 representations ಕೊಟ್ಟಿವಿ, my lords. ಇವಾಗ 4th one ಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನಂತ?
ಅದೇ ನನ್ನ ಹತ್ರ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ, ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ. ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ಆರ್ಡರ್ ಇದ್ದು ನನ್ನ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Land tribunal order is there. It's there available in the original.
ಅವ್ರು ಅದನ್ನು ಇಲ್ಲ ಅಂತ ಅದನ್ನೇ ಕೊಟ್ಟಿರೋದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್. ನೋ ರೆಕಾರ್ಡ್ಸ್ ಅವೈಲಬಲ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಇದು?
ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್, my lords.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಜೊತೆ ವಾಟರ್ ಕಾಪಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ರೆ ಸರ್ಚ್ ಮಾಡ್ಬಿಟ್ಟಿರ್ತೀವಿ.
My lords, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಿದೀವಿ.
ಓ, ಇದೆಲ್ಲ ಈಗ ನಿಮ್ಗೆ ಡೀಟೇಲ್ಸ್ ಇದೆಯಲ್ಲ?
ಈಗ ಇದನ್ನೇ ಟ್ರೀಟ್ ಮಾಡ್ತೀವಿ.
ಕರೆಕ್ಟ್, ಬರ್ಕೊಡ್ರಿ. Petitioner is aggrieved by the endorsement issued by 4th respondent Tahsildar. Wide annexure, yes. Petitioner, who is a subsequent purchaser of an agriculture land, moved an application seeking podium durasti in respect of petition land bearing serial number
239
bar P1 na
P1,
measuring
239
16
P3, 239
ಎರಡು
P4.
ಇದೆಯಾ?
My lords,
239 bar P1
P3,
measuring 18
P4.
guntas. 239 bar P3 measuring 16 guntas. Both situated at Chandagalu village.
P39 P4, my lords, 239 P4, 2 acre 17.8 ಗುಂಟ.
ಗ್ರಾಂಟ್ ಆಗಿರೋದೇ 1 acre as per the order.
My lords, ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸಪರೇಟ್ ಆ ಜಾಗದಲ್ಲೇ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪ್ರಾಪರ್ಟೀಸು ಇದಾವೆ, ಎಲ್ಲ ಸೇರಿ ಇದು ದುರಸ್ತಿ ಆಗ್ಬೇಕು. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸಸ್, ಸಪರೇಟ್ ಪರ್ಚೇಸಸ್ ಇವೆಲ್ಲ.
239 bar P1 and P3 ಅಂತ ಇದೆ.
Okay, my lords.
And P4
Yes.
and 239 bar P4 measuring 2 acres. 2 acres 17.8 guntas.
Yes, my lords.
Petitioner asserts that these lands were subject matter of land tribunal proceedings.
Yes.
Petitioner asserts that these lands were granted in favor of one Venkoji Rao.
Venkojirao. All subsequent grant ಆಗಿರೋದು ವೆಂಕೋಜಿರಾವ್.
ಅಲ್ಲ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲ ಇದು 1933 ಗ್ರಾಂಟ್ ಅಂತೀರಾ?
ಗ್ರಾಂಟ್ ಅದು ವೆಂಕೋಜಿರಾವ್ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಮೈ ಲಾರ್ಡ್ಸ್. ಅವರು ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿ ಅವರು ಡಾಟರ್ ಇನ್ ಲಾ ಕೊಡ್ತಾರೆ. ಅವ್ರು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಸೇಲ್ ಮಾಡಿ ಫೈನಲ್ ಆಗಿ ಪಿಲ್ಲಯ್ಯ ಅವ್ರಿಗೆ ಬರುತ್ತೆ. ಅದಾದ್ಮೇಲೆ ಜಯಮಾನ್ ಅವ್ರಿಗೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ.
Original grantee Venkoji Rao
ಎಸ್.
gifted this property in favor of his daughter-in-law, Srimati Chandrabai, on 2/9/1946. The Dhoni in turn sold 1 acre, sold above the petition lands in favor of one Pillaya, son of Dase Gowda. Under registered sale deed dated 3/12/1968.
ಎಸ್.
He said the Pillaya in turn sold it to
ಬೆಟ್ಟೇಗೌಡ.
Bette Gowda on 4/12/1968. They said Bette Gowda sold the properties in favor of one Srimati Jayamma on 27/11/1972. ಯಾರಿಗೆ ಗ್ರಾಂಟ್ ಆಯ್ತು ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ?
ಮೈ ಲಾರ್ಡ್ಸ್ ಇದು ಪಿಲ್ಲಯ್ಯ ಇದು ಜಯಮ್ಮ ಅವ್ರ ಮಗನ್ಗೆ ಮೈ ಲಾರ್ಡ್ಸ್ ಬಿ ರಾಮಚಂದ್ರ. ಅವ್ರ ಡೆತ್ ಆದ್ಮೇಲೆ ಅವ್ರ ವೈಫ್ ಲೀಗಲ್ ಹೇರ್ ಆಗುತ್ತೆ. ಲೀಗಲ್ ಹೇರ್ಸ್ ಇರ್ತಾರೆ, ಅವರು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಂಡು ಹೋದಾಗ 1981 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ ಆಕ್ಯುಪೆನ್ಸಿ ಸರ್ಟಿಫಿಕೇಟ್.
ಯಾರು ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ?
ಮೈ ಲಾರ್ಡ್ಸ್ ದ ವೈಫ್
Jayamma was the owner
ಎಸ್
as of 1972.
ಎಸ್ ಎಸ್.
ಹಾ. ಅಲ್ಲಿ ಯಾರು ಅಪ್ಲೈ ಮಾಡಿದ್ರು?
ಮೈ ಲಾರ್ಡ್ಸ್ ದಟ್ ಇಸ್ ಅಪ್ಲೈಡ್ ಬೈ
Land tribunal granted in favor of Pillaya, son of Dase Gowda.
ಎಸ್.
He applied for farm.
ಎಸ್.
Next petitioner asserts that one Pillaya, son of Dase Gowda, was the owner and had sold it to Bette Gowda, filed form number 7 before Land Tribunal, Mandera, Srirangpatna.
ಶ್ರೀರಂಗಪಟ್ಟಣ.
The Land Tribunal Srirangpatna, while order dated 6/10/1981, granted occupancy rights to said Pillaya, and the petitioner claims to have purchased this land under registered sale deed dated 22/6/2006. Next, fourth respondent Tahsildar has issued the endorsement, which is now impugned on the ground that petitioner has not produced any documents. ಇಲ್ಲೆಲ್ಲ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಆಕ್ಚುಲಿ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ವಿ ಮೈ ಲಾರ್ಡ್ಸ್. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಾಗ ಅದ್ರ ಜೊತೆಗೆ
However, before this court, petitioner has placed on record all title documents which are reflected in the synopsis. Petitioner has also placed on record the land tribunal order, which is evidenced at annexure
ಅನೆಕ್ಸರ್ ಕೆ.
K. Next, letter SCJP submits that since petitioner's application was not supported by these title documents, this endorsement is issued. However, this contention is countered by the counsel appearing for petitioner, indicating that application, along with application, all requisite title documents were furnished. Next, be that as it may, since petitioner in the caption petition has produced title documents, which also includes the order passed by the Land Tribunal Srirangapatna conferring occupancy rights to petitioner's vendor Pillai, who in turn has sold it to petitioner under registered sale deed
2006.
dated 22/6/2006. This court is of the view that fourth respondent Tahsildar shall treat this writ petition as an application seeking a Fodian Durasti. You online treat it alla. Learned SCP also fairly submit that this petition will be treated as an application. The fourth respondent Tahsildar will secure all relevant records and after verifying, will pass appropriate orders. Appropriate steps will be taken to execute Fodian Durasti. Recording the assurance made by learned SCP, this court proceeds to pass following order. Fourth respondent Tahsildar, learned SCP shall forthwith send a copy of the writ petition along with all annexes to the fourth respondent Tahsildar. Next, fourth respondent Tahsildar on receipt of the writ papers shall secure all relevant records from the concerned authorities and after due verification shall proceed to accomplish the prayer sought in the writ petition. Next, if the, after securing the records, fourth respondent in consultation, in coordination with sixth respondent / assistant director of land records, if the documents, if the title documents are found to be genuine, if the title documents and the land tribunal order are found to be genuine, shall accomplish the body work and demarcate the property purchased by petitioner in accordance with law.
Time frame,
This
6 months.
exercise shall be accomplished within a period of 6 months from the date of papers, writ papers from the area office.
Much obliged.
Appear for petitioner.
Yes, sir, 17.
Appear for petitioner.
Yes, sir.
File the writ petition. The respondent number 2 ಗೆ await ಇದೆ.
Await it, yeah.
It's await.
All right, await.
Interim order may be extended.
Interim order granted early is extended. List it in B group. Next.
18.
Yes, 18. Yes, sir.
Lord, the petitioner in the incident case have called in question the notice at annexure J, wherein he has been called upon to evict from survey number 211 in 102 5 acres, my lord. My lord, page number 37, my lord.
Page 37.
Page 37, my lord. Annexure J.
ಎಲ್ಲಿ ಯಾವ ರಿಟ್ಟಲ್ಲಿ?
Serial number
18.
18, serial number
18.
18.
Sorry,
Saraswati,
my lord, I'm sorry, I'm in list 2. I'm in list 2.
Yes, madam.
My lord, I have filed the writ for Mandamus, my lord, seeking.
My lord, the petitioner has sought to demarcate a property and to issuance of check by the DDLR, my lord. There are several survey numbers, my lord, that are more than 18 survey numbers are there, my lord. Some reasonable time may be granted, my lord, 4 months. For body and the rest, my lord.
And issuance of check, sketch, my lord.
ಮೂರು ಕೇಸ್ ಅಲ್ಲ?
ಹೌದು.
Same prayer, my lord.
Same prayer, same village.
You're seeking body based on what, madam? Grant order?
No, my lord, sale deed,
Failed it,
please. ma'am.
Yeah, in all the 3 writ petitions based on sale deed,
Sale deeds, based
What-
on the
what?
sale deeds.
What's the theory for the-
Only one writ, there are so many survey numbers, my lord. In other, only 2 acres, one survey number, my lord.
18.2, my lord, there are about 12
Uh,
survey numbers.
12 survey numbers.
Sorry, number 2. Petitioner alleging inaction. Inaction on the part of respondents 4 and 5 is compelled to knock the doors of the writ court. Petitioner assessed to be absolute owner of the petition land bearing survey number 24/57 measuring
2 acres.
2 acres.
2 acres situated at AK Kavala, Gullur Hobli, Tumkur district. Petitioner is tracing title through registered sale deed dated 22/12/2006. Petitioner's name, though petitioner's name is reflected in RTC, petitioner is aggrieved by non-consideration of his representation dated 28/2/2020. Petitioner through the said representation has requested the authorities to conduct 4D and Durasti. Next, Leonard SCGP on instruction submits that petitioner's request will be considered and 4D will be conducted and sketch will be issued provided some reasonable time is granted. Petitioner who has acquired title based on a registered sale deed has a legal right to seek 4D of the petition land. The respondents 4 and 5 are equally obligated to consider petitioner's representation and conduct 4D and Durasti and assign a new survey number by demarcating petitioner's property. Therefore, this is fit case where Mandamus lies. This court accordingly proceeds to pass following order. Writ petition is allowed. Respondents 4 and 5 are hereby directed to accomplish Fodian Durasti within a period of 4 months from the date of receipt of order.
3 months.
Uh,
6 months.
My lord, from 2017, they are struggling, my lord, from
4
two-
months, 4 months.
18.2 writ petition, my lord, 12 survey numbers ಇದೆ. ಸ್ವಲ್ಪ ಕಷ್ಟ.
ಮಾಡಿ ದಯವಿಟ್ಟು ಮಾಡಿ.
ಅದು
ಮಾಡಿ.
will do,
4
my lord.
months, 4 months. ಇದು private land, ಪಟ್ಟಾ land sealed ಇದೆ.
Sir, it was a government and.
Say number 9.
ಹೌದಾ?
Say number 19, Sharp Kumar case.
We have more matter to say dates.
ಆ dates ಅದು sealed ಇದೆ ಎಲ್ಲ ಬೇರೆ.
Dates, sir.
Yes, Shan Kumar.
ಈಸಿ ಆಗ್ತದೆ.
ಹಾ?
ಈಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು. 89 ಇಂದ 99 no, there is no transaction ಅಂತೆ.
Seven and 88 ಅಲ್ಲಿ ಭೂದಾನಕ್ಕೆ 1 ಎಕರೆ ಅಂತ ಆರ್ಟಿಫಿಲ್ ಬರ್ತಾರೆ.
ಹಾ.
ಇವರು they have secured EC for the year 89 on.
1 ಎಕರೆ ನಂದು 3 ಎಕರೆನಲ್ಲಿ 1 ಎಕರೆ ತಾರಾನಾಥ್ ಒಂದು ಇದೆ. ನಾಗರತ್ನ ವೈಫ್ ಆಫ್ ತಾರಾನಾಥ್. ಆರ್ಟಿಸಿನಲ್ಲೇ ಇದೆ, ಅವ್ರ ಆರ್ಟಿಸಿನಲ್ಲೇ ಇದೆ. MR4 of 89, 88, 89. ಅದು ಬೇರೆ ಇದಿರೋದು, ನಂದು ಆಗಿಲ್ಲ. ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ ಅದು.
ಸರ್ವೆ ನಂಬರ್ ಸೇಮ್ 154 ಬಂದು. ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಪೊಸಿಷನ್ ಮೇಲೆ ನಾಗರತ್ನ ವೈಫ್ ಆಫ್ ತಾರಾನಾಥ್ 1 ಎಕರೆ 8 ಗುಂಟೆ ಫಾರ್ MR number 4 of 88, 89.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರದು?
ಅದು 1 ಎಕರೆ ಬೇರೆ ಭೂದಾನ ಮಾಡಿರ್ಬೋದು. ನಂದಿನ RTC-ನಲ್ಲಿ ಇದೆ. ಅವ್ರ RTC is established that. ಟೋಟಲ್ 3 ಎಕರೆ 8 ಗುಂಟದಲ್ಲಿ ಅವೇ ಪರ್ಚೇಸ್ 1 ಎಕರೆ 8 ಗುಂಟಾಸ್.
ಹಾ.
ಅದು 1 ಎಕರೆ ಭೂದಾನ ಅಂತ ಹೋಗಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ನಾನು ಈ ಪೊಸಿಷನ್ 2000 ಅವ್ರನ್ನೂ ಹ್ಯಾಂಡ್ RTC ಇನ್ ಮೈ ನೇಮ್. ಮೈ ಅನ್ನೆಕ್ಷರ್ ಬಿ ಮೇಲಾಡ್.
MB ರೇಣುಕಾಂತ್ ಇದೆ ಮೇಲೆ ಆಧಾರ.
ರೇಣುಕಾಂತ್ ನಮ್ಮ ವೆಂಡರ್.
ಹಾ. ಆಮೇಲೆ ಕೆಳಗಡೆ ಯಾರ ಹೆಸರು?
ಬೋರೇರೋಡ.
1 ಎಕರೆ 8 ಗುಂಟಾಸ್.
ಬೋರೇರೋಡ. ರೇಣು ನನಗೆ ಸೇಲ್ ಮಾಡಿರೋದು.
ಹಾ.
ರೇಣು ಅದು ನನಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ 1 ಎಕರೆ 8 ಗುಂಟಾಸ್.
ನಿಮಗೆ ಮಾಡಿದ್ದಾರೆ.
22/3/89.
ವಾಟ್ ಇಸ್ ದ ಪ್ರೇಸ್ ವಾಟ್ ನಾವು?
ನಾ ರೆವಿನ್ಯೂ ಇದು ಕಂಪ್ಯೂಟರ್ RTC-ನಲ್ಲಿ ಭೂದಾನ ಅಂತ ಬಂದಿದೆ, ನನ್ನ ಹೆಸರಿಗಿಂತ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಕೊಟ್ಟಿದೆ.
ಏನು ಭೂದಾನ ಅಂದ್ರೆ ಏನ್ ಮೇಡಮ್ ಅದು?
ವಿನೋಬಾವೆ ಅವಾಗ ಸ್ವಾತಂತ್ರ್ಯ ಪೂರ್ವ ಚಳವಳಿಗಳಲ್ಲಿ ಕೆಲವರೆಲ್ಲ ಲ್ಯಾಂಡ್ ವಾಲಂಟರಿ ದಾನ ಮಾಡಿದ್ದಾರೆ. So it is found a place in 89, 88 itself. Saying that 1 ಎಕರೆ ಭೂದಾನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Sometimes ಆ ಒಂದು ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕೆಲವೆಲ್ಲ ದಾನಪತ್ರ ಇಲ್ಲದೆ ಇದ್ರು RTC-ಲಿ ಬರ್ಸ್ಬಿಟ್ಟಿರ್ತಾ ಇದೆ.
ಅವ್ರ ಪಾಪ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ.
ಪರ್ಚೇಸ್ ಮಾಡಿದೆ. RTC ನಮ್ಮ ಹೆಸರಲ್ಲಿದೆ, ವೆಂಡರ್ ಹೆಸರಲ್ಲಿದೆ.
ನಾನು ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತದೆ. RTC 87, 88 ಇದನ್ನು ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಅಂತಾನೆ ಇದೆ.
ಅಲ್ಲ, ನೀವು ಆ ತರದ್ದು ಎಲ್ಲ ಬರಲ್ಲ. ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್, ಪಟ್ಟಾ ಲ್ಯಾಂಡ್ ಅದು ಸೇಲ್ಡ್ ಇದೆ.
ಅವಾಗೆಲ್ಲ ಭೂದಾನಕ್ಕೆ ಸುಮಾರು ಲ್ಯಾಂಡ್ಗಳೆಲ್ಲ ಬಂದಿದೆ ಸರ್.
ಕಂಪ್ಯೂಟರೈಸಲ್ಲಿ
ದಾನ ಮಾಡಿದ್ದಾರೆ. ವಿನೋಬಾ ಭಾವೆ ಚಳವಳಿ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲಿ ಅವಾಗ ಸುಮಾರು ಲ್ಯಾಂಡ್ಗಳೆಲ್ಲ ಭೂದಾನ ಅಂತ ಹೇಳಿ ಸ್ಕೂಲ್ಗಳಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. That's why it's find a place in art.
ಎಲ್ಲಿದೆ ಭೂದಾನ ಅಂತ? ಎಲ್ಲಿದೆ?
ಏನ್ರಿ ಬೆಳಿ ಏನಿದಿರಿ?
ಎಲ್ಲಿದೆ ಭೂದಾನ ಅಂತ ಎಲ್ಲಿದೆ ಹೇಳಿ?
ಶಾಂತ್ ಕುಮಾರ್ ಅವರೇ,
ಭೂ ಸ್ವಾಧೀನ ಅಂತ ಎತ್ರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬೆಳೆ ಏನಿದಿರಿ ಇಲ್ಲಿ?
ಬೆಳೆ ರಾಗಿ ಏನೋ ಇದೆ ಸುಮ್ಮನೆ.
ಹಾ,
ರಾಗಿ
ಇದೆಯಾ?
ಹೌದು. If it is spot inspection ಮಾಡಲಿ, ಇದು change the mutation into RTC change ಮಾಡಿ. Even to direct the respondent Tahsildar to go to spot inspection and
Beyond 88 ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಈಸಿನ.
88 ನಾನು ಪರ್ಚೇಸ್ ದಿ ಪ್ರಾಪರ್ಟಿ 18 ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
Produce the previous.
ನೀವು ಮಾಡಿ.
ಹಾ,
That's why I have produced the RTC.
ಆಗ್ಬೇಡ, ಅದು ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿರ್ಬೇಕು.
ನಾನೇ ತಂದು ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ.
ಅಲ್ಲ, ಅದು ಕಡಿಮೆ ಆಗ್ಬೇಕಾದ್ರು ಗೌರ್ಮೆಂಟ್ ಕಡಿಮೆ ಆಗ್ಬೇಕಾದ್ರೆ ಬರೀ ಓರಲಿ ಆಗಲ್ಲ.
ಓರಲಿ ಇಸ್ ನಾಟ್ ಇದು.
ಲರ್ನಡ್ AGA is contesting this petition on the ground that the petition land is already gifted by the erstwhile owner to the government, while petitioner is tracing title by way of sale deed. Learned AGA is contesting the encumbrance certificate furnished by petitioner on the ground that encumbrance relates only from the date of purchase by petitioner and not prior to that. Therefore, learned AGA is hereby directed to place on record encumbrance prior to the sale deed obtained by petitioner. Yes. Listed in B group. Next.
Number 20.
Date,
28.
Mohammed Tahir.
Petitioners.
Yes, sir. Yes. First time, sir, ಇದು?
ಇಲ್ಲ ಇಲ್ಲ ಬಂದಿತ್ತು ಅವ್ರಿಗೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಕರ್ಸು. Kindly see annexure D, my lord, page 73.
Yes, madam.
My lord, in this matter, my lord, I seek for weeks time. AG Banprakash sir appearing in this.
Ah,
AG Banprakash sir is representing in this matter, my lord, I pray for weeks time in this matter. Got instructions. Or ಈ ವಾರ ಸ್ವಲ್ಪ ಇಂತ ಮೊನ್ನೆ ಬಂದಿತ್ತು ರೀಚ್ ಆಗಲ್ಲ ವೇಟ್
ಆಯ್ತು ಪ್ರಿಲಿಮಿನರಿಗೆ ಮತ್ತೆ
ಪ್ರಿಲಿಮಿನರಿ
ಅಷ್ಟೇ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Undertaking given by the state shall remain in force till next date of hearing. Hold on, 10 days.
next week.
25-2.
Yes, next.
Number 21.
Actually, this is a writ of Mandamus, your lordship.
As a Tahsildar Maddur, but it has to be K.R.Pete.
ತಪ್ಪಾಗಿದೆಯೋ ಅದು?
Tahsildar.
ಕರೆಕ್ಷನ್ ಮಾಡ್ಬಿಡಿ. ಅದೇನ್ ಪ್ರೇಯರ್ ಇದೆ ಮಂಜುನಾಥ್?
So they are seeking for consideration of application, my lord. Yesterday, I called them, my lord. They have to verify the records, my lord. I pray for 2 days accommodation.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡು ಬಿಡಿ.
Next week.
Till then, please correct it. Please. ಅದೇನಾಗಬೇಕು ಮಂಜುನಾಥ್ ಅದು?
K.R.Pete Taluk, Tahsildar K.R.Pete Taluk, Monday.
Second respondent is wrongly arrayed in the petition. The matter pertains to KR-Pete Taluka. However, Mandya Taluk, Tahsildar of Mandya Taluka is arrayed as a second respondent. Here is orally permitted to rectify the second respondent in the open court. ಮಾಡಿ ಇಲ್ಲೇ ಕರೆಕ್ಷನ್ ಮಾಡಿ. Petitioner shall amend. ಮಾಡ್ಬಿಡಿ ಇಲ್ಲ KR-Pete ಅಂತ ಮಾಡ್ಬಿಡಿ.
K.R.Pete.
ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ ಮಂಜು?
Yes, ma'am.
List it next week.
May I pray for a date, your lordship?
22. Yes, sir, she can take order.
Alternative remedy for this order.
Ah,
AC has passed order under 108. They can go for alternative remedy for this.
ಬರ್ಲಿ ಪಾಸ್ವರ್ಡ್.
Number 23.
only pass over the matter.
Password, all right.
24.
24. Yes, sir, one.
I pay for the petition in this case, my lords. Since from 2016, my lords, there were proceedings for allotment of land, my lords, for the association.
Fresh
Good.
matter.
Fresh matter, my lords.
This is also connected, my lord. Serial number 4 matter. That is,
ಹೌದಾ?
they are also seeking grant in the disputed area.
ಅದೇ.
ಇದರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂದ್ರೆ ದೇ ಪ್ರಿಪೇರ್ ಎ ಲಿಸ್ಟ್. ಎಲ್ರಿಗೂ ಕೊಡ್ತಾರೆ, ನಮ್ಮನ್ನ ಕೈ ಬಿಟ್ಟು ಬಿಡ್ತಾರೆ. ಇದು ಒಂದ್ಸತಿ ಅಲ್ಲ, ದಿಸ್ ಇಸ್ ನಾಟ್ ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್. They in the list, my lord, they draw sketch, they prepare a list, they send the file to government.
ಸಂಸ್ಥೆಗಳಿಗೆ ಕೊಡೋದಕ್ಕಿಂತ ನಮಗೆ ಗವರ್ಮೆಂಟ್ ಬಾಡಿಸಿ ಕೊಡೋದಕ್ಕೆ ಲ್ಯಾಂಡ್ ಇಲ್ಲ.
ಇದೆ, my lords, I produce a document to indicate there are still land is available.
All right. Letter is directed to accept notice. Next.
Sir, number 25.
Connect ಆಗ್ಬೇಕು.
25.
25 S.V. Prakash. S.V. Prakash.
ಡೇಟ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಮೂಡ್ ಇದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ. ಡೇಟ್ ಗಿವನ್ ಇದೆ. ಕೊಟ್ಬಿಡಿ. ಡೇಟ್ ಗಿವನ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಲಿಸ್ಟ್ ಇಟ್ ಆಫ್ಟರ್ 2 weeks ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
27.
ನನ್ನ PS list on so and so date. Next, Chokareddy.
26.
Application, my lord, this to go directed, my lord, to keep the presence of the concerned deputy commissioner. Present, my lord.
Deputy Commissioner is present. ಏನ್ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ ಏನ್ ಮಾಡ್ರಿದು?
Right, this is the podium,
ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಯಾಕೆ ಸಮನ್ ಮಾಡಿದೀರಾ?
podium Durasti matter. Earlier, my lord, this honorable court has issued,
Cost of rupees 25,000 each.
Ah,
Commission task.
is not complied ಅಲ್ಲ?
Lord,
is not
this
compliant.
Against that order, my lord, department inquiry is also there, my lord. We have prepared, government has prepared an appeal, my lord.
When you preferred an appeal. ಅದು ನೋಡ್ತೀನಿ ಬಿಡಲ್ಲ ಇವರೆಲ್ಲ ಮಿಸ್ಯೂಸ್ ಇವರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ಗಳೆಲ್ಲ. ಇನ್ನೊಂದು ಆಕ್ಷನ್ ವಿಲ್ ಇನಿಷಿಯೇಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಂಕ್ವೈರಿ ಅಗೇನ್ಸ್ಟ್ ಇಟ್. ವೇರ್ ಇಸ್ ಹಿ?
ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ? ಡಿಸ್ಪ್ಲೇ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ?
Was it the deputy commissioner when this order was passed or he is up? What is the date of order? He was in charge? Ask him why has not complied the order of this court? You ask him, he has to root out through you. He can't make direct submissions.
Page number 117.
1-1?
117, yes, annexure, yes. Operative portion 131, my lord. Last page, 131.
Yes, he was called upon to pay cost of 25,000 within a period of 4 weeks.
To the petitioner,
This,
to the petitioner.
or to the petitioner,
Yes.
and each deputy commissioner and Tahsildar, why this cost is not paid to the petitioner?
Immediately, they written a letter to the government, department and inquiry ಕೂಡ ಇದರಿಂದ cost ಜೊತೆ immediate government ಗೆ letter ಬರ್ತಿದ್ರಂತೆ. Government has suggested to prepare an appeal, my lord. There is a delay.
All right, whether you have preferred an appeal within 4 weeks?
Today,
Today you are filing, I would only to overcome.
today filed.
No, I will not accept it.
Because departmental inquiry ಎಲ್ಲ ಇರೋದ್ರಿಂದ.
And now I am going to order departmental inquiry. They think too much about themselves. And you should have communicated, ಇದು compliance report ನಿಮಗೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ನಾವು.
Communicated.
ಇದ್ರಲ್ಲಿ ಬರಲಿಲ್ಲ ನಾವು. Will initiate contempt also. ಕೊಡ್ರಿ contempt proceedings ಕೊಡ್ರಿ. ನಾವೇ ಮಾಡ್ಬೋದೇನ್ರಿ ಪಾಟೀಲ್ ಸರ್? ನಮ್ಮ ಮಾಡ್ರಿ ಯಾವ ಪ್ರಯೋಜನಕ್ಕಾಗಡ? ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದೆ ಇವ್ರದೆಲ್ಲ. ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಸಾಮಾನ್ಯ ಜನದ ಏನ್ ಮಾತು ಕೇಳ್ತೀರಿ ನೀವು?
Immediately they have taken the steps, my
Ah?
lord. Immediately they have taken the steps, my lord, to prepare an appeal.
What immediate you have filed today? That too when I noticed that cost is not deposited on the previous date.
Departmental inquiry ಕೂಡ ಅದಕ್ಕೋಸ್ಕರ ಅವರು appeal ಆಗ್ತಾರೆ. Cost ಗೆ ಅವರು ಮಾಡಿಕೊಂಡು.
Ah?
Inquiry initiate ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಇರೋದ್ರಿಂದ
Cost ಕಟ್ಟಿದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಂಕ್ವೈರಿನಾ?
I make two submissions.
Yes,
Well,
madam.
This matter came to this cause, I represented this officer, madam.
Or new reprint ಮಾಡಿದ್ರಾ?
Yes, ma'am. I represented while passing this order. The role of a special DC is very limited. Because as and when the notice pushed through computer by the Tahsildar, he will not come to know that why this notice has been pushed. Only after application of mind only, the DC will have to decide. Before deciding by the DC, the petitioner has approached this court challenging the notice itself. There is no role, there is no application of mind by the special DC. On that day itself, I requested this honorable court because DC has no role, my lord. This is only computer pushing of applications, my lord, by the Tahsildar. The DC ಮುಂದೆ our application ಮಾಡೇ ಇಲ್ಲ, mind application ಆಗೇ ಇಲ್ಲ. Only as and when application notice came to be issued, the petitioner approached this honorable court for the rejection of the notice, my lord. On that day itself, I make this submission, my lord. Somehow this honorable court has pleased to issue cost on both the officials and they want to prefer an appeal. Please, they have preferred appeal, my lord, only regarding conducting inquiry. There is no fault on the part of the special DC. These are all technical.
No, madam. Once an order is passed,
Yes.
either you have to seek review.
They have preferred
Chamber ಕುತ್ಕೊಂಡ್ರೆ he thinks too much of himself.
My lord,
appealing.
ಇದು ನೋಡಿಲ್ವಾ ಇದು ಆರ್ಡರ್ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ಲ? What he thinks of himself?
He filed appeal.
ಯಾವಾಗ ಇವತ್ತು? Madam, ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
He's under process, my lord.
What process?
15 days ಇಂದ ಇತ್ತು ಅದು.
Then why I should not take action against him? ಯಾವಾಗ ಆಗಿದೆ? ಸೆಪ್ಟೆಂಬರ್ದಲ್ಲಿ ಆಗಿದೆ madam. Within 4 weeks I have said. You should have challenged it in the 6th day.
My lord, one submission. Writ petition allowed. Review petition filed by the state. It was dismissed. Writ appeal filed. Now, one my submission. Writ petition filed, my lord, writ
ಎಲ್ಲ
petition
ನೋಡಿನ ಮಾಡಿದ್ದೆ madam.
allowed.
On merit, we have no voice. But somehow the notice generated because of the computer 136.
I am not,
As a casual manner, through computer, it has pushed to special DC login, my
you
lord.
can't reform your officers. We have to take action.
State,
Happened only because of computerization.
And you see, you have not complied also. Cost is not paid and you have not complied the directions also. What were the directions?
Directions is to deposit cost. And they want to challenge that order because of inquiry has been directed against this officer.
page number 131.
See, read Roman 3, madam. Yes. And I will not recall this order. Anyway, you filed it appeal. Read Roman 3, madam, page 130.
Yes, sir. Court is hereby directs state government to initiate appropriate inquiry and its respondent to for his actions that are in blatant violation of the directions issued by the court and for misusing the authority by attempting react. That's why, my lord, the
Re-
special DC has no occasion to apply his mind. He just, because Tahsildar as and when pushed the application, the notice will be generated automatically, it will go to petitioner, my lord. As and when the notice reach the petition, they are before this court.
ಚೆನ್ನಾಗಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ಸಾಫ್ಟ್ವೇರ್ ಮಲ್ಟಿ ಲೇಯರ್ಡ್.
ಅದು
ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಏನು ಸ್ಯಾಂಕ್ಟಿಟಿನೇ ಇಲ್ಲಲ್ಲ, ಒಂದು ಫೈನಾಲಿಟಿ ಅನ್ನೋದೇ ಇಲ್ಲಲ್ಲ.
ಅಲ್ಲಿ ನಾವು
mine is a consequential order, madam.
ಬಗ್ಗೆ ನಾವೇನು ಹೇಳಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಜಸ್ಟ್ ವಿ ಹ್ಯಾವ್ ಇನಿಷಿಯೇಟೆಡ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಷ್ಟೇ.
Kindly see the
ಅದು
writ
notice
appeal order,
ಏನಿದೆ
my
ನೋಡಿ.
lord. Writ appeal order.
Huh?
Writ appeal order, my lord. State has the deputy commissioner, assistant commissioner, all the state, my lord, have filed the writ appeal. In page number 112, annexure R, my lord, wherein my grant was upheld by the honorable division bench, my lord. In para number 2,
They are not denying the genuinity.
para number 3, no, page number 115, where deputy commissioner has prepared the appeal. Deputy commissioner has filed the review petition. It was dismissed. Again, writ appeal filed. Writ appeal, my lord, disposed. 3, my lord, para number 3, 115, in the division bench.
Would have applied the mind by the special DC, definitely. the
And
people
earlier,
also-
1960, very deputy commissioner has passed the order and declared that my grant is denied. 1960 itself passed the orders, my lord. In review petition, my lord, page number 11.
ಅಲ್ಲ ಅವರು ನೋಟಿಸ್ ಏನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ?
For appearance of before.
Let us say what are the contents.
Call for the records from 1947 to till date.
He thinks too much. He is above division bench.
The standard.
A deputy commissioner thinks that he is above division bench of this court.
This is like this, my lord. He won't before.
Ask him, send him before the deputy commissioner. Let us see. You ask him to get that matter posted.
14
Madam,
notices, my lord.
Madam, let us see how division bench will deal with this case. One ವಾರ time ಕೊಡೋಣ. List it. Landed AGA and SCGP together bring to the notice of this court that the order passed by this court in imposing cost on the deputy commissioner is assailed by filing a writ appeal. This court has noticed that this court is more than satisfied that that the deputy commissioner has resolved to challenge this order only when this court noticed on the previous date that cost of 25,000 imposed on deputy commissioner and Tahsildar is not complied. Anticipating action at the hands of this court, deputy commissioner has now, deputy commissioner through AGA makes a submission that this order is challenged. On a query to learned AGA as to when writ appeal is filed, It is brought to the notice of this court that this writ appeal is filed today. Finally, a week's time is granted to move the writ appeal court. It is made clear that if no orders are secured at the hands of the Honorable Division Bench, this court will proceed against the Deputy Commissioner in a manner known to law. Read with this matter in preliminary on so and so date.
Special deputy. Special deputy commissioner.
Special Deputy Commissioner for Court.
Placed.
Not only the cost method inquiry could idea pending. Not only the cost method inquiry could idea.
Yes.
The cost method.
Inquiry, departmental inquiry and cost.
19th.
ಇದನ್ನ ನಾವು ಕಂಟೆಂಪ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ಲೇಸ್ ಮಾಡ್ಬೋದಲ್ಲ ಸರ್?
ಮಾಡ್ಬೋದು.
It has to be routed out through registry. ಅಂದ್ರೆ ಬರಿಬೇಕು, that is a prima facie case of a contempt in this case.
The registrar will place it, register it as a case and place it.
We'll do it on the next date.
Number 27, Somshekhar PH.
Yes, sir.
ಇದರಲ್ಲಿ there is a land grant in favor of Akkayamma, 10th March 1972. Thereafter, Akkayamma, during her lifetime, it's entered in the revenue records till 1983. After the death of Akkayamma, name is not continued. Now, earlier occasion, we had approached this court. There was a direction.
ಇದು ಬಂದಿದೆ, ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ ನಮ್ಮ ಮುಂದೆ.
ಇಲ್ಲ ಮೊನ್ನೆ ಬಂದಿತ್ತು.
ಹಾ,
ಅದಕ್ಕೆ ಅವರು ರೆಕಾರ್ಡು ಇದು ಅಂತ ಅಂದ್ರು. ಅವರ ರಿಜಿಸ್ಟ್ರಿಂದ ಹಿಡಿದು ಅವು ಅಷ್ಟು we have the certified copy. All that I am saying is, again ಇವ್ರು ಬರೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಕಳಿಸಿದ್ರೆ ಆಗೋ ಅಂತದಲ್ಲ. Because of that, we said some positive direction to do it may. Kindly see Annexure B, my lord. Annexure B.
Yes, sir.
Idu darkhast register in a copy. Last entry is in the name of Akkayamma. Application in. Then Annexure C, page 16. (24/2/1972) ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ರೆಕಾರ್ಡ್ ಇದೆ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ.
ಎಲ್ಲಿ ಪೇಜ್?
Annexure C, page 16.
Typed copies on the next page.
ಹೌದು, ನನ್ನ ಹತ್ರ ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಇದೆ, ನನ್ನ ಹತ್ರ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ.
We have the certified copy.
Certified copy of this.
Yes.
Then Annexure D, page 18. Now 10/3/1972 ಕ್ಕೆ ಅಮೌಂಟ್ ತುಂಬಿದ್ರದ್ದು ಚಲನ್ ಕಾಪಿ ಇದೆ. I have the original also. Then the
Annexure D is
Annexure D,
a premium ಕಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಚಲನ್ ಕಟ್ಟಿದ್ರದ್ದು I have the original.
ಯಾವುದು ರಿಕಮೆಂಡೇಶನ್ ಬೈ ದಿ ಕಮಿಟಿ, ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಕಮಿಟಿ?
ಅಲ್ಲ, ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ 72 ದಲ್ಲಿ.
ಓ, 72.
72 ದಲ್ಲಿ.
ಚಲನ್ is also.
ಹಾ, ಒರಿಜಿನಲ್ ಚಲನ್ ಇದೆ. ಸಾಗೋಳಿ ಚಿಟ್ 10/3/72 ಸಾಗೋಳಿ ಚಿಟ್ ಒರಿಜಿನಲ್ ಇದೆ. Akkayamma died 13/6/2009.
Yes.
Akkayamma's son Mariappa died on 13/4/2020. That resulted in the daughter-in-law, that is Mariappa's wife, making the application. Annexure J is the order. Illi, that was on 10th October 2023. Order ಮಾಡಿದ ಕೂಡಲೇ they take a action by dispatching a letter to Devanalli office for calling for original grant records. Devanalli office at Annexure K annexure L, ಇದು MN, page 45.
Yes.
ತಹಸೀಲ್ದಾರ್ ಯಲಹಂಕ ಇವರಿಗೆ ದೇವನಹಳ್ಳಿ ತಹಸೀಲ್ದಾರ್ ತಿಳಿಸ್ತಾರೆ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಸೀನ್. ತತ್ಸಂಬಂಧ ಈ ಕಚೇರಿಯ ಅಭಿಲೇಖಾಲಯ ಶಾಖೆಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಯಲಹಂಕ ತಾಲೂಕ್ ಜಾಲ ಹೋಬಳಿ ಬೆಟ್ಟಹಲ್ಸೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 259 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದರಖಾಸ್ತು ವಹಿ ಲಭ್ಯವಿದ್ದು, ಅಂದ್ರೆ ರಿಜಿಸ್ಟರ್ ಅವೈಲೇಬಲ್ ಇದೆ. ವಹಿಯು ಭಾಗಶಃ ಶಿಥಿಲಗೊಂಡಿರುತ್ತದೆ. ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣಾ ವಹಿ ಇದ್ದು ಶಿಥಿಲವಾಗಿರುತ್ತದೆ. ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಮಂಜೂರಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣಾ ವಹಿ ದರಖಾಸ್ತು ವಹಿ ಹೊರತುಪಡಿಸಿ, ಅಂದ್ರೆ ಅವೆರಡು ಅವೈಲೇಬಲ್ ಇದ್ದಾವೆ, ಹೊಡಿಸಿ ಇತರೆ ಯಾವುದೇ ಪೂರಕ ದಾಖಲೆಗಳು ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಜಾಲ ಹೋಬಳಿ ಜಮೀನಿನ ನೈಜತೆಯ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ ಮಂಜೂರಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸಬಹುದು. So he says, in our office only these two registers are available with regard to grant. Other things are not available. Either way, the matter remains like that.
ತಗೊಳ್ಳಿ register is maintained by you. ಅದ್ರಲ್ಲಿ ನೋಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. It's original record which is with you. And they have certificate copy with them.
The last occasion, my lord, received the copies, more copies, my lord, same has been forwarded to the Tahsildar. How much?
ಅಲ್ಲ, ನಾವು ಅದನ್ನ ತಹಸೀಲ್ದಾರ್ರಿಗೆ ಅದಷ್ಟು ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದೇವೆ. ಆದ್ರೆ ಇವನ್ನ ಅವ್ರ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟು ಇದನ್ನೂ ಒಂದು ಕಳ್ಕೊಳ್ಳೋದಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ನಾವು. ಅವ್ರ
This is the second petition ಈಗ. ಒಂದು ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಆಗಿದೆ. ಯಾಕ್ರಿ ಅವರು ಈ ತರ ಎಲ್ಲ ಮಾಡ್ತಾರೆ?
83 ದಿಂದ ಅಕ್ಕಯ್ಯಮ್ಮನ ಹೆಸರು ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ಬಂದಿದೆ. There after it is ಅಕ್ಕಯ್ಯಮ್ಮನ ಮಗನ ಹೆಸರನ್ನು ಮಾಡಲಿಲ್ಲ, ಯಾವುದನ್ನು ಮಾಡಿಲ್ಲ. It's not continued.
Woodley Grantee's name was mutated.
Yes, it had appeared in the revenue records. I have produced it. Kindly see at annexure F, page 30. ಸಾಗುವಳಿದಾರ ಕಾಲಮ್ ನಲ್ಲಿ ಅಕ್ಕಯ್ಯಮ್ಮ ಹೆಸರು ಬಂದಿದೆ. For the year 78, 79 onwards, up to 82, 83. Therefore, on the earlier occasion, there was a direction issue.
You have failed to maintain your records. So you want to punish citizens on the ground that original records are not found anta. Which are those two documents which you have admitted now?
That is annexure B and annexure B and annexure C, they are admitting.
B, what is B, sir?
B is the application register.
That is the main.
ಒಂದು application ಹಾಕಿದ್ರ ಬಗ್ಗೆ. Annexure C is recording of the application being disposed, granting the land. It is registered in the register, entry is found.
B and C.
B and C. I have chalan, original of the chalan for having paid the amount, and the original sagoli chitti issued to me. ಇದು ಕೊಡಿ. ಇದು 10,372 ನಾವು 75 ರೂಪಾಯಿ ಅದು ಕಾಸ್ಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರದ್ದು ಟ್ರೆಜರಿ.
So these are all the annexure M and N, my lord, these are all the internal communications of Devanali Tahsildar and Yelahanka. I don't know, my lord, how they work. These
ನೋಡಿ
are-
ನೀವು ನೋಡಿ
these are not the certified copies, my lord.
ಇದು ನೋಡಿ. They are the originals of what, sir? ಅದು
ಒಂದು ನಾನು ರೊಕ್ಕ ತುಂಬಿದ್ದು, ಇನ್ನೊಂದು ಒರಿಜಿನಲ್ ಸಾಗುವಳಿ ಚೀಟಿ ಇಶ್ಯೂಡ್ ಟು ಅಕ್ಕಯ್ಯಮ್ಮ. ಸಾಗುವಳಿ ಚೀಟಿ ವಹಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆರ್ಡರ್ ರಿಜಿಸ್ಟರ್
ಕೊಟ್ಬಿಡಿ. ಬರ್ಕೊಡ್ರಿ. The second round of litigation, wherein petitioner is now again compelled to approach this court, assailing the endorsement.
ಇವಾಗ ಬರೀ ಮ್ಯಾಂಡಮಸ್
ಏನ್ ಬರ್ದಿ? There is a second round of litigation where petitioner is compelled to knock the doors of this court, seeking directions at the hands of this court. Are the learned senior counsel appearing for petitioner and learned CJP appearing for respondents. Petitioner. In the caption petition has sought for issuance of writ in the nature of mandamus. Referring to the ಇದು communication ಅಲ್ಲ, ಇದು annexure ಏನು?
ಅನೆಕ್ಷರ್ ಎಮ್ಮು
N.
ಎನ್ನು ಯಲಹಂಕ ತಹಸೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ಅವರಿಗೆ ಬರೀತಾರೆ, ಇವೆರಡು ವಹಿ ದರ್ಖಾಸ್ತು ವಹಿಯ ದೃಢೀಕೃತ ದಾಖಲೆಗಳೊಂದಿಗೆ ಕಳಿಸ್ರಿ ಅಂತ. ಅವರು ದರ್ಖಾಸ್ತು ವಹಿ ನಮ್ಮ ಹತ್ರ ಇದಾವೆ, ಬಟ್ ಉಳಿದ ಆರ್ಡರ್ ಎಲ್ಲ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂತೇಳಿ ಅವರು ಒಂದು ಉತ್ತರ ಕಳಿಸ್ತಾರೆ. ಹೀಗೆ ಹಾಗೆ ಮುಂದೆ ಹೋಗ್ತಾ ಇದೆ.
On an communication sent by third respondent / Tahsildar Yelahanka, Tahsildar Devanhalli has sent a responding communication dated 21/10/2024, evidence that annexure and indicating that the Devanhalli office has maintained records indeed relating to maintained records, and the only two relevant documents relating to this petition land are available with his office, namely
ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್
Darkhast register, which is evidenced at annexure B.
And ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣಾ ವಹಿ, ದಿ ರಿಜಿಸ್ಟರ್ ಇಶ್ಯೂಯಿಂಗ್ ದಿ ಸಾಗುವಳಿ ಚೀಟಿ.
And the register issuing
Register maintaining the issuing of
maintained in issuance of ಸಾಗುವಳಿ ಚೀಟಿ
are available ಅಂತ ಹೇಳ್ತಾರೆ, ಉಳಿದಿದ್ದಿಲ್ಲ.
Next, the second respondent, Tahsildar, who is obligated to look into these documents and take action under the provisions of section 128 and 129, is clearly found to be in complete laxness in not considering petitioner's representation dated so and so.
Respondent 3 ತಹಸೀಲ್ದಾರ್ 2-1.
ಎರಡೇ ಇದಾರಲ್ಲ, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ತಹಶೀಲ್ದಾರ್. Petitioner is tracing title over this petition land through her mother-in-law. Mother-in-law. Petitioner asserts that her mother-in-law had the benefit of grant at the hands of a competent authority, and the then Tahsildar Devanhalli has issued a Sagoli chit, which is evidenced at Annex E. Records the conduct of third respondent in squatting over petitioner's claim clearly gives an indication that this is a case of dereliction of duty at the hands of third respondent Tahsildar. The revenue officials are required to maintain the records, more particularly the crucial documents relating to grant made in favor of the citizens. More often, this court is encountering the lackadaisical attitude of the revenue authorities in not maintaining the public documents and then shying away their obligation to act on the request made by the citizens when more particularly where inheritance khata is insisted by the legal heirs of original grantee. The revenue officials are often issuing endorsement or endorsement indicating that original records are not present, or an endorsement is issued indicating doubting the very genuineness of the grants. Next, now coming to the case on hand, two documents, namely the
Annexure B, register of application.
the Annexure B, which is the register of application received by the then Tahsildar, would be a crucial document. Perusal of Annexure B, it is clearly evident that petitioner's mother-in-law, Akkaima's application, is indicated at Annexure B. In response to the claim made by a petitioner's mother-in-law, the authorities have granted, and same can be gathered from the certificate register of issuance of Sagoli chit.
ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್ ಅಪ್ಲಿಕೇಶನ್ ಏನಾಯ್ತು ಅನ್ನೋದನ್ನ ಮುಂದೆ ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್ ನೋಡಿ Annexure C page 16.
The Darkhast register pertaining to issuance of grant orders.
Grant order.
Which is also evidence from Annexure C. On closer examination of this document, it is clearly evident that the petitioner's mother-in-law was granted the land in question while order dated 24/2/1972 nadu.
ಹೌದು 24/2/72.
72. The Leonard Senior Council today in the open court has also
ಅಲ್ಲ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ Annexure D and E. I have the originals. We have produced
the petitioner has also produced a true copy of the challan for having deposited the requisite premium as demanded by the authority before issuing Sagoli chit, which is also evidenced at Annexure D. The documents, the original documents of Annexure B and
D and E
were also furnished before this court. This court has given its sanctions consideration to these original documents. These documents were also handed over to the Leonard SCGP to examine these original records. Next, in the light of these significant details, this court is of the view that a simple mandamus that was issued on earlier occasion calling upon the respondent authorities to act upon the grant order obtained by petitioner's mother-in-law and pass appropriate orders on the earlier repetition had not yielded any results. On the contrary, the third respondent, Tahsildar, appears to have further complicated the case, which can be gathered from the endorsement issued by the Tahsildar Devanalli as per Annexure N. On closer examination of Annexure B, D, B, C, and D, petitioner is able to substantiate that a mother-in-law had the benefit of a grant order at the hands of a competent authority, followed by grant serving which is issued by the competent Tahsildar, the then Tahsildar. The fact that petitioner's mother-in-law has paid the premium is also evidenced at Annexure D. Petitioner, next, who claims to be a daughter-in-law, is made to run pillar to post only to get a name mutated based on the grant obtained by petitioner's mother-in-law. It is also not in dispute that petitioner's mother-in-law name was reflected in RTC pursuant to grant. Therefore, this court is of the view that a positive direction needs to be issued to the third respondent, Tahsildar. The documents which are now available with the office of Devanalli, Tahsildar, office of the Tahsildar office Devanalli would suffice in deciding petitioner's claim. Therefore, there shall be no impediment for third respondent Tahsildar to secure these original records. It is quite interesting to note that even now petitioner is holding certified copies of relevant documents, which should enable the revenue authorities to act upon these public documents and ensure that petitioners' right, that citizens' rights in immovable property are not declined for want of proper documents at their end. If petitioner, a illiterate lady through her mother-in-law, is able to maintain the original records with her, it is incumbent on the part of revenue officers to either retrieve or look into these documents and pass appropriate orders and restore the names of legal heirs of original grantee. Petitioner, in the light of these crucial documents, has a legal right to seek mandamus in the hands of this court and direct the respondents to act on the reputation dated so and so. Next, third respondent is equally obligated to consider petitioner's reputation strictly adhering to the procedure contemplated under section 128 and 129 of Karnataka Revenue Act. It is open for third respondent to look into the original, to old RTCs where original grantee's name was reflected in RTC. For the foregoing reason, this court passes the following order. Writ petition is allowed. Third respondent Tahsildar shall secure the existing records which are indicated in Annexure N and proceed further and adopt further course of action. Next, on receipt of the records as indicated in Annexure N, third respondent is also at liberty to look into the certified copies of these orders which are in the custody of petitioner. After examining these records, third respondent shall ensure that petitioner, being a legal heir of original grantee, is entitled to seek change of khata. Full stop. Next, the third respondent shall accomplish the task of change of khata within a period of 10 weeks from the date of receipt of order copy. 10 weeks.
Is under inquiry, my lord. 3 months time may be granted.
Order 3 months. 3 months from the date of receipt of order.
28, Swami LBM.
Similar to this case also, my lord, because they don't have the records. They
They don't
cancel,
have the records.
they don't have the records, so they have cancelled. And they say forfeit to the government, my land. Page 44, my lord, the operative portion.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಈಗ ಸ್ಟೇ ಇದೆಯಾ ಇದರಲ್ಲಿ?
Illa, first time I'm,
First time
second time, after notice.
ನಿಮ್ಮ ಹತ್ರ ಏನ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ?
I've got the grant itself. If you see annexure A, my lord, page 15. It is 77-78 in the it was a Gomala land. My vendor was an unauthorized occupation. Then it was granted to him by annexure B.
ನಿಮ್
Sagodi
sale deed
check has-
ಯಾವಾಗ?
Yes, ma'am.
When did you obtain sale deed?
I obtained sale deed in 2096, my lord,
You obtained in 1996.
96.
ಈಗ
That
ಏನ್
is-
ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
What is the order now? They say that this grant is not genuine.
They don't have records, so the mutation done into this record is not correct. So it should forfeit to the government.
ಓ ಇದು ಎಂಕ್ವೈರಿ ಅಲ್ಲ, 136(3) ಕೆಳಗಡೆ ಸಪರೇಟ್ ಎಂಕ್ವೈರಿ ಅಲ್ಲ.
Illa, separate illa.
ಇಲ್ಲ ನೀವು ಅದು ವಾಟ್ ವಾಸ್ ದ ಒಕೇಶನ್ ಫಾರ್ ದಿಸ್ ಜೆಂಟಲ್ಮನ್?
Revision by the sumoto revision by the.
ಅದೇ ಎಂಕ್ವೈರಿ ಅದು.
ಹೌದು.
ನಿಮ್ದು ಸೇಲ್ ಡೀಡ್ 1996.
96. In similar matter.
ಯಾರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ? ಗ್ರಾಂಟಿಂಗ್ ಮಾಡಿರ್ಬೇಕು ನೀವು. ಅವ್ರಿಗೆ ದೇ ಹ್ಯಾವ್ ವಾಶ್ಡ್ ಆಫ್ ದೇರ್ ಹ್ಯಾಂಡ್ಸ್.
Fixing a date, my lord, we will.
In similar matters, this court directed for sending it back of the same village, but the division bench has said they could not have exercised the revision after 30 years. That is at the operative portion of 66. There is no.
ಅದೇ ಈಗ ನೀವು ಪರ್ಚೇಸರ್ ಬಂದ್ಬಿಟ್ರೆ ಚೆದಿಲ್ಲ ಅಲ್ಲಿ ಬಂತದು.
ಹೌದು.
Because your rights have stood crystallized. ಆಯ್ತು, ನೋಡೋಣ ಬರ್ಕೊಡ್ರಿ. Petitioner is a purchaser of a granted land. Petitioner ನೀವೇ ಮಾಡಿದ್ದ, ನಿಮ್ ತಂದೆಯವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದ?
ನಾವೇ ಮಾಡಿ.
Petitioner is a tracing title through registered sale deed executed by original grantee on 1/7/1996.
24/10/96.
On
24/10/96.
sale deed obtained on 24/10/1996.
Yes.
ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀರಲ್ರಿ ಸೇಲ್ ಮಾಡಕ?
ಹೌದು. Then I paid amount also, 50% of the.
The petitioner has also ensured that the grantee is secures permission from the government to sell the property. It is the petitioner who has deposited 50% of the market value before securing permission to purchase this granted land. Do yours all these permissions. Now the deputy commissioner, under the garb of inquiry under 136(3), has come to conclusion that this grant is fraudulent.
Illa, no records.
Has come to conclusion that there are no records indicating that this land was granted to petitioner's vendor. Consequently, has directed to
Cancel the mutation and take back the land.
cancel the mutation and take back possession. Matter requires consideration. Accordingly, the order of the deputy commissioner, special deputy commissioner, while annexure L is stayed pending consideration of the caption petition. It is open for state to file statement of objection, list it in B group.
29. That is,
Yes, 29.
number 29,
Date code, date given in there. List it on so and so date.
24.
Yes, next.
Number
None
30.
appears, list it on so and so date.
Number 30, I
Yes,
appeal for the
Baldare,
petition.
await notice,
Await notice.
wait notice.
Any
31?
date, my lord. Because emergency ಇದು ನಾ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಮಾಡ್ತೀವಿ.
Correct ಮಾಡ್ಲಿಲ್ಲ ಅದು.
ಇಲ್ಲ ನನಗೆ ಅವೇರ್ನೆಸ್ ಇರಲಿಲ್ಲ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಮಾಡಿರೋದಕ್ಕೆ.
ಹೌದು, ಮತ್ತೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Any date in the 2 weeks, my lord, because they have no objection to transfer the mutate the revenue records in my favor, my lord.
ಅಲ್ಲ, ನೀವು ವಕಾಲತ್ತಕ್ಕೆ ಮೂವ್ ಮಾಡಿ ನಾವು ಅಲೋ ಮಾಡೋ. That you do that.
31,
Next. Await,
32,
await notice. Entry order extended, list it in B group. Next. 32, this also pass over.
33,
Abhishek,
It's sought for writ of Mandamus, my lords, against district commissioner, my lords, to consider my application. My lord. It's a granted land, my lord, survey number 60/2, situated at Are Gudadahalli, at Dodbalapur Taluk, my lords. 2 acre rent kunte grant.
Next for 1 week's time.
ನೀವು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ?
Notice ಆಗಿದೆ last week.
ಅಲ್ಲ, 4 ದುರಸ್ತಿ ಮಾಡಕ್ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
19 34. 7J.
Hearing for petitioner, my lords. But last time notice has been given, my lords,
Yes,
writ of
Vinaya.
Mandamus to mutate the name as per the decree. my lords.
ಅದೇನಾಯ್ತು ಈಗ ಕಡೆಗೆ ಏನಾಯ್ತು? ಇದು ಎಂಟರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆಯಾ ಪೋರ್ಷನ್ ಇದೆ ಮೇಡಮ್?
Portion ಇದೆ.
19 ಹಾಕೋಣ ಇವೆಲ್ಲ.
Like portion.
Portion.
Multiple division ಇದೆ, multiple owner.
ಇದು ಪೋರ್ಷನ್
ಹೌದು.
ಹೆಂಗ್ ಮಾಡೋದು ಇದೆಲ್ಲ?
They have to produce levies. Because of
My lords,
process
what,
55.
my lords, what happen is, my lords, it is a granted land, my lords. It is there is a vast extent. Now 11 sketch apply ಮಾಡಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ. We have tried all our efforts, my lords. Podiಗೂ apply ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ಮತ್ತೆ 11 sketch apply ಮಾಡಕ್
ಯಾಕೆ
ಆಗ್ತಾ ಇಲ್ಲ.
ಆಗ್ತಲ್ಲ?
My lords, because our ಇದು ಈಗ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇಲ್ವಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ 11 sketch apply ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಯಾರ ಹೆಸರಲ್ಲಿ ಇದೆಯೋ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಏನ್ ತೋರಿಸುತ್ತೆ, ಯಾರು ಓನರ್ ಇರ್ತಾರೋ ಅವರೇ ಅಪ್ಲೈ ಮಾಡಬೇಕು. ಆಧಾರ್ ಕಾರ್ಡ್ ಹಾಕ್ಬೇಕು, ಆಧಾರ್ ಕಾರ್ಡ್ ಇಂದ OTP ಬಂದ್ರೆ ಮಾತ್ರ ಅಪ್ಲೈ ಮಾಡಕ್ ಆಗ್ತದೆ. This is the difficulty, my lords.
ಮಾಡಿದೀರಾ ನೋಡಿ ಮೇಡಮ್.
For this we are before this court, my lords.
ಡಿಗ್ರಿ ಪ್ರಕಾರ ದಯವಿಟ್ಟು ಹೆಸರು ಹಚ್ಚಿರಿ, ಆಮೇಲೆಲ್ಲ ಮಾಡ್ತಾರೆ.
ಕೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಇರ್ತಿರ್ಲಿಲ್ಲ.
ಈಗ ತಗೊಳ್ಳಲ್ಲ ಆನ್ಲೈನ್ ನಿಮ್ದು ಅವ್ರ ಹೆಸರಿಲ್ಲ, ಡಿಗ್ರಿ ಇದೆ ಅವ್ರ ಹೆಸರಿಲ್ಲ, OTP ಬರಲ್ಲ ಅವ್ರಿಗೆ.
ಬರೋದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ 1 to 5 ಆಗದೆ ಹೊರತು ಬರೋದೇ ಇಲ್ಲ. ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಎಲ್ಲ
ಅಲ್ಲ ಈ ಕಡೆಗೆ ಒಂದು ನೀವು ಯು ಆರ್ ನಾಟ್ ಟ್ರೈಂಗ್, ದೇರ್ ಇಸ್ ನೋ ಸಾಫ್ಟ್ವೇರ್ ಪ್ರಾವಿಷನ್ ಫಾರ್ ದಟ್. ಡಿಗ್ರಿ ಮುಖಾಂತರ 11 ಸ್ಕೆಚ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರದ್ದು RTC ದಲ್ಲಿ ಹೆಸರು ಇರ್ಬೇಕು.
now anyhow it is under process.
So both ways the citizens are suffering.
Only purchaser should aware of after only conducting 4D ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ ಇದು ಡಿಗ್ರಿ ಇದೆ, ಇದು
ಡಿಗ್ರಿ ಅಲ್ಲ ಆಗಲ್ಲ ಅಂತಾನೆ ಡಿಗ್ರಿ ಮಾಡ್ಕೊತಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಇದು ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಸೂಟಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, it is partition suit, my lords. It is my grandfather's property.
ಮತ್ತೆ
It is page number 15, my lords.
Before partition it is granted land.
Compromise.
Yes, my lords. It is
ಕಾಂಪ್ರಮೈಸ್.
compromise.
ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಸೂಟ್ ಆಗ್ತಾರೆ 3 months ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್.
No, my lords. It is the suit was filed in the year 2023, compromised in the year 2024. my lords.
24 ಅದೆಷ್ಟು? ಯಾವಾಗ ಅದು ಫೈಲ್ ಆಗಿದೆ?
My lords, 14/3/24.
Now tell me madam, can you secure 11 sketch you will apply? Tell me what is the provision?
1 to 5 ಆದ್ಮೇಲೆ ಹಾಕ್ಕೊಡಿ. 1 to 5 it is under process. All government lands 1 to 5 it is under process. In a what food manner they are doing it.
You tell me what is the solution you tell. ಅದಕ್ಕೆ ಇದನ್ನ ಹೇಳ್ರಿ, ಇದು based on decree, if the names are mutated then they can obtain 11 sketch.
Single owner single ಇದ್ರೆ ನಾವು objection ಇಲ್ಲ.
No, you are not getting my point. In a partition suit, if there is a prelim decree and if it has attained finality, please reflect extent.
That we are trying.
ಅದನ್ನ ಮಾಡ್ಬಿಟ್ರೆ
In the RTC.
then they can seek 11 sketch. They have to seek 11 sketch.
I'll come back.
Don't allow them to sell unless they seek 11 sketch, but for entering name you should allow it.
My lords, one of the previous, your lordship only ordered, my lords, in that observation of made, when there is a decree like this, like.
ಇದು 19th ಹಾಕಿದೆ ನೋಡೋಣ, let madam seek instruction. They have
Yes,
their own
ma'am.
difficulties. ಇದು ಒಂದು 19th ಹಾಕ್ಬೋದಾ ಮೇಡಮ್? 19th ಏನು?
Extra
19
ಕೊಡಿ ಆರ್ಡರ್.
19 ಇದೆ. 19 ಇದೆ ಅಲ್ಲ 11 sketch.
ಮುಂದೆ ಹಾಕೋದಾದ್ರೆ ಡಿಸೈಡ್ ಆದ್ರೆ ಇದು.
ಆಯ್ತು ನೋಡಿ ನಿಮ್ಗೆ ಯಾವುದು ನೋಡೋಣ.
Yes, ma'am.
24 to.
Yes, 36.
36.
The case, my lord, where the demolition of the property of the petitioner was sought to be made by the respondent. My lord, what they did is, my lord, they give me a notice, Annexure G, page number 33.
Is it a fresh matter?
My lord, this was heard for some time, my lord, interim order has been granted.
ಅದು 194
194 or 195. Please see, my lord, Annexure G, page number 33. They allege that I am there in survey number 194. And they said that they called upon me, my lord, to make my reply. They said, come on 1/2/2025 at 11 o'clock. I went on 31/1 and gave them the reply. First, my lord, they started the demolition drive. Immediately, I moved my lordship and my lordship was pleased to protect me. My lord, I was called upon, my lord, to produce the document to show that I'm in 195. This property has been, my lord, subject matter of grant in favor of my father. Hakkupatra has been issued. Khatas, my lord, have been made out in my name. And hence, my lord, I got, my lord, the documents. The building license have been issued in my favor. My lord, the trade license have been issued by the concerned Gram Panchayat. And even, my lord, the sketch would show that I'm in survey number 195. That is what, my lord, is there on the record. Now, what is the report now they say is, you're not there in 194, you're there in 195, but even 195 is also a government land, and hence I want to take action against me. No, they're not sure about their own land. Now, the notice said 194. I now have all the documents to show that I am in 195. Now, they say that, no, you are in 195 only, there is no difficulty, but even 195 is the government land. Now, they keep on changing the case, and my lord, no notice, nothing. My lord, straight away they come and start demolishing. In fact, even when the interim order was directly dictated by my lord, they made a submission that it is already demolished. We took instructions and found out that it was still there. Fortunately, my lord, it is still there. Now, the whole difficulty is they can't take me for a ransom like this. Now, the Honorable Apex Court, my lord, has given the guidelines under Article 142, my lord. The entire country will have to follow it, my lord, is what has been said. I just pass it on. They don't just follow this judgment. Very recently, my lord, after the my lord, paragraph number 91, my lord. The detailed procedure that they need to follow, my lord, have been now specifically stated by the Honorable Apex Court. The directions, my lord, are there. From para 91.
Ah, 91 is not applicable. Para 91 is not
Yes.
applicable to it.
Yes,
There's a grant in your favor, sir.
there is a grant in my
In
favor.
survey number 195.
195.
That demolition drive is in respect of 194.
194. Now the report that they submitted before my lord on the previous occasion is to say that no, he's in 195 only, but even 195 is also a government land.
ಎಲ್ಲಿದೆ ಅದು?
ಅದೊಂದು report ಹಾಕಿದ್ದಾರೆ.
Oh, 195 is a totally different property.
It's a different property.
But ನಿಮ್ದೀಗ ಅದು ಫೋಟೋ ಅಲ್ಲಿ ರೋಡ್ ಬರ್ತಿರಲ್ಲ, ನಿಮ್ದು ರೋಡ್ ಇದೆಯಲ್ಲ.
ನನಗೆ road, but the other side of the
Other side.
one boundary of my property, my lord, is road. There is no difficulty. But I don't come in survey number 194 and I have sufficient documents to show it. Moment I, my lord, make all these documents available, they shift, my lord, their case.
In show cause notice, what they say?
194. Annexure G, my lord, page number 33. The allegation is that I am squatting over survey number 194. Line number.
They say that survey number 195 is a Sarkari Gomal land.
No, they say 195 is also Sarkari Gomal land and you are sitting over there. Now, the least thing that I have is, I have given the reply. They don't even consider it. Morning, they come over the property with the JCB and start demolition. That's where the Honorable Apex Court, my lord, has given the measures that have to be.
Where is the show cause notice?
My lord, page number 33, my lord, Annexure G.
30?
33, my lord. They say this, my lord. Malikaru Ramachandra bin Sampangaya, Edavanalli Grama Chiluru Dakle, Marulwadi Hubli.
Issue it on 1-2.
They say, come on 1/2/2025 at 11 o'clock, you come. This is what they
And this
say.
demolition drive, the drive is undertaken on what day?
On 1st of February itself.
Same day.
Same day. On 31st, my lord, I have given the reply because I thought that they would do something. One day prior in hand, I go and I make a reply and give them all the documents. Morning of 1st, my lord, they come with
But
it.
this is a show cause notice issued to you
Issued to me.
on 1-2.
No, this is, my lord, prior to it.
Allah, you were called
Date
upon
illa.
to be present on 1-2.
No, I was called upon, my lord, to come up with the documents on 1/2.
You have submitted all details on
Yes, my
previous
lord.
day.
On 31/1/2025, as per Annexure H, I have produced the document.
They issue a show cause notice indicating that you are in possession of 194.
194.
Yes, madam.
I inquired it about this anomaly, my lord. Instead of 195, they wrote common agi 194 is a gundu topo. So gundu topo, they cannot claim it. Anybody cannot claim on gundu topo. Gundu topo is situated in 194. Abutting to 194, 195 runs now. And they have been granted with 195 in this side, my lord. But they have occupied next to 194 illegally. That's why we have issued notice prior to demolition only we have issued notice now. And we have also got one directions from the Honorable Supreme Court wherein it clearly says, my lord, before parting with this case, we have directions to all the state governments in the country that they should prepare schemes for eviction of illegal unauthorized occupants of the Gram Sabha, Gram Panchayat, Karamboke, Shamat land, and these must be restored to the Gram Sabha, Gram Panchayat for the common use of villages of the village. For this purpose, the chief secretaries of all the state governments, union territories in India are directed to do the needful, taking the help of other senior officers of the government. The said scheme should provide for the speedy eviction of such illegal occupants after giving him a show cause notice and a brief hearing. Long duration of such illegal occupation or huge expenditure in making constructions thereon or political connections must not be treated as justification for condoning this illegal act for regularizing the illegal possession. We have also got so many instructions, directions from this honorable court.
ಅಲ್ರಿ ಒಂದು ಎಂಕ್ವೈರಿ ಮಾಡಿಲ್ಲ ಪ್ರಾಪರ್ ಆಗಿ 194 ಮಾಡ್ತೀರಾ ಈಗ ಬಂದು ಇಲ್ಲ 195 ಅಂತ ಏನಿದು ಹೈ ಹ್ಯಾಂಡೆಡ್ನೆಸ್ ಮೇಡಮ್
They have not been given that area, my lord. They have illegally occupied there.
ಎಲ್ಲಿದೆ ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ಏರಿಯಾ ಎಲ್ಲಿದೆ
ಅವ್ರು ಕೊಟ್ಟಿರೋದು sketch ಅಲ್ಲಿ 195
ಅಲ್ಲಲ್ಲ ನೀವು you showing
is also under dispute. They themselves says in the reply saying that OS is pending against the
Madam,
Gram Panchayat.
madam, you locate the portion which is granted to them. Show them where is that granted portion now. ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಎಲ್ಲ.
Because they themselves filed the reply.
No, very arbitrary, madam. You can't call on within a day. And you intend to vacate all. See, you made a statement on that day that
94
he is sitting over 194 ಅಂತ. ಈಗ ಬಂದು 195 ನಮ್ದೆ ಅಂತಂದ್ರೆ.
I rectified my, that day itself I made corrected my statement saying that ಅವ್ರ ಅಂಗಡಿ ಡೆಮಾಲಿಷ್ ಆಗಿಲ್ಲ ಅಂತ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಾನು ಬಂದು ಹೇಳಿದೆ. ಪಕ್ಕದ್ದೆಲ್ಲ ಅರ್ಧ ಡೆಮಾಲಿಷನ್ ಆಗಿದೆ. whichever the properties constructed on 194 ಗುಂಡು ತೋಪುನಲ್ಲಿ ಆಗಿದೆ. 195 ಇವ್ರದ್ದು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ನಾನು ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ. ಅವ್ರು ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 195 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಬೇಕಿತ್ತು.
ಇಲ್ಲ, the young man went out and called. He said that you had already made a submission that it's already demolished. It was not.
194 ಅಲ್ಲಿ ಇರೋದೆಲ್ಲ ಡೆಮಾಲಿಷನ್ ಮಾಡಿದ್ರು, ಅರ್ಧ ಏರಿಯಾ ಡೆಮಾಲಿಷ್ ಮಾಡಿದ್ರು. ನಾನ್ ಮತ್ತೆ ಕ್ರಾಸ್ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿ ನಾನೇ ಹೇಳ್ದೆ ಇದನ್ನ ಮಾಡಿಲ್ಲ ಇವ್ರದ್ದು ಬಿಕಾಸ್
No, this you can't apply. Here, there's a grant order. First, you show them where that granted portion falls.
Yes.
Without demarcating that portion, you can't initiate demolition drive. Adu trespasser gadu. You can do it without giving. Aurgu ಮಾಡಬೇಕಾದ್ರೆ ನೀವು ಟೈಮ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದು ದಿವಸ.
ಒಂದಿನ we have issued notice. ಅವ್ರು ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಷ್ಟೇ ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಹೇಳಿ ನನಗೆ ಪ್ಲೀಸ್ tell let me be told when they issued the notice, when I slept over the matter. Nothing.
Happened. I think I have produced that also.
Actually,
Paper ಲೆಲ್ಲ notice.
you want a disposal or we'll hear it leisurely, we'll hear it. B group ಅಲ್ಲಿ post ಮಾಡ್ತೀನಿ. But interim order granted early is extended till the date of hearing.
My lord, I will produce all the necessary documents to show
Prima
the dates
facie,
have been granted.
prima facie, this court is satisfied that the demolition drive undertaken by the respondents is not preceded by a proper inquiry and no reasonable opportunity is given to the petitioner. Time and again, Honorable Apex Court has consistently held that before authorities intend to take possession or demolish structures, sufficient opportunity should be given. In the case on hand, petitioner is served with notice on 31st.
2025, man. 31/1/2025.
31/1/2025,
My lord, I have been served on 29/1/2025.
29/1/2025, 25, and petitioner has rushed to the authority by filing a detailed representation, which is evidence at Annexure H,
Please, ma'am.
which is dated 31/1/2025.
Please, ma'am.
The impugned order at Annexure G pertains to survey number 194. While petitioner asserts that he is the owner pursuant to grant made by the authority in a portion of survey number 195, and that is running a hotel
Yes, ma'am.
business. On examining these relevant documents, this court is more than satisfied that respondents arbitrarily intend to take prescriptive action even against petitioner who is tracing his right based on a grant made by the authority. Petitioner cannot be treated as a trespasser and therefore matter requires consideration. Learned AGA to file statement of objection. Till then, authorities are directed not to precipitate the matter.
Then furnish all the relevant
I'll do
documents so that they
Right
are
now, I'll do.
granted with license and all.
Right now, I'll do.
Next,
Number 37, J.R. Mohan.
Petitioner in this case, madam. This is a fresh matter in which I have called into question the legality of the order dated 17th January 2025 passed by the first respondent deputy commissioner, whereby the deputy commissioner has directed his subordinates to mutate the names of the respondents in respect of the land which belong to me. My lord, I was in possession and enjoyment of an extent of 1 acre 9 guntas of land in certain number 64/1 of Rampura village, Kasba Hubli, Kanakpura Taluk, as a tenant under 1 Chennanke Gowda. I submitted my application for grant of occupancy rights, and proceeding was initiated before the Land Tribunal Kanakpura in case number LRF R2/7677. The Land Tribunal, after considering the genuineness of my case, was pleased to pass an order dated
based on what the deputy commissioner has ordered to mutate name of private respondents,
there is absolutely no basis, my lord.
you are tracing right through land tribunal order.
Yes, and Land Tribunal order in respect of one portion of property and in respect of another portion, I
Family
have
partition, family partition.
family oral partition in the year 1964. I acquired an extent of 1 acre 9 acres of land.
What is the rights of private respondents in the case?
They, my lord,
ಏನು?
they are the female children of the original
ಯಾರು?
my ancestor.
ಯಾರ್ದು legal heirs of?
Legal heads of one Shambulingaya alias Kullaya. Page number 30, my lord.
ಅವ್ರು ಯಾರು?
This is
How Shabulinga is related to it?
he was in possession and enjoyment of the land in survey number 64/1 to an extent of around 3 acres.
Madam, ಏನಿದು?
The DC has disposed of the order, while passing the order, he suggested that the civil court ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತೀರ್ಮಾನಿಸಿಕೊಂಡು
Yes, madam.
ಅಲ್ಲಿವರೆಗೂ ನಾವು ಜಾಯಿಂಟ್ ಖಾತಾದಲ್ಲಿ ಇರ್ತೀವಿ.
Yes.
ಜಾಯಿಂಟ್ ಖಾತೆ ಹೇಗಿರ್ತಾರೆ? ಅಲ್ಲ, you should have restored names in petitioner's favor and you should have relegated private respondents to approach trial court. Joint name ಹೆಂಗ್ ಬರುತ್ತೆ? ಅವ್ರದ್ದೇನಾದ್ರು ಬೇಕಲ್ಲ, ರೈಟ್ ಇದ್ರೆ ಜಾಯಿಂಟ್.
ಶಂಭುಲಿಂಗಯ್ಯನವರ ಹೆಸರಿಗೆ ಪುನಃ ಸ್ಥಾಪಿಸಬೇಕಾಗಿರುತ್ತೆ.
ಶಂಭು ಯಾರು?
Shambhulang is the original propositor of the family.
ಯಾವ ಫ್ಯಾಮಿಲಿನ?
ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮತ್ತೆ ದ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಫ್ಯಾಮಿಲಿ ಮೂಲಕರ್ತ ತಾತ ಮುತ್ತಾತದ ಹೆಸರಿಗೆ ಮ್ಯೂಟೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅವರು. 1% ಆಫ್ ಲ್ಯಾಂಡ್ ಮೆಜರಿಂಗ್ 1 ಎಕರ್ 9 ಗುಂಟಾಸ್ ನನಗೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಮತ್ತೆ ರಿಮೈನಿಂಗ್ 1 ಎಕರ್ 29 ಗುಂಟಾಸ್ ನನಗೆ ಆನ್ಸಿಸ್ಟರ್ ಪ್ರಾಪರ್ಟಿಯಾಗಿ ನನಗೆ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಬಂದಿದೆ. ILR ಮ್ಯೂಟೇಷನ್ ಎಲ್ಲ ಆಗಿದೆ ನನ್ನ ಹೆಸರಿಗೆ. 1 ಎಕರ್ 29 ಗುಂಟಾಸ್ಗೆ ಮ್ಯೂಟೇಷನ್ ಆಗಿದೆ. 1 ಎಕರ್ 6 ಗುಂಟಾಸ್ಗೆ 9 ಗುಂಟಾಸ್ಗೆ ನನಗೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ. ಟೋಟಲಿ ಐ ಆಮ್ ದ ಓನರ್ ಆಫ್ ಅರೌಂಡ್ 2 ಎಕರ್ 38 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್.
Failed to produce any of the partition deed, my lord. Based on oral partition, the DC has refused to accept the same.
ಅಲ್ಲ, ಅದು ಆಕ್ಟೆಡ್ ಅಪಾನ್ 1964 ಅಲ್ಲ, ಎಲ್ಲಿದೆ ಮ್ಯೂಟೇಷನ್ ಇರ್ಬೇಕಲ್ಲ ಅದು.
Oral partition ಮೇಲೆ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು. Oral partition
64 ಪಾರ್ಟಿಷನ್ ಅದು ಮ್ಯೂಟೇಷನ್ ಇರ್ಬೇಕಲ್ಲ. ವೆದರ್ ಮ್ಯೂಟೇಷನ್
ನನ್ನ ಹೆಸರು ನಮ್ಮ ತಂದೆ ಹೆಸರು ಮ್ಯೂಟೇಷನ್ ಇದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ page number 31, my lord. Page number 31. A typed copy is at page number 32. ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ಸರ್ವೆ ನಂಬರ್ 64/1ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಇಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಪೇಜ್ ನಂಬರ್ 33 ನಲ್ಲಿ ನಮ್ಮ ತಂದೆ ಹೆಸರು ತೋರಿಸುತ್ತೆ. ಹುಚ್ಚಯ್ಯ ಅಲಿಯಾಸ್ ಚಂದ್ರಯ್ಯ ಬಿನ್ ಶಂಭುಲಿಂಗಯ್ಯ.
ಪೇಜ್ 31 and 32.
ಆ ಟೈಪ್ಡ್ ಕಾಪಿಯಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 33. ಪೇಜ್ ನಂಬರ್ 33 ಇಲ್ಲಿ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ನಮ್ಮ ತಂದೆ ಹೆಸರು ಹುಚ್ಚಯ್ಯ ಉರುಫ್ ಚಂದ್ರಯ್ಯ ಬಿನ್ ಶಂಭುಲಿಂಗಯ್ಯ. ನನ್ನ ಹೆಸರಿಗೆ 1 ಎಕರೆ 27 ಗುಂಟೆ ತೋರಿಸ್ತಾರೆ ಸ್ವಾಮಿ. Ever since the date of partition, my father continued to be in continuous possession and enjoyment of this particular land.
The counsel for petitioner. He impugned order passed by first respondent deputy commissioner prima facie appears to be contrary to the family partition obtained by petitioner's father in 1964, and also occupancy rights granted by by land tribunal in favor of petitioner's father while order dated 3/2/1982. Ignoring these two significant details, Deputy Commissioner directed to restore the name of petitioners and private respondents and sister.
Yes, ma'am.
And sister. Civil code ಹೋಗಂತಾರ?
ಹೌದು ಸ್ವಾಮಿ, ಸಿವಿಲ್ ಕೋಡ್ ಹೋಗಿ ಬಗೆಹರಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ.
The second respondent has also directed the parties, has relegated the parties to work out their remedies before competent civil court. Matter requires consideration, bearing in mind that petitioner is asserting that his father's name was mutated by way of family partition effected in 1964 to an extent of 1 acre 29 guntas, while his petitioner's father acquired title to an extent of 1 acre 9 guntas based on a land tribunal order. Accordingly, order of the deputy commissioner annexure so is stayed till next date of hearing. London DGA is directed to accept notice to 1 to 3, issue notice to 4 to 12, 13.
Grateful.
38. Rajesh Gowda.
Stream
Yes, Rajesh Gowda.
annexure F, my lord. This stream over the survey number 73, the water flowing to the river. The survey sketch is categorically mentioned. But there is no.
For conducting survey, they participated in the survey and it has come to know that they have encroached.
On the X point ಅಲ್ಲ, X point ಅಲ್ಲಿ ಇದೆಯಲ್ಲ obstruction.
Portion purti, they have formed the road. State has not formed the road. Last occasion, they made statement that we are going to make road on the Rajakandi. It is they themselves have made the road. We have cleared that road. They have blocking the Rajakandi. That's why we have cleared. They have encroached 3 guntas of land.
ಯಾರು?
The petitioners.
If at all we would have encroachment, we will leave. Until there is a canal on the, what is a stream, my lord?
You're yourself guilty of
No.
violating the law.
We are not encroached anything. That is, my lord, here, this way also there is a canal.
Mr. Gowda, there is a report indicating that you have encroached.
Oh, this is not the report, the encroachment. They're saying that this canal is going. ಅದು ಕ್ಯಾನಲ್ ಹೋಗಿದೆ ಅಂತ ಹೇಳ್ತಾರದು ಅಷ್ಟೇ ಅದರಲ್ಲಿ. ಕೈಂಡ್ಲಿ ಸಿ ಕೃಷಿ ಮತ್ತು ರಸ್ತೆ 3 ಎಕರೆ 25 ಗುಂಟೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಿಸ್ ಇಸ್ ದಿ ವಾಟ್ ದೇ ಗಿವನ್ ನೌ. ದಿಸ್ ಒನ್ ಇಸ್ ಗೋಯಿಂಗ್ ಫಾರ್ ಕ್ಯಾನಲ್. ಸ್ಟ್ರೀಮ್ ಹೋಗ್ತಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿರೋದು. ದಿಸ್ ಇಸ್ ನಾಟ್ ಫಾರ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್. ದೇ ಇಶ್ಯೂಡ್ ಇಟ್. ಅದು ನಮ್ದಲ್ಲ 68/4 ಮೇಡಮ್, ಅದು ಸರ್ವೆ ನಂಬರ್ 68/4. ದಟ್ ಇಸ್ ವಿ ಆರ್ ನಾಟ್ ಎನ್ಕ್ರೋಚ್ಡ್ ಎನಿಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್. 73 acre 25 guntas for mine.
3 acre 25 guntas, it is encroached.
3 acre 25 guntas.
ಯಾರು ಸರ್ವೆ ನಂಬರ್ 73 ದಲ್ಲಿ
73 ಅಲ್ಲಿ we are in position 73, 92, 66, 78. They saying that, kindly see in the last bottom model 11, there are 4 survey numbers. 73, 92, 66, 78. That's saying, my lord, this canal is coming 73, 78, 92, 66. ಅದು ಅದ್ರ ಒಳಗಡೆ ಬರ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು ಹೊರತು ಇಟ್ಸ್ ನಾಟ್ ಎನ್ಕ್ರೋಚ್ಡ್.
ಒತ್ತುವರಿ ಅಂತ ಬರೀತಾರೆ ನೋಡ್ರಿ.
Sir, ಒತ್ತುವರಿ ಅಂತ ಬರ್ತದೆ 3 acre 25 guntas. How can we encroach? This is not the report of the, this is not the report on which they have been drawn. There is nothing is there. The note is not been issued. 3 acre 25 gunte ನಾವು ಎನ್ಕ್ರೋಚ್ ಮಾಡಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. We are owner of 2 acre 10 guntas. How can I encroach 3 acre 25 guntas, my lord?
Entire Rajakalu.
ನಾನೇನಾದ್ರು ರಾಜಕಾಲುವೆ ಉತ್ತೀರ್ಣ ಮಾಡ್ಕೊಂಡ್ರೆ right now I will leave, my lord. If at all any encroachment of the Rajakaluve, anything, they illegally trying to form the road on the Rajakaluve. That is my contention, my lord.
We are clearing the Rajakaluve.
ಅಲ್ಲ ಸ್ವಲ್ಪ ಇದರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಬೇಕಿಲ್ಲ ಎಲ್ಲೆಲ್ಲ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿ.
ಅಲ್ಲ ಇಲ್ಲಿ
ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ, ಪೂರ್ತಿ ಇದೆ ಏರಿಯಾ ಪೂರ್ತಿ.
that is the Rajakaluve, madam. Kindly see.
ಬ್ಲಾಕ್ ಮಾಡಿ ರೋಡ್ ಮಾಡಿದ್ರೆ that we have cleared it.
ಅದು ಏನ್ ಗ್ರೀನ್ ಕಲರ್ ಇದೆಯೋ that is the Rajakaluve, my lord. It is not encroached portion as claimed by the respondent, my lord. That is the Rajakaluve only. And also village map is also very clear. Village map ಅಲ್ಲಿ ಈ ಕಡೆ ಈಸ್ಟ್ ಮತ್ತೆ ವೆಸ್ಟ್ ಎರಡು ಕಡೆನೂ ರಾಜಕಾಲುವೆ ಬರುತ್ತೆ.
You file a counter to this.
Yes, my lord.
List it ಬರ್ಕೊಳ್ಳಿ. It on so and so date.
Interim order, ma'am.
Interim order granted earlier is extended till next date of hearing. However, petitioner shall counter the sketch furnished by Leonard AG indicating that it is the petitioner who has encroached over Rajakaluve.
Yes.
At his request, 2 weeks time is granted.
39, Jayakumar SC.
Date ಬೇಕಾಗಿ.
Date code. Yes, Vijay Kumar.
53.
I shall be the, Your Worship, in that there is no pathway in the survey number 10/16. 10/15 and 10/16 is the lands of the petitioner. That was that land was purchased by my father in the year 19.
ಬಂದಿದೆಯಾ ಏನಿದು?
ಹೌದು first time ಬಂದಿದೆ ಸ್ವಾಮಿ.
Yes, madam, seek instruction.
Worship, I am seeking interim order.
ಏನ್ entry ಮಾಡ್ರು Vijay Kumar?
ಆ road ಇದೆ ಅಂತ ಹೇಳಿ I filed appeal. The second respondent issued endorsement stating I have no jurisdiction to entertain the appeal. Your Worship, kindly see the annexure D, Your Worship. F, Your Worship. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಈ ಪ್ರಾಧಿಕಾರ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡದಿಲ್ಲದ ಕಾರಣ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡು ಇತ್ಯರ್ಥಪಡಿಸಲು ತಿಳಿಯುತ್ತಾ ನೀವುಗಳು ಸಲ್ಲಿಸಿರುವ ಮೇಲ್ಮನವಿಯನ್ನು ವಿಲೇಪಡಿಸಿದೆ. ದಟ್ ಐ ಫೈಲ್ಡ್ ರಿವಿಷನ್ ಬಿಫೋರ್ ದಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್. First respondent confirmed the order of the third respondent. There is no Bandidari itself. That is my case.
That is seek instruction.
They have created documents without issuing any notice. I have produced the document to show that without notice. So kindly say annexure D also. In that they have mentioned that they are Hanmantappa ಅಂತ ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಟೈಪ್ ಮಾಡಿದ್ದಾರೆ. ಹನುಮಂತಪ್ಪ ಅಂತ ಬಾಟಮ್ ಅಲ್ಲಿ. They claim that it is the sign of my brother. My brother is an illiterate. He is not putting any signature. On that basis, they are claiming that there is a Karab in their land and the pathway is going on our land. In the entire extent of 4 acres of land, there is no pathway in our land.
In the order, my lord, it is made an observation. Reclassification ದಾಖಲೆಗಳಲ್ಲೂ ಬಂದಿದ್ದಾರೆ. And ಗ್ರಾಮ ನಕಾಶೆಗಳಲ್ಲೂ ಬಂದಿದ್ದಾರೆ.
There is no pathway in the village map itself, Your Lordship.
ಎಲ್ಲಿದೆ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, I have produced before the second respondent, but he has not considered that.
ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು.
Pass the order.
ಅಲ್ಲ, ಸ್ಪರ್ಧೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲ, I have produced the document before the second respondent, bulk of document, but they have not considered nothing. He has given the endorsement that this authority has no jurisdiction. And basing on this order, the first respondent has mentioned that there is a kharab in the land of the petitioner. And that too, he says that in the year 1951, there is a kharab measurement, and at that time itself, the kharab is existent. While I am purchasing the land, there is no kharab in our land.
Okay, Kumar, the next day I'll consider it.
Please.
That is here to seek instruction in the matter. Relate this matter in preliminary on so and so.
25 to. So number 40, Vandana.
Lords, in respect of a converted land, an application seeking change of khata is filed on the basis of a will. The purchasers from the legal heirs of the so-called testator have filed their objections. The only course open for the Tahsildar in such circumstances is to direct the parties will have to be relegated to the civil court. Tahsildar presently has not passed an order, but once the objections are filed, he has posted the matter for inquiry. That cannot be done. It's a very recent judgment of the Supreme Court. May just pass it on. Copy. Kayali Baribati Memona. This is what the Supreme Court says. Organ copy. Notes paragraph number 5. Notes last about 6-7 lines, notes from the bottom in paragraph number 5.
Yes.
As per the settled proposition of law, if there is any dispute with respect to the title, and more particularly when the mutation entry is sought to be made on the basis of the will, party who is claiming title right on the basis of the will has to approach the appropriate civil court. That's.
Are you related?
Notes, I am the grandson and the notes the original grantee's son was in the military, so he died during the service. His widow and his son have sold the property in my favor. So even before the sale took place, they had filed an objection before the authorities. That's the Tahsildar saying that some fabricated documents are being projected by taking advantage of the absence of this deceased, and therefore it should not be
Filed
considered.
you have filed your objections.
Objections are filed.
I'll say that he has to strictly adhere to the principle laid on and full bench judgment tax set ಮಾಡ್ತಾ
But Jayamma's case also specifically deals with a very specific.
ಜಯಮಲ್ಲ ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ
Nagendra's case.
ನಾಗೇಂದ್ರ
Yes.
ಆಯ್ತು, ಈಗ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ,
ಅದಕ್ಕೆ
ಬರ್ಕೊಡ್ರಿ. All the learners in the council for the records, third respondent, Tahsildar, has issued notice to the parties since private respondents have set up a will. Respondent number 4 has set up a villa.
Yes.
ಇದೇನ ಅಶೋಕ್ ಕಾರ್ಪೊರೇಷನ್ ಅಂದ್ರೆ ಏನದು?
Lords, Ashok Corporation, what they say is,
ವಿಲ್ ಯಾರಿಗಿದೆ?
in the name of Ashok Corporation, they say that they have purchased the property by means of a will. That is their contention.
ಹೇಗ್ ಬರ್ದ್ರಿ? Has set up a will. Time and again, this court has taken a consistent view, citing the law laid down by the full bench in the case of C. Nagendra Singh, that a legatee cannot get his name mutated based on a will.
Lords, it's a converted property.
Ah,
It's a converted property.
oh, it's converted
It's
property.
a converted property.
All ಎಲ್ರು ಬಂದ್ರಲ್ಲ.
Now, the reason why I submitted converted properties, Tahsildar lacks jurisdiction.
Even otherwise, all right. One more crucial point that is raised by learned senior council is that in view of land being subjected to conversion falls beyond the authority of Tahsildar to hold an inquiry in respect of a converted land. Reliance is also placed on apex court judgment rendered in the case of Jitendra Singh. Having examined the records, this court is of the view the petitioner is entitled to some protection till next date of hearing. The proceedings pending before third respondent Tahsildar
Third respondent.
are stayed till next date of hearing. Learned AG is directed to accept notice to 1 to 3, issue emergency notice to R4.
Lots, great.
41.
Abit court.
Petition.
Yes, sir. Dimagowda.
My grandmother purchased the property bearing survey number 577 in the year 1953, my lord. My lord, thereafter, the revenue entries are entered in the name of my grandmother. But my lord, some circumstances, the respondent number 6, they are sold the property in favor of vendor of my grandmother, enter the revenue entries in the name of respondent number 6, my lord. Thereafter, I approached the assistant commissioner.
Wait. Now revision is allowed.
Revision is allowed.
Revision, why? According to you, they have no right in
They have
surrender.
no right to challenge the order passed by the assistant commissioner. They are not parties.
Your case is for, your right is in 577/1.
One is correct.
Who are they? Private respondents, over here.
They are claiming 577/2 minute. 577 is entirely different property,
Because it
577.
has undergone 4D.
Undergone 40, they have obtained the conversion order also, 577/2. They are challenged the order, they are not parties before the assistant commissioner. I have not sought for any relief against the respondent number 7 and 8. Even in spite of the same, my lord, deputy commissioner consider their.
Allah, they are tracing right in 577/2.
577/2.
They have any right? They have it in 577/2.
577/2 only, my lord. My right is
Not in
not
577.
71.
ನಿಮ್ದು ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ನಿಮ್ದಾ 577?
1 ಎಕರೆ 1 ಗುಂಟೆ ನಮ್ಮದು ಸರ್.
ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ರಿಮೈನಿಂಗ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆಯಾ?
ರಿಮೈನಿಂಗ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಲ್ಲ ಸೇಲ್ ಆಗಿದೆ, ಬೇರೆ ಇದಾರೆ ಸರ್. ನಮ್ದು ಓನ್ಲಿ 1 ಎಕರ್ 1 ಗುಂಟ. There 20 guntas is also in 577/2 ಮೇಲೆ.
2 only.
2 only. In respect of that, I have produced their own sale deeds also, my lord, before.
Recorded. Though private respondents sale deed pertain to survey number 577/2, they have approached the second respondent deputy commissioner by way of revision,
Yes, ma'am.
and this revision is allowed. Petitioner's grievance is that second respondent deputy commissioner has not adverted to the title documents of respondents 7 and 8, which relate to 577/2.
Correct.
While petitioners are owners in survey number 577/1. Records prima facie reveal that 577 has undergone 4D, and petitioners the portion purchased by petitioners grandmother is assigned new sub-survey number as survey number 577/1.
Yes.
Matter therefore requires consideration. Order of the second respondent deputy commissioner is stayed till next date of hearing. SCGP accepts notice to 1 to 5. Issue emergency notice to 6 to 8.
Much.
42. Sarvana? Yes, Ravi Shankar.
2012, the panchayat grants a property saying it's a Gram Thana. Lord's temple is constructed. Then in a very adjacent property, CL7 license is applied for. That is opposed to, saying that there is an existing temple. Lords, then the political will comes in. The Tahsildar springs into action and says that he wants to see whether this property is situated in the property of Gram Thana or Oni. Lords, then they covered the entire property by using polythene sheets. At that time, we approached this honorable court in earlier instance. Said that they have not even issued a notice, they have covered everything. They will have to hold an inquiry and to find out whether it is there or not. So this honorable court directed the Tahsildar, you dispassionately, without getting into all these things, because there is a CL7, a very politically influential person is there. So dispassionately, you please decide the matter. And also directed that after he passes an order for 4 weeks, this order should not be given effect. Now the Tahsildar called upon me to file my objections. They conducted survey. In the survey, they wanted to say that this is an unsurveyed portion which is not assigned with any number. Therefore, it is a ONI. That's an assumption with which they went. So what I said is, both sides of this property, which is about 14 feet in width, is my personal property. Instead of you going straight, you take 30 feet of my property on either of the sides, you deviate it so that the temple remains. That is the objection which I filed. I also said, please don't get influenced by the fact that there is a CL7 license, because the whole object of shifting the temple is to ensure that CL7 license comes in place in the place where they have applied for. Lords, may kindly see notes the orders which is passed by the Tahsildar at page 57 while noting my contentions. Lords, last paragraph in page 57. Sadri notice ge Arun Kumar bin Krishnapar avaru 9/12/24 ತಮ್ಮ ಲಿಖಿತ ಸಂಜಾಯಿಷನ್ನು ನೀಡಿ ತಮ್ಮ ನೋಟಿಸ್ನಲ್ಲಿ ಹೇಳಿರುವಂತೆ ಯಾವುದೇ ರೀತಿಯಾದಂಥ ಕಂದಾಯ ಇಲಾಖೆಯ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಗುಂಡೇನಹಳ್ಳಿ ಗ್ರಾಮದ ನಕಾಶೆ ಕಂಡು ಬಂದ ಓಣಿ ಮಾರ್ಗವನ್ನು ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಓಣಿ ಸರ್ವೆ ನಂಬರ್ 75 ಮತ್ತು 77ರ ಮಧ್ಯಭಾಗದಲ್ಲಿ ಹಾದು ಹೋಗಿ ಮುಂದಿನ ಜಮೀನುಗಳಿಗೆ ಹಾದು ಹೋಗುವಂತೆ ಉಪಯೋಗಿಸುತ್ತಿದ್ದೇವೆ ಹಾಗೂ ಸದರಿ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿ ಅನಾದಿ ಕಾಲದಿಂದಲೂ ರಾಮ ಆಂಜನೇಯ ಸ್ವಾಮಿ ವಿಗ್ರಹವನ್ನು ಪೂಜಿಸುತ್ತಿರುತ್ತೇವೆ ಹಾಗೂ ರಾಮ ಮತ್ತು ಆಂಜನೇಯ ಸ್ವಾಮಿ ವಿಗ್ರಹಗಳಿಗೆ ತಾತ್ಕಾಲಿಕ ಶೆಡ್ ನಿರ್ಮಿಸಿರುತ್ತಾರೆ. ಈ ವಿಷಯವಾಗಿ ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ದೇವಸ್ಥಾನ ನಿರ್ಮಾಣ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ತಾಲೂಕ್ ಪಂಚಾಯಿತಿ ಸಭೆಯ ನಿವೇಶನ ಮಂಜೂರಿ ಮಾಡಲು 12/10/24 ಸರ್ವಾನುಮತದ ಅಂಗೀಕಾರ ಮಾಡಿರುತ್ತಾರೆ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ದೇವಸ್ಥಾನದ ಅಭಿವೃದ್ಧಿ ನಿರ್ಮಾಣ ಕಾರ್ಯವನ್ನು ನಡೆಸಲು 10/7/2013 ಅನುಮತಿ ಸಹ ನೀಡಿರುತ್ತಾರೆ. That date is 12/10/2012, not 24. I produced at annexure B. ಕಲ್ಲುಘಟ್ಟ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ಖಾತೆ ನಂಬರ್ ಸೋನ್ಸೋ ಆಗಿರುತ್ತದೆ. ಸದರಿ ದೇವಸ್ಥಾನವು ತನ್ನ ವೈಯಕ್ತಿಕ ವಿಚಾರ ಸಂಬಂಧಿಸಿದ್ದಲ್ಲ. ದೇವಸ್ಥಾನದ ಕಟ್ಟಡವು ನಿರ್ಮಾಣವಾಗಿರುವುದಿಲ್ಲ. ಗ್ರಾಮಸ್ಥರ ಹಿತಾಸಕ್ತಿ ಚಿಕ್ಕ ಗುಡಿಯ ದೇವಸ್ಥಾನವು ಚಿಕ್ಕ ಗುಡಿಯಾಗಿ ನಿರ್ಮಾಣವಾಗಿರುತ್ತದೆ. ಸದರಿ ದೇವಸ್ಥಾನ ಹೆಸರಿನಲ್ಲಿ ಟ್ರಸ್ಟ್ ಸಹ ನೋಂದಣಿಯಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿಷಯವು ಆಗಿರುವ ಸುಮಾರು 2-3 ತಿಂಗಳ ಹಿಂದೆ ಮಯೂರ ಗ್ರೂಪ್ನವರು ಸದರಿ ದೇವಾಲಯದ ಪಕ್ಕದಲ್ಲಿ CL7 ಎಂಬ ಮದ್ಯದ ಅಂಗಡಿ ತೆರೆಯಲು ತೊಡಕಾಗುತ್ತದೆ ಎಂಬ ದುರುದ್ದೇಶದಿಂದ ಹಾಗೂ ರಾಜಕೀಯ ಒತ್ತಡದಿಂದ ದೇವಸ್ಥಾನವನ್ನು ತೆರವುಗೊಳಿಸುವ ಉದ್ದೇಶದಿಂದ ಅರ್ಜಿಯನ್ನು ನೀಡುತ್ತಾರೆ. ಸದರಿ ದೇವಸ್ಥಾನದ ಖಾತೆಯ ವಿಚಾರವಾಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ 90 ಮಧ್ಯಂತರ ಆದೇಶವನ್ನು ಸಹ ನೀಡಿರುತ್ತದೆ. ನಾನು ಯಾವುದೇ ಸರ್ಕಾರಿ ಜಮೀನಾಗಲಿ ರಸ್ತೆಯನ್ನಾಗಲಿ ಒತ್ತುವರಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸದರಿ ನೋಟಿಸ್ ವಜಾಕರಿಸಿ ಕಾರ್ಯವನ್ನು ಮಾಡಲು ಅನುವು ಮಾಡಿಕೊಡಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ. ಮುಂದುವರೆದು ಭವಿಷ್ಯದಲ್ಲಿ ಮೋಜಣಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಒಂದು ವೇಳೆ ದೇವಸ್ಥಾನ ಇರುವಂತಹ ಜಾಗವು ಓಣಿ ಮಾರ್ಗಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತೆ ಅಥವಾ ಓಣಿ ಮಾರ್ಗದಲ್ಲಿಯೇ ನಿರ್ಮಿಸಿದ್ದರೆ ಸದರಿ ಓಣಿ ಮಾರ್ಗಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತೆ ಇರುವ ಶುದ್ಧ ಕ್ರಯಪತ್ರ ಪಡೆದ ನನ್ನ ಮಾಲೀಕತ್ವದಲ್ಲಿ ಇರುವಂತಹ 75/2 ಭೂ ಪರಿವರ್ತನೆಗೊಂಡಿದ್ದು ಸದರಿ ವಿವಾದಿತ ಓಣಿಯಲ್ಲಿರುವ ದೇವಸ್ಥಾನ ವಿಸ್ತೀರ್ಣವನ್ನು ನನ್ನ ಸ್ವತ್ತಿನಲ್ಲಿ ಸಿದ್ಧನಿರುತ್ತೇನೆ ಹಾಗೂ ಸದರಿ ಓಣಿಗೆ ಹೊಂದಿಕೊಂಡಿರುವಂತಹ 76/5 76/3 ಎರಡೂ ಸ್ವತ್ತುಗಳು ಸಹ ನನ್ನ ಮಾಲೀಕತ್ವದ ಒಳಪಟ್ಟಿರುವ ಸದರಿ ಓಣಿ ಪ್ರದೇಶಕ್ಕೆ ಸರ್ಕಾರ ವಿಧಿಸಬಹುದಾದ ಮೌಲ್ಯವನ್ನು ಭರಿಸುವುದಾಗಿ ನಾನು ಕೋರಿರುತ್ತೇನೆ. After all these things, it doesn't take any of these contentions into consideration because there is an existing temple. The whole object is to ensure, that if the temple is dismantled, CL7 license comes. There is another writ petition which is filed.
Temple is in existence.
Temple is in existence. Kindly, Lordships may kindly see the orders passed in the previous occasion. This is at page number 39, page number 43 minutes. Sorry. Page number 44, para 5. This is the reason why we came before the court. Para 5. The Learned Senior Counsel proposed to contend that the reasons assigned today to justify wrapping of the premises to prevent desecration of the idols is an afterthought. ಅದು ನಾವಲ್ಲಿ ಎಲ್ಲ ಐಡಲ್ಸ್ ಎಲ್ಲ ಇದೆ, ಎಲ್ಲ ಡಿಸಿಕ್ರೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅಂತ ನಾವು ಪ್ಯಾಲಿಥಿನ್ ಶೀಟ್ಸ್ ಹಾಕಿ ವ್ರಾಪ್ ಮಾಡಿದೀವಿ ಅಂತ ಕಂಟೆನ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ವಿ. Even para 4, it says that CL7 is the neighboring property they have applied. Para 4, it's extracted. CL7 license ಗೆ ಅನುವು ಮಾಡ್ಕೊಡ್ಬೇಕು, ದೇವಸ್ಥಾನನೇ ಮುಂದಕ್ಕೆ ಹಾಕ್ಬಿಡ್ತು.
What is it now, challenge now?
Not the order is passed by the Tahsildar saying that this is constructed on the ONI, therefore it should be demolished. The order is of demolition.
Yes, Manjunath, speak and say. Not to precipitate, at least till next date of hearing.
Lordships had given directions in the previous matter to maintain status quo as it exists today, page 46, para 8.
Yeah.
Yes, page 46, para 8. And then at page 47, the court has directed that this should be continued for a period of 4 weeks so that they will not precipitate the matter immediately.
Of the letter city council appearing for petitioner. What is the records? The respondents have undertaken prescriptive action to demolish an existing temple on the premises that it is located on
ONI.
On the ONI. At a request consideration, the CGP shall secure instructions and place on record the relevant documents justifying its action. Till then, respondents are hereby directed not to precipitate any further till next date of hearing.
Lordships.
Yes, next.
Orders matter. So number 43, Gangadhar JD.
Yes, sir.
Your Lordship, I filed an application for LRs in the year 23 itself. There are two sons of 3A.
ಏನಾಗಬೇಕೀಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಏನಿದೆ?
ಅಲ್ಲ, ಒಬ್ಬರಿಗೆ ಸರ್ವಿಸ್ ಆಗುತ್ತೆ ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ, ಇನ್ನೊಬ್ಬರಿಗೆ ವೇಕೆಂಟ್ ಸೈಟ್ ಅಂತ ಬರ್ತದೆ. ಥರ್ಡ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ನೋಟಿಸ್ ವಾಸ್ ಸರ್ವ್ಡ್.
Effective service ತಗೊಂಡಿದ್ದೀರಾ? ನೋಡ್ರಿ 3 times ಆಗಿದೆ.
3 times notice issued and answer
ಆಗಿದ್ಯಾ?
paper publication.
ಈಗ ಹಾಕಿದಿರ ಪೇಪರ್?
ಇಲ್ಲ, ಹಾಕ್ತೀನಿ.
ಹಾಕಿ. Alright. A week's time.
Substitute.
ಹಾಕಿ. Please. Adjourn by 1 week. Next.
44, Abdullah.
Yes. Sole petitioner.
No, not sole petitioner, Your Lordship. There are 3 petitioners originally. Petitioner number 1, Audrey Rodriguez, has passed away in
So
2024.
2 to 4 are the legal heirs.
Yes, Your Lordship. And I have made an application to have 2 additional children of hers brought on record as legal heirs. So the application, Your Lordship, will have for a moment.
I 1 of 24.
Yes, Your Lordship.
They are pertaining to LRs of R1.
Yes, Your Lordship.
You have to take notice there.
No, Your Lordship.
ಅಲ್ಲಲ್ಲ R1 ಅಂತ ಬರೆದಿದ್ದಾರೆ. P1 ಅದು.
P1. Alan Rodriguez and Pamela Mandre can be taken.
Barcode. A memo is filed indicating that petitioners, first petitioners have died and petitioners 2 to 4 are legal heirs of petitioner number 1. An application is also filed to bring the other surviving class 1 heirs.
Yes,
of
Your
this is petitioner number 1. Memo is taken on record. petitioners 2 to 4 are treated as the last. Further, having examined the amendments made in I-1 of 24, this court is of the view that the proposed laws of first petitioner, as indicated in I-1 of 24, are also entitled to come on record and contest the petition. I-1 of 24 is accordingly allowed. Petitioner shall forthwith carry out amendment physically. While amended constituted, 2 weeks time is granted.
Your Lordship, I have one submission. So 2016 matter pertaining to timber grown in Coorg. And there is a decision of this honorable court which says that the Coorg land tenures after the promulgation of the Karnataka Land Revenue Act have become non-operable and have been repealed. Now the timber's value has been deposited with the Forest Department on the basis of.
Or at least listed in B group on so date. Next.
Would I request a specific date?
Yes, you'll get the date. Next.
12-3. Cell number 45.
Paper publication.
R5, S. Ramalingam. R12, Sina. R13, HM Prakash Reddy. R14B, Manjula.
Petitioner in compliance of steps having been taken by way of substitute service. 2 sets of copies are furnished. The unserved respondents who are notified by way of paper publication are called out. Service is held sufficient. Registry to print their names.
Any date may kindly
be fixed.
2021. I thought it listed in B group and so date. Yes.
Cell number 46.
Interim order may kindly be
Extended interim order, if any, is extended till next date of it.
May I request even the previous matter of interim order?
In the previous material interim order, if any, is extended till next date.
46.
46.
My lord, appearing for the petitioner, on 3rd September only we have taken steps, my lord. Notice, issue notice to our tenant, we have taken steps on that day.
Needful done, huh?
Needful done, my lord.
May I make a submission? In serial number 46, your lordship, I appeal for respondent 5 to 9. The main ground which the petitioners have raised is that the respondent number 3, before whom the respondents 5 to 9 had preferred appeal, has not passed any orders on the condemnation of delay application. If that is the case, this matter may be allowed and remanded back to respondent number 3. Because since he has not passed on the application of condemnation of.
But at 2:30 will pass orders.
My lord, clearly a week's time maybe, my senior will submit on the merits, my lord. Tomorrow, maybe kindly tomorrow, my lord.
He is conceding, he wants your writ to be allowed and you want an adjournment.
No, my senior wants to submit on this, my lord. It's to.
Or at least this matter in preliminary on so and so date. That is, since counsel appearing for respondent is willing to concede the prayer sought in the petition.
My lord.
And further has no objection if the matter is remitted back to the authority. Yes.
Interim order make.
Yes, ಅದೇ ಮೊದಲು interim order ಮಾತ್ರ ಬೇಕಾಗಿದೆ. Interim order granted is extended till next date of hearing.
47, Shindra Singh.
I appear for petitioner, please, your lordship. Your lordship, I have complied with the office objections, please, your lordship. The RTCs of the digitally signed copies have been produced, your lordship. The office is seeking for the certified copies. Lordship may kindly dispense it, please, your lordship.
Office objection is overruled by accepting the council submission. List this matter in preliminary on so.
Grateful, your lordship.
18-2.
Grateful, your lordship. Date may kindly be fixed, please, your lordship.
18-2.
Date quoted.
For petitioner.
Grateful, your lordship.
48.
This matter is concerned, Lords, I appear for Hansavan and Lords Illas of Array. Lord, considering my submission that my application for vacating stay is pending. The Lordships on 3/8, my Lords, 3/8
ಅಲ್ಲ ಇದು ಇನ್ನೂ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
ನಾನು ಆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದಾಗ್ಲೇ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಗೆ ಅಂತ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಮತ್ತೆ ಅದು ನೋಟಿಸ್ ಹೋಗಿ
ಆಯ್ತು ನೋಡೋಣ ಮತ್ತೆ ನೋಡೋಣ ಪಾಸ್ವರ್ಡ್ ನೆಕ್ಸ್ಟ್.
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಇಬ್ಬರಿಗೆ ಅನ್ಸರ್ಡ್ ಅಂತ ಬಂದ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ದೇ ಆರ್ ಆಲ್ಸೋ ಕಂಟೆಸ್ಟಿಂಗ್ ಎನಿ ಡೇಟ್ ಮೇ.
ನಾನೇ ಕಂಟೆಸ್ಟಿಂಗ್ ಪಾರ್ಟಿ. ಐ ಹ್ಯಾವ್ ಲಾರ್ಡ್ಸ್ ಐ ಹ್ಯಾವ್ ಎಂಟರ್ಡ್ ಅಪಿಯರೆನ್ಸ್.
ಇದ್ರಲ್ಲಿ ಎಲ್ಲರನ್ನು ಪರ್ಚೇಸ್ ಮಾಡಿರುವಂತ ಸಮಯ ಏನಾಗಿದೆ ಎಕ್ಸ್ಟೆಂಟ್ ಕಮ್ಮಿ ಆಗ್ತಾ ಬಂದಿದೆ.
ಈಗ ನೀವು ಸ್ಟೇ ತಗೊಂಡಿದ್ದೀರಾ, ನಿಮ್ಗೆ ಪ್ರಿಲಿಮಿನರಿ ಬೇಡ ಆಗಿದೆ. ಪ್ರಿಲಿಮಿನರಿ ಬೇಡಲ್ಲ, ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದು ಬೇಡ. ವಿಲ್ ಲಿಸ್ಟ್ ಇಟ್ ಬಿ ಗ್ರೂಪ್.
ಅಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್
ಸ್ಟೇ ಬೇಡ.
ಅಲ್ಲ ಬೇಕು
ಇಲ್ಲ ಮತ್ತೆ ಪ್ರಿಲಿಮಿನರಿಗೆ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದೀರಲ್ಲ.
ಅಲ್ಲ ಸರ್ ನಾವು ಅಪೋಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆ ಅಂತ. ಮಾಡಬಾರ್ದು ಅದು. ಲಿಸ್ಟ್ ಇಟ್ ಪ್ರಿಲಿಮಿನರಿ.
interim order. Maybe.
Interim order granted earlier is extended.
27.
49.
For the petitioner, 79 AB matter, your lordship. The only objection by the office, your lordship, production of ration card, identity card.
Date of order, you know.
Date of order 5/1/2016, your lordship. Similar matters has been tried by the Honorable Court. Your lordship has been tried that.
Is it without notice to you?
ಹೌದೌದು ನೋಟಿಸ್ ಬಂದಿಲ್ಲ ಏನಿಲ್ಲ I have a copy of the order sheet also.
Order ಮಾಡ್ತೀರಾ ಸರ್ ಹೋಗ್ಬೇಕಲ್ಲ ಅದು.
Similar cases have been granted by this honorable.
ಅದೇ similar case interim order.
ಅಲ್ಲಲ್ಲ, that's what your lordship has been granted then.
Prima facie, this court is of the view that inquiry undertaken by Assistant Commissioner under section 79 E and B appears to be in gross violation of principles of natural justice. Without asserting as to whether notice are served on petitioner, inquiry is concluded and sale deeds obtained by petitioner are nullified. Matter requires consideration. Accordingly, it will order passed by
Yes, Assistant Commissioner.
so and so as per annexure
Annexure
D.
G,
is stayed pending consideration of the caption petition listed in B group. Next. P. Urgency or will list it in preliminary, sir? Can I list it in preliminary?
ಆಗ್ಬೋದು.
Office objection ಏನಿದೆ ಅದು?
Only to that ನನ್ನ ವೆಂಡರ್ ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅನ್ನೋದಷ್ಟೇ.
Council submission is accepted, office objection is overruled, list it in preliminary on so and so date. In land reforms matter,
17 NB violations ಆಗಿದೆ. Earlier to my purchase, property has been converted for which.
converted,
Converted. That is annexure is page number 73.
as in the date of inquiry, it was already converted.
Converted. 2013 ಅಲ್ಲೇ conversions ಆಗಿದೆ.
Have the counsel for petitioner?
ಇಲ್ಲ.
Page number 73.
Kindly peruse page number 73.
ಅದಕ್ಕೆ ಇದೆಯಾ conversion order ಇದೆ?
Along with that.
Have the counsel for petitioner peruse the records as the date of inquiry initiated by Assistant Commissioner.
ನನ್ನ ವೆಂಡರ್ಗೆನೆ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ.
Under section 79 E and B, petitioners erstwhile vendor had secured a conversion order. If that is so, the order under challenge requires consideration in the light of law laid down by the full bench of this court while answering reference in WP number so and so. Learned AGA is directed to accept notice since matter prima facie is squarely covered by the judgment rendered by this court. Really, this matter preliminary on so and so date. Till then, order is stayed.
25. Great.
Madam, please examine. Next.
51.
Lord, I am for the, Lord, 74 partition deed is produced, my Lord. And it is Kannada, the re-Kannada, ಮತ್ತೆ ಕನ್ನಡದಲ್ಲಿ ಟೈಪ್ ಮಾಡಿ ಹಾಕಿದ್ವಿ, ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದ್ವಿ.
Yeah.
Mandamus ಅದು, writ of Mandamus, I sought for a survey of the land.
Agidya, council submission is accepted, office objection is overruled. List this matter in preliminary on short date court.
Short date tomorrow.
Yes, sir.
18 to
18.
Please.
52.
52.
For the petition, my lord. Lord, two parties who were before the AC were not arrayed as parties before the DC. We have arrayed only those parties who are before
ಯಾರ
the
appeal
DC.
ನಿಮ್ಮ appeal ಇರ್ಲಿಲ್ಲ ಅದು.
Appeal ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ.
That appeal was not by you.
Both the appeals were by me. Before the AC also by me, before the DC also by me. Challenge to the mutation proceeding.
Why did you leave out some of the parties?
Lord, somehow before the DC, they had left it out.
We'll do one thing. Let this matter in preliminary along with office objection on. We'll examine on.
19. Very well. 3.
ಏನಿದು? Yes, government ಏನ್ರಿ ಇದು? Delay will allow, will condone delay. Yes, sir. Your objection for delay what?
No. We will file it, my lordship, short date. We will file the objections.
For
Kindly.
delay also?
No,
You want to
this
file?
short date, my lordship.
ಏನ್ ನೀವು ಅಥಾರಿಟಿಗಾ? ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿನಾ?
Yes.
ನಾಳೆ ನಿಮ್ದು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಬಂದ್ರೆ ಡಿಲೇಗೆ ಅಬ್ಜೆಕ್ಷನ್. Don't ಬರ್ಕೊಳ್ರಿ. A week's time to file objection to delay application.
54. Jagdish Baliga.
Respondent number 2, my lord. In this matter, my lord.
All that will condone delay and list it in admission.
What?
Will condone delay and list it in admission.
Okay.
And then we'll dismiss his review petition.
Yes.
Quashone is accepted. Passed on is accepted, delay of 80 days in filing new petition is condoned. Let this matter in admission on so and so date.
Yes.
Next,
55. Hey, Ramesh.
Leading applicant.
ಇದು ನೋಡೋಣ some other day. Some other day. 2022 matter, ಕೊಡ್ರಿ date ಕೊಡ್ರಿ.
53.
Alright, next.
Like interim order may be extended.
Extended, interim order extended, next. 56.
53.
56.
6.
What is this correction?
For the petitioner, my lords, R2 and R3 have filed the correction. We haven't been served a copy.
Any clerical mistakes?
No, I'm not too sure, my lords. It was allowed in our favor. They filed the correction. We haven't been given a copy yet. The direct.
Copy is not served on you. ಉತ್ತರ ಕರೀರಿ ಬೇಕಾದ್ರೆ.
56, 57.
ಅದೇನದು ಸ್ಟೇ ಪ್ರೈಮಟ್ರಿ ಇದೆ ಅದು ಹೋಟೆಲ್ ಮೂಡ್ ಅದೇನ್ ನೋಡ್ರಿ.
50 gunters of land has
ಆ
50 gunters of land has been reserved for graveyard or grass which has been.
ಚಂದ್ರಚೂಡ್ ಏನ್ರಿ ಹ್ಯಾವ್ ಲಂಚ್ ಅಂಡ್ ಕಮ್ ಬ್ಯಾಕ್.
Yes, I'll be back.
Fifty-four into 24.
ಬೇಗ ಹೋಗ್ಬೇಕು. 11, 27 to.
46.
ಆಯ್ತು ರೀ 46 ಇಂಟ್ರಿ
Serial number 22, sir.
ಹಾ?
Serial number 22.
ಅಲ್ಲ ಇದ್ರದ್ದು WP ಯಾವ್ದು ಹೇಳಿದ್ರಿ ತಗೊಳ್ಳಿ ಅಲ್ಲ
The council appearing for petitioner shall furnish details in regard to entitlement of salary on parity to report settlement by next date of hearing. ಎಲ್ಲ ಮಾತಾಡ್ಕೋಬೇಕು ನೀವು ಇಲ್ಲೇ ಬಂದೆಲ್ಲ ಮಾಡಂಗಿಲ್ಲ ಸುಬ್ರಹ್ಮಣ್ಯ.
ಇಲ್ಲ,
ಇದು ಸುಮ್ನೆ ಹಿಂಗೆ ನೋಡಿ ಇದು.
I didn't have the communication, my lord. Just now I received it. That is why, my lord, I am. Otherwise, I would have.
Tell your management that is giving up 50% back wages.
Please. Lord.
Yes, next.
Lord, 17th, I have some difficulty.
So some other date.
Please. Thursday. Next Thursday.
Yes, next.
Appear for petitioners.
Yes, madam. Where is your colleague on record? Why she is not
Procedural.
appearing?
Issue is regarding whether the regrant of land is to the tenant, whether at all he was tenant, and whether the land tribunal had jurisdiction to grant this land. Lord, I made some small synopsis.
Yes, ma'am.
Dates only. Lord, from serial number 3, I would like to read.
Yes.
There was a notified land. Lord, as I say, 1/7/1970, as per the tribunal order, is a date of vesting. And nothing is shown that whether this land really stood vested, because they're already notified. So there was no vesting according to us. I will show that, Lord. Then, my lord, 17/3/1971, after the date delay application is filed by the applicant saying that he is working, he is cultivating land since 8 years. That is from 1963. And my lord, and he also says that the said land is Devadaya Inam land. Lord, 7/2/1974, the government, my lord, make a physical transfer of all these properties along with this survey number also from the Mujrai department to the board. But 1980, DC transfers this case to land tribunal. And 82, there's a first grant order by land tribunal under the Religious Inams Abolition Act. Now, this is important because earlier the grant was Religious Inams Abolition Act. Application is also under Religious Inams Abolition Act. Why I say so is, thereafter, my lord, writ petition was filed questioning this order of grant, and my lord, it was remanded. Now, after 14 years, land tribunal without jurisdiction. If it is Religious Inams Abolition Act, it should be DC who should do the grant and not the land tribunal. So after 14 years, my lord, land tribunal now has given re-grant. That is what is questioned in this writ petition. And there is one more connected petition, my lord, where we had taken a action under 54, and that order is there. Once I finish this, my lord, I will show the other. But my first contention is, what is the nature of this land? Your Lordship will see Inams Abolition Act alli, section 3, it very clearly says, it's a Devadaya Inam. If the quitrent register shows Devadaya, Lordships has a religious charitable.
Yes.
A religious charitable Inams Act, section 1, my lord.
Yes.
Religious inams or charitable inams means a grant of a village or a portion of a village or land entered in the register of inams or in the quitrent registered or any other revenue record as Devadaya or Dharmadaya. Now, the tribunal says the entry here is Kazi service Devadaya anta ide anta tribunal has given a finding.
Yes.
Now, since we are on the Inams Act, I request my lords also to see the explanation of Inam in the personal Inams. Personal Inams alli is a Inam which is granted to an individual. Personal Inams alli. And under miscellaneous Inam, Kazi Inam is not there.
Yes.
So, my lord, it is my humble submission that prior to the vesting itself, 1968, when the notification under Section 5 is issued, it is a religious Inam. So, two applicants have filed application. One is the Qazi, the family of the Qazi, and the respondent here now. They showed, both of them showed board as the Inamdar. Once they have shown board as the Inamdar, board can only hold religious properties. It can't hold any other. So this has to be a religious Inams Act. And therefore, my first contention is grant by land tribunal is basically without jurisdiction. Idralli explanation Qazi service Inam Barodel. And the quit rent register very clearly uses the word Devadaya. And there is a notification under 5, which is religious and pious lands are taken.
All right, if it is if you admit that it is Inam land.
You know, that next I'm coming. No, it can't be Inam
You're
land.
admitting or you're going by the verse?
I will have to show my lords that insofar as this is concerned, the government has retransferred it back to us.
Under what provision?
Because they were all Mujrai lands, not capable of being vested. They had all ceased to be Inams and had become Waqf by virtue of the 68 notification. Ili vesting order came in 1970. The act came in 54. So
Yes.
these land was not capable of being vested. No, that is one larger question insofar as whether this. I am now going to assume for a moment that some authority has a power to grant and it stood vested. Not, first of all, jurisdiction of the land tribunal is not. And there is absolutely nothing to show he was a tenant. Absolutely nothing to show. Some entries in his name for 3-4 years are there. He claims to be a tenant from 1963. And correctly on 68, 69, 70, 71, 72, 73 his names.
That is the requirement. 3 years.
Requirement. No, these are all,
3 years
these are all-
preceding 1970.
These-
Requirement.
these are all presumptible along with others, just
Yes.
not by itself.
No, I'm asking you what the law mandates.
No, no,
3
no.
years prior to 70.
3 years prior to, it should be on the 74 is the cutoff date. On that day, it should have been
74 ಬರಂಗಿಲ್ಲ ಇದಕ್ಕೆ.
1970 ಆದ್ರೂ ತಗೊಳ್ಳೋಣ, 1971 ಆದ್ರೂ ತಗೊಳ್ಳಿ.
70.
70 let us take because it was the
3
original.
preceding years to 1970.
68 in the start ಆಗುತ್ತೆ.
Yes.
Though he says he was a tenant from 1963
Hmm.
as per his this one. Two, my lord, the tribunal doesn't issue a notice to the board when it has already suffered an order earlier.
What is challenge now?
No, my lord, the land tribunal order.
What is the date of the order?
Lord, date of the order is 31/8/2011. Kindly see the remand order by this court. The remand happened on 1997. 14 years. The land tribunal doesn't do anything.
Yes.
And my lord, what my lords need to see today, this enactment of reforms were for the agrarian reforms for persons who really were poor agriculturists, not to a person who holds. I'll show the number of lands he held then and he continues to hold. This is not meant for these kind of people. If my lords were going to be convinced that yes, he is a poor agriculturist, my lord, then it should go. My endeavor is to show that he was neither a tenant, neither was he entitled to give, and 3 is no jurisdiction by the authority. Largely, my lord, this is my points.
You first cover your notification and the work fact, whether it precedes or vesting by under Inams. What's the law on that point? Then I will hear all other.
Yes, ma'am. But insofar as that issue is concerned, the lordship may have to then take the work fact, my lord, as it was there then. Give me the old act.
56.
1954.
54.
54. What of it? What of it?
54 work fact. Yes, madam.
Lords will kindly see the definition of work for a moment. But that is in 2 R.
Q.
KL, my lord. It was in the old act, it is at L. Section 2L. 2L. But it includes grants. That's what I wanted to show. All kinds of grants, so long as a grant is for a religious and charitable and pious purpose, to L, my lords.
ಇದು ಗಿರಿ ಹಳೇದು
ಆಯ್ತು ಹೊಸದು ತಗೊಳ್ಳೋಣ. We can more or less it's not much changed. ಏನಾದ್ರು ಚೇಂಜ್ ಇದ್ರೆ ನಾನು ತೋರಿಸ್ತೀನಿ.
ಅದು section 3
This should be in 2R. The only, I think, number is changed.
3R.
3R, only number is changed, but otherwise essence is the same. At least what I want to show is still continues. 3R ಅಲ್ಲಿ sub number 3, Roman number, is grants, all grants. So Inam is a grant. If it is for religious and pious purpose, it becomes a grant. That's my first point. Then section 4, David.
Yes.
Lord, for this, my lords may have to see the old act. ಹಳೇದಿಲ್ಲ.
ಓದಿತ ಓದಿ.
ಇಲ್ಲ ಇದೆ. Just mark for. Lord, your lordship will see in that section 4. It says survey of work existing as on day of coming into force of the act. Just mark that sentence. Section 4, my lord.
Yes.
So when a notification comes, it is my humble submission that it gives a list of what was existing as a work as on the day this act came. The notification may have come later because there is a process that takes place. Appointment of commissioner has to happen, survey commissioner has to go and make a survey, call for people, conduct inquiry. So a given land, if it conforms to the definition of the waqf in that act, and if it was existing as on the day the 54 Act came, then it is a waqf and ceases to be an inam.
How the properties under
Which are
Inam-
notified, which are notified.
No, we'll come to that. Why this discrimination?
No, I'll come to discrimination later.
No, because see, I'll tell you. You can fall back on Work for Act, forget Work for Act for a moment. If a village
Hmm.
or some lands are given to a holder for a specific purpose,
Please,
he holds that land as a inamdar,
as an inamdar. Yes.
limited right.
Yes,
limit-
yes,
Limited
yes,
right.
yes.
Once the inams are recalled, automatic vesting, it's a by operation of law.
Yes, madam.
Unlike under Karnataka Land Reforms Act, there has to be an inquiry to find out whether there is a vesting. But under Inam, there is vesting by operation.
Operation of what lands, my lord? Of those lands which were inams as on the day.
All right, so according to you, rest all lands will stand automatically vested with the government. But these lands which are given to a particular sect,
No, it's not particular
that.
sect. No, I never use the word sect.
I don't know, of course.
I'm only saying,
It comes in.
I'm only saying under that act. Lord, there are many other things that can happen. Now, for example, this court has taken in the case of Adimar Mutt case, that certain lands, they never characterized as a waqf. Division bench decision is there, I will show. They were not characterized inam. They didn't have, it was not an inam granted land. Therefore, it was not capable. Now, my lord, I am being now faced with a subsequent legislation, which was essentially made for a reform purpose, to grant lands to those persons who were actually tilling.
Whether state, which is the custodian of the public property,
Please.
is competent to dedicate this property?
Lord, at that point it was not for state. It must have, who has dedicated it? There is a dedication.
No, I'm asking you whether state is competent to dedicate. Work to property to be categorized as a work property, there has to be a dedication.
Please.
Followed by acceptance.
Please. Please.
Whether there is a dedication and whether state can dedicate.
Lord, in the year 1963, there's a Supreme Court decision in Yuan Jung's case, where the Nawab of, as a state of Hyderabad,
They can do it.
they had done it,
Now can do it.
that they can do.
I'm asking whether state.
Today, now the state can do, my lord, I think it's a question that requires consideration. I wouldn't say that state by itself, because if it is a property that it is giving so many grants to so many people, it is giving grants to landless people, it is giving grants to temple, it is giving grants to many other sects. To appease each community, my lord, it does.
No, if a grant is through the prism of Inam's Act, then you have to, there's the informity. The law is very clear. Once abolished, all lands will fall back on the government. There is a liberty to a holder to seek re-grant.
Yes, my lord. It's for a holder to seek re-grant.
Re-grant.
Re-grant. Now,
That's
the
only,
holder the holder in this case, according to me, should be by virtue of the notification, the board.
correct, fair enough.
Now, against the board, the person who claimed to be an inamdar also filed an application, who is also petitioner before my lords. And the applicant who has filed an application under the Religious and Charitable Inams Act also has filed. Therefore, my lord, since here, startlingly, the order is without jurisdiction.
Maybe.
Lord, for now, since my lord asked.
No, I'm agreeing with you on that point. Land
Only
Tribunal has no
but since
jurisdiction.
My lord asked, because
Question
if I
is-
can succeed on that, my lord, then this larger issue can be kept open.
And if there is a re-grant and simultaneously there is a claim for tenancy rights,
Please, my lord.
which will gain precedence. Whether
If he is a
tenant-
tenant, my lord, he should get it. If person is a tenant, they have to get it.
So
They have to get it.
re-grant is subject to tenancy rights.
Tenancy rights, yes.
Yes,
There have to be tenancy. I am saying here he is not even a tenant.
that has to be inquired. Question is whether you have a locus. Once you're able to convince that you have a locus, everything will fall in
We have a
place.
notification. We are the inamdar. They themselves filed an application again showing me as inamdar. I have my locus.
It has to go to the special deputy commissioner. for
Should
it.
at this moment go to, my lord, my learned friend's argument is under the tribunal has, as the DC and tribunal have given their mind, and they have called it as Qazi Service Inam, Qazi Service Devadaya, and therefore it should come under miscellaneous. Lord, it is clearly a religious grant.
Was it to an individual or to the?
It was to an institution.
To the institution.
That is what I'm saying. That's what I'm saying. There is an individual here who is claiming it to be his individual.
Yes, yes. Yes, madam. ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೀರಾ? ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಎನ್ ಕುಮಾರ್ ಸಾಹೇಬ್ ಜಡ್ಜ್ಮೆಂಟ್.
That which is given from Gulbarga High Court. I think so.
ನಾನು ಫಾಲೋ ಮಾಡಿದ್ದೀನಿ.
Allah, that is there in Supreme Court, my lord. It is stayed and it is.
ಅಲ್ಲ, is it stayed?
My lord, there's a status quo.
Or ಆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾಗಿದೆ?
State and commentary is there in SLP number.
ಯಾರು ಮಾಡಿಲ್ವಾ? ಇಲ್ಲ, ಚಾಲೆಂಜ್ ಆಗಿದೆ ಅದು. ಆರ್ ಯು ಶ್ಯೂರ್?
ಇದು ಚಾಲೆಂಜ್ ಆಗಿದೆ. Is in, I will tell you. SLP number 19701 and 72 of 2013.
It is still pending.
Still. Actually, I had to go to argue that it didn't come.
Stayed, madam. Are you sure it is stayed?
No, I'm saying not. There is a status quo order in that.
Allah, status quo.
The order is not per se stayed.
But maybe entry and possession ಬಗ್ಗೆ status quo ಇಡಬಹುದು.
Yeah, entry possession. So government what they will do with regard to that. Lord, I'm on a very short point.
You're not on that point now. You don't.
Lord, that case, Lord, from what I could understand, his lordship has held two things. One was that was a case where there was a similar notification like this, and there were about large extent of land was given by some earlier ruler to some institution, and there were many regrants. After about 40 years, the board filed, essentially canvassing the point that I have canvassed just now, which I said. This question, with utmost respect and great sense of responsibility I'm submitting, is not answered in either by the single bench nor the division bench. What my lords have held there is that if you want to take such a contention, you should have questioned the vesting order. And since having not questioned the vesting order or the act itself which said so, such a one. Two, his lordships also has gone on the factual aspects of that case and said, as per the records that are there, a finding is given that there was no dedication at all. Here, my lord, nobody is arguing that. Whether there was dedication. There has to be a dedication. If there is no inamdar, how can a tenant maintain a petition, an application? There is this very point, my lord, was considered by the. Yeah, one more copy. One more copy for him. But I'll just give a copy to my learned friend. Since my lords are considering a question of law. Lord, this was a case which went from Madras High Court, where this precisely what my lords asked. A particular sect is given something, and that sect, my lord, questioned it saying, under Article 26, 27 and all, we are all protected, a right to practice. Therefore, you cannot pass such laws of vesting, etc. That's what the argument was. I only request your lordship's attention to just 3 lines, last 3 lines in that decision.
Where, madam? Page?
My lord, I think we're having different page. Last para number 14, my lord, sir.
Para 14. Yes, madam.
Para 14, my lord.
Yes.
My lord, all that the says, the question will have to be defined in reference to so and so. Last, we also make it clear. Lordships have that.
Para 14, you said para 14. You said para 14.
Para 14, it was argued by Mr. Shastri.
It was urged.
Urged by Mr. Shastri.
Yes.
Lord, then just few sentences below, in the end of that paragraph, just above.
Yes.
We also make it clear. Fourth line from bottom of that para. very tense.
Makes, no, where are reading? I read para 14 better.
Please. But the applicability of the impugned act, the question cannot
I
be.
think you are carrying a different citation, it appears.
Yes, my lord.
Idodi. Which one you have given to? Idodi Kodrel.
Because this I was not going to rely, since my lord asked me a larger question of locus standi.
ಅಲ್ಲ ನೋಡಿ ಅದು ಬೇರೆ ಇದೆ.
But can I take the liberty to mark it?
Yes, ma'am.
Next page. I just put a small mark, kindly bear with it. Last page, not overturn the page. Because the rest are all facts.
Yes.
We also make it clear, I marked it.
Yes.
That the disposal of these writ petitions does not preclude the inamdars from agitating the question that a particular property is not a inam at all and does not under any of the aforesaid 4 categories or fall under one or the other of the categories as may be urged for the inamdars. What I'm saying, submitting, Lord, this question that I can always urge that it was not an inam land. Because government itself retransfer it back to us. No, this is an old decision where the constitutional validity of these vesting orders were questioned under the ground that Article 26 gives a protection to some kind of people, therefore you cannot anta. So for that, the court has said a given land, you can always say it was not an inam land.
Yes. Yes, madam.
These 2 points, my lords ask a question, so therefore I'm just trying to, but otherwise, Lord, my essential points are no lack of jurisdiction to the tribunal. And 2, my lord, board is not heard. No notice was given to the board. And my lord, 3, that particular appellant or applicant is not a tenant.
Not it.
Because there is no valid tenancy. Lord, once there is a tenant, there has to be an owner. Whether this tenant got the land from the owner. Who was the person? Because the so-called owner also has filed an application seeking for re-grant. That is the inamdar. And the inamdar says, he was never my tenant, he never gave vara to me.
Now this lands covered and inams were kept out of purview of land tribunal jurisdiction by a judgment rendered by this court.
By Kudli Sringari.
Under wrong assumption, land tribunal was in fact holding an inquiry and conducting and deciding orders. When actually that the judgment came and there was a notification
93, the
by the
judgment.
government saying that it has to, all these applications have to be relegated to special
Deputy
deputy
Commissioner.
commissioner, that too for inams.
That too for inams.
Inams.
The religious inams only.
Correct. You are right.
Only religious inams. But today the end result is, as I have understood the judgment and the enactment, Lord, there were 2 enactments made. Just to, Lord, I hope I can recollect. There were 2 enactments made to the Inams Abolition Act. By virtue of both the enactments, the jurisdiction which was existing with DC stood transferred to tribunal.
Yes.
And our High Court struck both the enactments, amendments. Supreme Court said, you could have only struck down what was in front of you. You could not have struck down the other one. So what was in front of them was religious inams abolition. So the transfer to tribunal was struck down and it continued with DC. Insofar as all other inams and of course land tribunal is always it. Insofar as all other inams are concerned, it continues. I mean, it by virtue amendment applies and therefore DC, tribunal. And my lord, earlier order was given by the correct authority because at that time it was by virtue of the amendment it went to land tribunal. And land tribunal, the application is under Religious Inams Abolition Act. How can my learned friend now say, no, it is not religious inams, it is under the miscellaneous inams. No application only under the Miscellaneous Inam Abolition Act.
ಇದು 6A ಕೆಳಗಡೆ ಇದೆಯಾ ಅದು?
ಅವ್ರು ಹೇಳ್ಬೇಕು ಎದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ. ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಲ್ಲಿ. Miscellaneous Inams Abolition Act. Miscellaneous Inam Abolition, you 3 tenants can get. Khadim tenant.
ಇದರಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹಾಕಿದ್ರು ಹಾಕಿರಬೇಕು.
Form 7 no religious inams ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. Now the DC say, the tribunal says, this is not a religious inam, this is a personal and miscellaneous inam. Without an application, how the tribunal can consider a re-grant without an application?
Read that land tribunal order now.
Please, Lord. Lord, can I just show the application for a minute before land tribunal order also is there in the writ petition? Kindly let us see the application that I have filed. Lord, notification on is not disputed. These lands are notified.
Yes.
Therefore, I'm not showing the notification. But anyway, I have put it at annexure C, page 20. Notification is there. Entire extent is notified. 5 acres and odd. Page 22. Annexure D. Lordship's got annexure D. ದಯವಿಟ್ಟು ನೋಡಿ. ಮೈಸೂರು ಪ್ರದತ್ತಿ ಮತ್ತು ಧಾರ್ಮಿಕ ಸಂಬಂಧವಾದ ಇನಾಮ್ ರದ್ದು ಆಯ್ತು. ಕಾನೂನು 1955. So the application is under the Mysore Religious and Charitable Inams Act. Then they have filed an application under 7(4), for seeking under 7(4). ಮೇಡಮ್, ಮೇಲ್ಕಂಡ ಜಮೀನು ಸೆಕ್ಷನ್ 4 ಪ್ರಕಾರ ಸದರಿ ಜಮೀನುಗಳನ್ನು ನನ್ನ ಹೆಸರಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಕೋರಿರುತ್ತೇನೆ. ಆಮೇಲೆ ದೇವಸ್ಥಾನದ ಹೆಸರು ಕಾಸಿ ಇನಾಮ್. ದೆನ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ ಶೋನ್, ಮೈ ಲಾರ್ಡ್. ಕೈಂಡ್ಲಿ ಸಿ ವಾಟ್ ಹಿ ಸೇಸ್. ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ವಾರಕ್ಕೆ
ಸುಮಾರು 8 ರಿಂದ 9 ವರ್ಷಗಳಿಂದ.
Yes. So kindly see the date of application 71. 8 ರಿಂದ 9 ವರ್ಷ ಅಂದ್ರೆ 1962 ಅಥವಾ 63 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಬೇಕು. $65 is the notification.
Yes.
Then, my lord, next annexure, my lords will see, is the objections that we filed in the first instance. This is to show that the applicant treated me as the inamdar. Board antane kottidare. The earlier order which is set aside is there. If my lord wants to see, he can give it a Kaibara order. Since that is already set aside, I have not produced it. Lord, here I took a essential contention that, my lord, he is not a tenant and the person Qazi was not authorized to give it on rent. But para 2, I will just read and leave it. As per section 15(2)(j) of the Act, the board alone is authorized to sanction lease of the land belonging to work for more than 3 years. In this case, no sanction from the board has been obtained. The lease cannot be said to be valid. The petitioner who is in possession of the land is contrary to section 15(2)(j) and 36 of the Act. Cannot be deemed tenant. He cannot claim any tenancy rights as occupant tenant. Then, my lord, the setting aside order, your lordship, please. Lord, this is a contention of the respondent. Therefore, I am also trying to answer here. Writ petition was filed by the another applicant who claims to be a Qazi. He questioned this grant order of 82. After, on the ground that I have made some additional evidence, namdu kelila, yaru kelila, so therefore kindly give me an opportunity to be heard. We were party to this petition. Board. Then kindly see the order, what the court said. The impugned order 31/7/82 passed by the land tribunal is hereby.
Where are reading, madam?
Lord, this is page number 29, typed page, or sorry, ink page, typed page 4 of the order of this honorable court. Then, Lord, land tribunal order is quashed. Then, Lord, direction at 3, small Roman 3. The land tribunal is further directed to pass considered order thereon by taking into consideration the evidence that was led by both sides earlier to the appeal, and further taking into addition any additional evidence. That additional evidence can be led by anybody, if any, by the parties to be adduced before it in the future. Then the land tribunal shall hold a limited inquiry and issue notice to all persons concerned. Now, the stand of the respondent is, this was a direction only to be heard between two rival claimants, applicants. Nimdena kelsa alla nimmanen kelo avashyakate illa. Therefore, principles of natural justice need not have been followed insofar as I am concerned, is the argument, is the defense. Therefore, I am just trying to show, my lords, that there was a specific direction that additional evidence can be adduced by all the parties and everybody concerned should be issued notices. And notice is not issued to the board. The Lordship might decide who is the jurisdictional authority and let them, let it be open for all of us to urge our points. Let the judicial authority take a call.
Who challenged in earlier round of litigation?
The earlier
Full-wide,
order,
Qazi.
Qazi.
And you accepted the order.
That's what I'm saying. It was set aside.
But you
Let's see.
didn't challenge this.
See,
order.
it's not, I am a party to this. If I was not a party, they had not made me a party, Lord, then I agree. I was a party to this, I became beneficiary of this order. And this honorable court has repeatedly said that in a application for between Inamdar and the tenant, all concerned has to be heard. They can't leave me out now. They themselves have called me as Inamdar. It's a notified institution. Lands are notified. So now to say you are nobody and then go, Lord, with utmost respect. Therefore, Lord, and Rule 17 very clearly says all parties have to be heard. That is the defense of the applicant here, that you never questioned, you accepted it. But somebody questioned that. And the order is set aside. Lord, let us assume the order was not set aside. Then yes, such a contention could be raised. The order is, that's why I read para 1, where the entire order is set aside, not a portion of it. Court said you take additional evidence from everybody. And I raised a legal question earlier that was not answered.
Yes.
Then, my Lord, generally this question is always asked to me, what my lords posed. There was a agrarian reform that has happened. There can't be someone who is exception to this agrarian reform. Everybody should fall in line. Yes. Let us do proper justice and give it to the person who really was an agriculturist, who really needs this land. The purpose of the agrarian reform was to enrich a downtrodden, not a person who is holding hundreds of acres, who has got the influence to enter the names at the relevant point of time. I will show all the material. My lords may decide. Whichever way is fine. At least justice should be done in the right direction. With agrarian reforms, keeping agrarian reforms, even let us assume an institution is deprived of its land, it's fine. But today, so many temples are there without any lands.
Yes.
No, then the impugned order.
Yes.
Now, the impugned order starts from page 12. But page 13, there itself, the para numbers are not numbered. Lord, the first paragraph is the narration of what happened earlier. I request the court's attention to the second paragraph. Accordingly,
Yes.
accordingly, my lords got that. Accordingly, the case was taken on file and notices were issued to both the parties to appear before the land tribunal and represent their case, and not to the board. When the High Court has given a specific direction that Rule 17 has to be fully followed, how the tribunal can only give notice to the two applicants without hearing the owner, Inamdar?
Yes.
Lord, then the next are all narration of what has happened earlier after their evidence and all. Not only to save time, I'm not going to repeat that, but we'll come to the order portion. Page 16. They're all narration of facts. If my lord so pleases, I can read it, but just to save time, order portion. 16.
Yes.
Not that. The land tribunal has examined the records carefully and considered the contention put forth on behalf of petitioner 1 and 3rd petitioner. No respondent here again. So no opportunity for us. In the instant case, the first instance, it would be relevant to mention that the land in question is a Qazi Inam Devadaya. This Qazi Inam Devadaya does not feature in the Miscellaneous Inams Act, whereas the tribunal concludes that it is. The Special Deputy Commissioner in his order dated 2/7/2007 has come to the conclusion that Qazi Inam squarely falls within the meaning of miscellaneous service Inam under subsection 3 of section 1 of Mysore Personal Miscellaneous Inams Act of 1954, and accordingly the matter remitted back to this land tribunal for consideration. So after it got remanded back by this honorable court, it went to the correct jurisdictional, that is Deputy Commissioner. By then the Supreme Court decision in Gauramma had come. So it went correctly to the Deputy Commissioner. Deputy Commissioner says Kazi Devadaya Inam. Kazi anno hesre illa in that miscellaneous Inam's explanation at all. And the application itself is not under miscellaneous, personal and miscellaneous. How can an application filed under another act can be given for consideration in another act and be transferred there? Even for a moment, let us assume my lords are going to hold that it comes under personal and miscellaneous Inam. No application is filed by anybody. This court has already taken a view that one application filed by for under act cannot be transferred to another application because the jurisdictional fact of all these are different. The tenant under the religious CS has a different rights. Tenant under Inam's miscellaneous act, different rights. Certain Inam's tenants are different. I should know what kind of a tenant I am. Then only I can choose where I come from. It's not that, oh, I'm a tenant, you can give me here or there or that. This court has said, no, that cannot be done. Then the instant case consequent to come into force of the Mysore Miscellaneous Inam Act, these land were vested to the government. The then land tribunal, Anekal, held inquiry into the matter threadbare and having considered the evidence rendered by the parties, especially come to the conclusion that Shri Abdul Wahab was not in possession and cultivation of the land in question, and accordingly the occupancy rights in respect of the land in question was conferred in favor of Venkat Reddy. First petitioner hearing on vide order dated 31/7/82, which is now set aside. However, the said order has been quashed by the land tribunal and the matter is remanded for fresh inquiry and disposal. It's not quashed by land tribunal, it's quashed by the High Court. They failed to place any documentary evidence to show that Abdul Baha was in occupation of the land and cultivating the same as on the date of vesting of the land with the government. Further on, looking into the statements of Abdul Baha, it is clear that his ancestors were receiving vara from first petitioner, much less the entries in the revenue court such as Pahani, etc., were continuing in the name since 1960. Lord, this is a perverse finding. 1960 in the no entries there. I admit from 1968, 69 entries have started. Then in furtherance of this, the contention of LRs of Abdul Wahab that due to ignorance he had not got the entries made in his name cannot be accepted. Thus, there is a clear evidence to show that there was a relationship of landlord and tenant between them. Hence, the presumptive value has to be attached to the entries in the Panis in the name of the first petitioner as on the date of vesting of the land with government, even before and even subsequently. The fact of occupancy and cultivation of the land in question by the first petitioner and his paying vara to the Qazi is specifically substantiated by the evidence of an independent witness. But who is this independent witness? Not forthcoming. Apart from this, possession of the land in question continued with the first petitioner. Apart from this, he is also paying land revenue in respect of land in question regularly. It would be relevant to mention that even after remand of the matter by the High Court of Karnataka, the third petitioner and his LRs on record have failed to adduce any further evidence to substantiate the fact that they and their ancestors, Shri Abdul Wahab, was in possession of the land cultivating the same. At this stage, it is relevant to refer the decision of so-and-so, so-and-so. Thus, the third petitioner's LR have utterly failed to substantiate their occupancy rights. In furtherance, the third petitioner, now his LRs have failed to rebut the presumptive evidentiary value of the entries in the revenue record contained in the name of the petitioner in respect of the land in question. Hence, the petition is entitled for registration of occupants in respect of the land in question in his favor. Insofar as the partition of properties among the members of the family Venkat Reddy herein, either under the subsequent partition deed or will, etc., it is not concerned with these proceedings. Lord, in this partition, my Lord, 13 properties are partitioned among the family members. Ashton land ide avra hatra. If he was poor tenant, my Lord, everybody should come to the rescue of such a tenant under the agrarian reforms that our country took place.
Yes.
It was not certainly not to enrich already strong holding landlords.
Yes.
But in these circumstances, unanimously resolved.
Where is that Inam register? You have produced Inam register?
No, Lord, it is not there. Government was called upon last time to produce when we argued this matter to call for records to see. Because I showed to the court a list, a government order of 1974, by which, my Lord, all these lands management stood vested back to the board. If it had already vested with the government, why did it have to transfer it back to the board, my Lord?
ಅದು ಇದು ನೋಡಿದ್ದೀರಾ page 19 madam?
Page 91,
Now 19.
19. Quit rent register. ನಾನೇ ಹಾಕಿದ್ದು.
ಅದರಲ್ಲಿ ಅದು ನೋಡಿ ಫಾರ್ ಕಾಜಿ
ಅದ್ರಲ್ಲಿ-
ಸರ್ವಿಸ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅವರು.
ಆ ಕಾಜಿ ಸರ್ವಿಸ್ ಇನಾಮ್ ಅಂತ ಬರ್ದಿದೆ.
ಅದೇ ಕಾಜಿ ಸರ್ವಿಸ್ ಅಂತ
ಸರ್ವಿಸ್ ಮಿಸ್ಲಿನಿಯಸ್ ಇನಾಮ್ಸ್ ಅಲ್ಲಿ ಬರೋಲ್ಲ.
ಅಲ್ಲ ಮೇಬಿ ಬಟ್ ಇಫ್ ಇಟ್ ಇಸ್ ಕಾಜಿ ಅಲ್ಲ ವಿಲ್ ಸಿ ದಟ್
ಕಾಜಿ ಸರ್ವಿಸ್ ದೇವದಾಯ.
ಅಲ್ಲ ಕರೆಕ್ಟ್
ಹಾ.
ಕಾಜಿ ಸರ್ವಿಸ್ ಅಂತ ಬರೆದ್ರೆ ಏನಾಗತ್ತದು ವೆದರ್ ಇಟ್ ಇಸ್ ಟು ಎನ್ ಇಂಡಿವಿಜುವಲ್ ಆರ್ ಟು
It
ರಿಲಿಜಿಯಸ್
was to a religious with a condition to a religious institution ಅಂತ ಹಳೆಯ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇದೆ. There's a 1918 records.
ಬಟ್ ಹೌ ಟು ರೀಡ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್
But we can probably produce that.
ಅಲ್ಲ ಹೌ ಟು ರೀಡ್ ಓನ್ಲಿ ದಿಸ್
This says for ಕಾಜಿ
ಕಾಜಿ
ಸರ್ವಿಸ್.
ಸರ್ವಿಸ್ ಅಂದ್ರೆ ಟು ಎನ್ ಇಂಡಿವಿಜುವಲ್ ಅದು
ಇಲ್ಲ ಮೇಡಮ್, ದೇವದಾಯ ಸರ್ವಿಸ್ ನೆಕ್ಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲಿ.
ಕರೆಕ್ಟ್
ಹಾ.
when it is to the institution ಅಲ್ವಾ ರಿಲಿಜಿಯಸ್
No,
ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್
as my understanding,
that goes to the institution.
it is to the institution. ದೇವದಾಯ ಸರ್ವಿಸ್.
ಇದು ಟು ಎನ್ ಇಂಡಿವಿಜುವಲ್ ಹೂ ಇಸ್ ರೆಂಡರಿಂಗ್ ಕಾಜಿ ಸರ್ವಿಸ್ ಅವ್ರಿಗೆ ಮಾತ್ರ ಇದು.
But it's what Supreme Court has taken a view only on Qazi services.
Ah.
The dedication is to the institution. The person who performs the Qazi service, that person will get.
ಆ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ?
Ide. I've produced it as a list of judgment. Oh, for Qazi service itself, there is a decision. Tenants of Qazi service ಕೆಳಗ್ ಬರಲ್ಲ ಅಂತ.
ಅದು ಜಜ್ಮೆಂಟ್ ಯಾವ್ದು ಮೇಡಮ್ ಅದು?
I will give. Separately. Lord, our High Court decision, what I've given and what you said, bunch ಈ ತರ ಕೊಟ್ಟಿದ್ದೇನೆ.
A list of authority.
Decisions ಇದೆ. I've
Yes.
given with decision.
Yes, ma'am.
Lord, in that, can I request my Lord's attention to 3. Case 3,
Case 3.
Karnataka, page number 15 of this bunch that I have given. There's
Yes.
one bunch like
Yes.
this.
This is dated 6th March 2021.
Oh.
The first judgment is Ramchandran, correct?
Yes, but 6th March, correct. First one is Gauramma's decision, correct.
Which one you want to rely?
Third decision.
Or third one, Kaji is only a
Qazi,
manager
yeah, is only a superintendent of a work.
of work property.
Has no right to claim property independent.
Independent.
ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದ್ದಾರೆ. In 15 to 19 is the page. Lord, this decision has attained finality and Supreme Court decision is referred in this. I will show that also. Lord, this is a 2005 decision, NRRP 6096. That's the decision I'm relying upon.
Yes.
Idralli, but these were all properties notified. Lord, para 5.
Para 5.
One other question my lords had asked. ಅದಕ್ಕೆ ಒಂದ್ ಸ್ವಲ್ಪ.
Yes.
In support of his argument, he has drawn my attention to the judgment rendered by the Andhra Pradesh High Court report in
ಅದ್ರಲ್ಲಿ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ತಾ ಇದ್ರೆ?
para 5 of this judgment of this LRRP.
ರಾಮಚಂದ್ರನ್ ಜಡ್ಜ್ಮೆಂಟ್?
ಇಲ್ಲ, ರಾಮಚಂದ್ರಲ್ಲ, serial number 3, page number 15 of that bunch. 15 is State Board of Secretary versus State of Karnataka.
Correct, State of Karnataka.
Idralli detailed order is there, my lord. It's a
Para 5.
para 5. There was another question my lord asked.
Yes.
In order to constitute a waqf, lordship was saying,
Para 5 starts with however.
in support of his argument, he has drawn.
Place reliance on a decision in the.
Received Andhra Pradesh High Court.
Ah,
In order to constitute a waqf,
yes.
it is not necessary to use the word waqf. As so long as it appears that the intention of the donor is to set apart any specific property or the proceeds thereof for the maintenance or support in perpetuity of a specific object or of a series of objects recognized as pious by the law, by Mohammedan law, it amounts to a valid amount. Then next, what is held? The position of a ghazi is analogous to the position of a shabet, whose position is similar to that of a manager or guardian of minor estate. Then my lord, Mutavalli yaru anta ಹೇಳ್ತಾರೆ. And many decisions. Para 8, I request attention.
Right.
Hmm.
Yes.
The decision rendered by the Supreme Court in Syed Ali versus Andhra Pradesh Waqf versus can be quoted usefully for the purpose of this case, wherein it is held that the dedication of property need not be in favor of Dargah. Grants by way of service inams for purposes recognized by Muslim law as pious, religious, or charitable constitute the property as a Waqf property. Waqf property permanent dedication grant under Inam's law does not nullify it.
Yes.
Then, my lord, however, in this case, there is no dispute. The property was dedicated by Muslim and it was also referred to as Qazi Inam land. In view of the subsequent notification holding that it was a Waqf property and the said notification not being questioned by anyone has become final and conclusive, treating it as a Waqf property. Therefore, the finding of both the tribunal as well as the appellate authority confirming the order holding the property being Devadaya Inam land for Qazi service and the provisions of Karnataka religious and charitable inams are applicable because of section 6C of the said act and shall be entitled to a person rendering any religious service in the religious institution for registering him as occupant is contrary to the well-settled positions of law. As Kasi is only a superintendent or manager, he has no power to claim property independently as that to the work. His position is analogous to the position of a Shabayat and accordingly, therefore. Lord, this decision squarely covers a Qazi. My lords have seen. So that is applicable to this writ petition. There is a writ petition filed by the Qazi's family. So that is writ petition number.
Yes.
35473 of 2005 connected. Iದ್ರ ಜೊತೆಗೆ connect ಆಗಿರೋದು 35473 of 2005 is filed by the LR of the Qazi. Questioning this very same tribunal orders, claiming independent right because their forefathers served as Qazis, they say they are entitled.
More writ petition ಇದೆ ಅಲ್ಲಿ.
ನಾಲ್ಕಿದೆ ಸ್ವಾಮಿ.
ಒಂದು your action under 51 ಆಯ್ತು.
54 ಒಂದಿದೆ. ಒಂದು by the Qazi family.
Yes. Who is representing them?
Some of the petitioner is appearing. But I'll give that writ petition for it. But yeah, 4874 of 2012. It's connected today. That is filed by these LRs of Abdul Wahab. Pencil. This decision squarely. Now I am answering whether a tenant of a Qazi, my learned friend, is now claiming to be the tenant of a Qazi. Whether he is entitled for a occupancy rights. Lord, a patta, here lordships have very clearly said, grant of patta under Inam's Act does not nullify it. Lord, what I want to propagate ultimately, you may get a patta, but you can't become the owner of a land which by character is not inalienable. You can hold a patta, you can, at best, if my lords were to hold that Inam's Act are applicable even for Waqf land, it can't, there is, because of the character of a Waqf that it is, cannot be alienated at all, because it ties up with the corpus. because that is how the trust is structured.
Yes.
The grant of a patta cannot take away the character of a land. And therefore, Supreme Court says, therefore, the grant itself cannot be made anotara. They've said in that Sayat Ali's case.
Yes.
Please, my lord. So, insofar as the tenancy is concerned, there's one more, a couple of more decisions in that bunch itself. This court has held that the notice to the board is mandatory.
Records are there, no records? Order sheet notary. Whether work board was notified.
ಅಲ್ಲ ಆರ್ಡರ್ ಅಲ್ಲೇ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ ನಾವು ಇಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದ ನೋಟಿಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ. In the
Notary.
impugned order itself, I just read. Lord
No,
saw.
we'll see the order.
Yes, we can see the order, but from my instructions, my lord, the order, impugned order itself very clearly says we've issued only to the to both the parties to appear. That is, both the applicants. ಹೆಸರಿಗೆ ಮಾತ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲಿ ಬೋರ್ಡ್ ಹಾಕಿದ್ದಾರೆ. And when they heard also,
Which one is the next judgment you are relying?
please, next judgment that I wish to rely upon. The very next judgment, my lord, 24 page number.
Yes.
Lord, this is a case in LRRP 6032 of 98. That's what is there with my lords. Land Tribunal Shiradu.
Yes.
The question which my lord asked, whether they're at all capable of being granted, whether there is any bar at all to be granted, all this court has answered these questions before.
Yes, madam.
Who is deemed to be tenant? One by one, the court has looked at every definition. It's there. Then the next decision, my lord. Writ petition 4th January 2008, the very next decision.
Yes.
Lord, the court posed the question that my lord specifically asked at page 28. 28, whether the provisions of Karnataka Certain Inams Abolition Act is inconsistent with the personal law of Tammathalu. That court did not answer that question. It said we will leave it open. But what the court said is important. My lord, that is what para 13. 12, I will read para 12. What the court said is, the impugned order having been passed in the year 2002 and the application having been filed in the year 1979, notwithstanding whether the provision of the Waqf Act or the provisions of 1995 Waqf Act are applied, the validity of the tenancy agreement is subject to the provisions of the Waqf Act. What the court is telling is, the tenancy agreement should be valid under the Waqf Act. This question has not been addressed nor answered. It is only when if the tenancy agreement is held to be valid that the tenant become a lawful tenant for consideration of occupation is what this court has held. Whether at all he was a tenant under the board or the Qazi Anudu, the tribunal doesn't say. The tribunal just says from 1960 his name is there, which is a perverse finding. From 1960 his name is not there. Yes. Records may be seen. I have looked at records. I am admitting from 68 or 69 it starts. 69 it starts. It's a classic case of a case which my lords are seeing many places where 69, 70 enter adre. Those will be by powerful people is all I can say. Lord, next, my lord, next decision. Very next decision. So this is given in the year 1996.
Next illa, ide kadedu. Ide last statement.
And, we filed it on 6/3/2021.
6/3?
2021.
Which is the last judgment?
35 pages se kottidiri.
Ah.
Page 38 vargu irbeku. One more decision is there of His Lordship Justice Ullal last.
Correct. Adella kade judgment. You are right.
Ade kode judgment.
Yes.
No, what first I showed was Lordship Justice Anand Bere Reddy.
Correct. Correct.
Adadmeli this one. Notification is conclusive.
Yes.
Therefore, tenants cannot get anta idral bandidare.
Idರಲ್ಲಿ ಯಾವ paragraph?
ಹೇಳ್ತೀನಿ. Notification is issued, anta they have the honorable judge has noted. Then para 14.
Yes.
So what the judge says is that being case, that is if notification is issued, it is not open to the land tribunal to doubt the claim of the petitioner that they are not the owners of the subject land. Once notification is issued, Lord, I become the owner. The land tribunal cannot sideline me.
Yes. Not issue. They'll tag ಹಾಕಿಡಿ also.
Lord, one more decision that board has to be given a notice. Division bench decision ಇದೆ. ರುಕ್ಮವ್ವ ಅಂತ ಅದು ಒಂದು ಸೆಪರೇಟ್ ಆಗಿದೆಯಾ? One more, this is a division bench decision. There's one recent one also. Once I finish, I will take all of it, make another and give it back.
You are arrayed as a party, you are a respondent number 3.
But notice ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ.
Notice ಕೊಟ್ಟು.
So just last 4 lines, page 7 ಅಲ್ಲಿ, no order recording of property could be passed without impleading or hearing the board ante. This is under the Land Reforms Act alle ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, sir. .
Lord, that decision, I should have put it here. I did not know. Two decisions, my lord asked one question, 1963 one decision ನಾನು ಹೇಳ್ದೆ. Who can give Nawab of Advant, I want to show, I have only one copy, I'll make copies and then
Please.
reply ನಲ್ಲಿ ಹೇಳ್ತೀನಿ ನಾನು.
Ready.
And one more is that Syed Alidu.
We'll
Whether
continue tomorrow. Madam,
tomorrow, yes, tomorrow.
ಸ್ವಲ್ಪ ಇದಾವೆ ಎಲ್ಲ ಅಪ್ಸೈಡ್ ಡೌನ್ ಆಗಿದೆ. You ask your,
I will put again, I will,
Colleague.
can I take that bunch back and,
ಅದನ್ನ you do.
ಬೇಡ ಇನ್ನೊಂದು bunch ಕೊಡ್ಲಾ?
ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ.
ಇನ್ನೊಂದು ಹೊಸ bunch ಕೊಡ್ತೀನಿ ಎಲ್ಲ ಹಾಕಿ.
Please. Yes, tomorrow. This will
2:30.
continue tomorrow. Yes, next. ಯಾವುದು? RF ಇದೆಲ್ಲ. ಇನ್ನೊಂದು ಯಾವ್ದು ಮಾತಾಡು, ಅದು ತಗೊಳ್ಳೋಣ, ಕಡೆಗೆ ತಗೊಳ್ಳೋಣ. ಯಾವ್ದು ಇದೆ? ಮತ್ತೆ ಯಾವ್ದು ಇದೆ? ಯಾವ್ದು ಹೋಗಿದ್ಯಾ?
ನೀನ್ ಕೊಡ್ತೀನಿ ನಾನು.
ಅದು ಯಾವ್ದು ಹೋಗಿದ್ಯಾ ನೋಡಿ.
4 o'clock matter I'm ready.
Yes, I'll take. ನಿಮ್ದೆ. You will conclude today. ಬಸವರಾಜ್ ಅವರೇ.
ಹೌದಾ? Okay.
ಮಾತಾಡ್ ಮಾಡಿದ್ಯಾ? ಇಲ್ಲ ಇನ್ನು ಇದು ಮಾತಾಡು. ಇದೆಲ್ಲ ಎಷ್ಟು ರಿಪೀಟ್ ಮಾಡ್ಬೇಡಿ. ಎಷ್ಟಿದೆ ಮಾತಾಡು. Tomorrow, madam, please. See the shearing. You can wait for shearing. ನಿಮ್ದು ಆಮೇಲೆ ಜೆ ವಿಶ್ವನಾಥ್ ರೆಡ್ಡಿ.
My lords, in this matter, serial number 3, my lords.
Yeah.
Lords, your lordship on the last date of hearing directed the government to get the records from the ACDC. My lords, of course, I could get some documents which said to have been filed by the contesting respondent before the, my lords, KAT. My lords, the so-called grant.
Now I'm running out of time. Can you please cooperate with us?
But ಅಲ್ಲ ಅವ್ರು ಕೊಡುವಂತ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಕೊಡ್ತಾ ಇದ್ದೇನೆ ಕೋರ್ಟಿಗೆ.
ಹೌದಾ?
ಒರಿಜಿನಲ್ಸ್ ಅಲ್ಲೂ ಇಲ್ಲ, ಅಲ್ಲಿ ಹಾಕಿದ್ದು ಫೋಟೋ ಕಾಪಿನೇ, ಅದನ್ನೇ ಕಾಪಿ ನನಗೆ ಸರ್ವ್ ಆದ್ವಿ.
Yes. ಹೌದಾ?
My lords, as per this document, my lords, the respondent claims to have been granted in way back in 1964. Here is the, my lord, may submit this document just for perusal, my lords.
ನೋಡೋಣ, ಇದು ನೋಟ್ಸ್ ಕೊಡಿಲ್ಲ, ಏನೂ ಗೊತ್ತಾಗಲ್ಲ. ನನ್ ಕೊಡಿ, ಅದು ಕೊಡಿ, ನನ್ ನೋಟ್ಸ್ ಇದೆಯಾ? ಅದು ಎಲ್ಲ ಬೇಕು. Just brief me, otherwise comes.
My lords, what had happened is, the petitioner herein is the grantee under defense quota. He was a ex-personnel. He was serving in army, so he was granted with land bearing survey number 200.
Correct.
And
no, got it.
Please.
Assistant Commissioner doesn't issue notice.
Yes, no, he recalls the notice.
Recalls, you suffer an order.
Yes.
But your revision is allowed.
Yes, my appeal
Commission.
before DC was allowed. Against which they came before
Got
KAT and KAT passes an order.
On an assumption that you were not noticed.
Yes, as if that I am the appellant before the court. Now, the document which I am shown to the court now. Sir, page number.
ಯಾಕೆ ಇದು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಇದು ನೀವು?
On the other day, learned senior counsel had contended that we have been granted with the land way back in 1964. Therefore, it requires consideration. He read the order passed by the assistant commissioner at page number.
Correct.
I'll just show it to you, my lords.
ಈಗಾಗಲೇ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅವ್ರಿಗೆ.
Grant, actually grant alladu, they claim that it is a grant, except this document, no other documents are available before the court. Court or anybody, my lords. My lords, may I draw the attention of the court to page number 67, my lord, second paragraph.
Page 67.
60. ಇಲ್ಲ ಆಯ್ತು ಕೊಡ್ತೇನೆ ಎಲ್ಲ ಕೊಡ್ತೇನೆ ಅಲ್ಲಲ್ಲ I'll make my submission. 100%.
Original records.
If at all my learned friend has the copies, all the copies, my lords, but my handicap is only these copies are there now.
All right, I will again adjourn it, Mr. Hegde.
Unless it's furnished to me, I will not be able to.
No, I will definitely furnish it. 1 second, I'll make my submission to the court.
1 second, it's not over.
No, it is not.
My lord knows, when we say 1 second, many times, my lord.
Page 67, my lord, second paragraph. ಪ್ರಸ್ತುತ ಆದೇಶಕ್ಕೊಳಪಟ್ಟ ಭೂಮಿಗಳು ಈಗಾಗಲೇ ಮೇಲ್ಮನವಿದಾರ ಸೋ ಅಂಡ್ ಸೋ ಇವರಿಗೆ KDR ನಂಬರ್ 382:61 ದಿನಾಂಕ 12/3/64ರಲ್ಲಿ ದರಖಾಸ್ತು ಮಂಜೂರಾದ ಬಗ್ಗೆ ದಾಖಲೆ ಮೇಲ್ಮನವಿದಾರರು ನೀಡಿರುತ್ತಾರೆ. On the basis of this observation, your lordship directed the government to get the document. But now, this order which I am now referring, which is produced by the contesting respondent before the
Correct. So you should hold all those documents. They were produced before Assistant Commissioner?
They have produced before Assistant Commissioner, they have produced before KT.
also.
Howdo, this is the document, entire set given by them to me. But interestingly, this land, my survey number is not there. My lords, except this document, there are no other documents with the revenue authorities to show that there is a grant in his favor. This is the only document which shows that he has been granted in 1964. I agree. I am not contesting that.
But this petition land is not part of this grant.
No. So therefore, he is a person who is non-suited to file this, contest this matter. Well, if at all, if he can show that this particular survey number, that is survey number, my lords, (299)(1)(a), measuring 1 acre, 10 cents, is the land in question. Let him show one document.
299, but 2A is there.
2A is there. That is different. Mine is 1A. So therefore, even if the court summons all documents possible by the government to produce, it doesn't help in any way.
These are the documents on which they have placed reliance.
Which they have placed it before the KAT.
Wait, I'll pen down. I have not made notes. We need a brief notes, otherwise.
May I make it and give it?
No. Num notes idre namaga adu ಬೇಕು.
ಸರಿ ಅದು ನಮಗೂ ಹಾಗೆ ಆಗುತ್ತೆ.
ಹೆಗಡೆ ಅವರು ಎಷ್ಟಾದ್ರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ.
Copy ನಾನು ಕೊಟ್ಬಿಟ್ಟು ಅರೇಂಜ್ ಮಾಡಿಸಲಬಹುದು. ಇಲ್ಲ ನಾನು ಕಾಪಿ
ತಗೊಂಡ್ಬಿಡಿ, ನಿಮ್ದೇ ಅದು. ಇದು ನಿಮ್ದೇ.
was there, my lord. He died. So my lord, none of the records are available now. With children are there.
See, petitioner,
I request my lord.
ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ petitioner has successfully retrieved. I don't know from where, all Xerox copies.
Please, my lord.
And he'll just go through.
Please, my lord. Pass the copy so that I will be.
ಇಲ್ಲ, ನೀವೇ ಒಂದು ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೋಬೇಕು. ನೀವು ಯು ಕಾಂಟ್ ಲೀಗಲಿ ಇನ್ಸಿಸ್ಟ್ ದಟ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಯೋರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಕೊಡ್ರಿ ಗಿರೀಶ್. ನೋಡಿ ಚಂದ್ರ.
So that if a lot.
ಯಾವ document? ನಿಮ್ document.
I will be able to assist then and there, otherwise my lord again.
ಅಲ್ಲ like ನೋಡಿ, I am not deciding today.
Please, sir. You will not make.
Tomorrow, ಇದು ನಾಳೆಗೆನೆ.
ಆಗ್ಬೋದು.
ಈ ಎರಡೇ ವಾರ ಈ ರೋಸ್ಟರ್ ನಮಗೆ. So no respect for you people.
Kindly see, my lord, I also pray, not only this, now, this I not see, my lord, kindly see the order, which I was relying upon, which my lord printed one, sentence,
57,
huh?
57 page number.
Please, my lord. 67.
67.
67, my lord.
Hmm.
It's at the top. ಸದ್ರಿ ಭೂಮಿಗಳ ಪೈಕಿ ಆಂಶಿಕ ಭೂಮಿಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರು ಸೊ ಅಂಡ್ ಸೋ ಮರೆ ಮಾಡಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. ಆದೇಶಕ್ಕೆ ಒಳಪಟ್ಟ ಭೂಮಿಗಳು ಈಗಾಗಲೇ ಮೇಲ್ಮನೆ ದೇವಕಾವರ ಶೆಟ್ಟಿ ಅವರಿಗೆ ವಿಚ್ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಸೇಸ್ ದ ಆರ್ಡರ್ ಇಸ್ ದೇರ್. ನಂಬರ್ 2. ನಂಬರ್ 3 ಪ್ಯಾರಾ ಪೇಜ್ 67 ಪ್ಲೀಸ್. ಪಾಯಿಂಟ್ ನಂಬರ್ 2. ಪಾಯಿಂಟ್ ನಂಬರ್ 3. ಮೇಲ್ಮನೆ ವಿಧಾನ ಪ್ರತಿವಾದಿ ಪ್ರಶ್ನಿತ ಆದೇಶದಲ್ಲಿ ಮಂಜೂರಾದ ಭೂಮಿಗಳ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಅಪರೇಟಿವ್ ನಲ್ಲಿ 93ರಲ್ಲಿ ಆದೇಶ ದಿನಾಂಕ ಡ್ಯಾಶ್ ಮತ್ತು ಸಹಾಯಕ ಕಮಿಷನರ್ ಅವರು ಮಾಡಿದ ಆದೇಶ ಪ್ರತಿವಾದಿ ಸಚೀಂದ್ರ ಡ್ಯಾಶ್ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯು ಸಹಾಯಕ ಕಮಿಷನ್ ಮಾಡಿದ ಆದೇಶವನ್ನು ಸ್ಪೆಷಲ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಮಂಗಳೂರು ಎತ್ತಿ ಹಿಡಿದಿರುವುದು ಸಹ ಕಡತದ ದಾಖಲೆ ಕಂಡು ಬರುತ್ತದೆ. ಪುತ್ತೂರು ಮುನ್ಸಿಪಲ್ ನ್ಯಾಯಾಲಯದಿಂದ ಮೂಲದಾವ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಮತ್ತು ಅದೇ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ ಕಮಿಷನ್ ವರದಿಯಲ್ಲಿ ಪ್ರಶ್ನಿತ ಭೂಮಿಗಳ ಪಾಲ ಹಿಂದಿನಿಂದಲೇ ಮೇಲ್ಮನದ ಬಾಧ್ಯತೆ ಖಚಿತವಾಗುತ್ತದೆ. ತಹಶೀಲ್ದಾರ್ ಸಚಿವ ಮಂಜೂರಾತಿಗೆ ಮೇಲ್ಮನದವರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ ವಿಷಯ ಕಡತದಲ್ಲಿ ನಮೂದಾಗಿದ್ದರೂ ಸಹ ಆಕ್ಷೇಪಣೆ ಪರಿಗಣಿಸಿ ಕಂಡುಬರುವುದಿಲ್ಲ. ಆಕ್ಷೇಪದಾರ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದಾದರೂ ಸಹ ಹೇಳಿಕೆಯಲ್ಲಿ ಆಕ್ಷೇಪಣೆಗಾಗಿ ಇವರಿಗೆ ಮಂಜೂರಾದ ಬಗ್ಗೆ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ವರದಿ ಇದ್ದರೂ ಸಹ ಅವರಿಗೆ ಯಾವುದೇ ಸೂಚನೆ ಬಗ್ಗೆ ಇರದೆ ಏಕಮುಖವಾಗಿ ಮಂಜೂರಾತಿ ಕಂಡುಬರುತ್ತದೆ. ಏಕಮುಖ. So one sided order. Next.
No, you check out your, see,
Please.
your claim is based on edifice that this land was granted to you prior to this.
There are other aspects also, my lord. All these are found there. The notice was issued, the inquiry was held.
No. First you show that this land was granted to you.
The one aspect, my lord.
No, that is the main aspect. If there is no grant in your favor, then you lose locus. You will lose locus. You have no right in the property.
Two aspects, my lord.
No. First you overcome that fundamental hurdle.
Please.
If you are able to show that this was granted to you, which is earlier in point of time,
Please.
your grant is prior to their grant, then you have a case.
Please.
ಅದು ನೋಡಿ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಇದೆ ನಿಮ್ಗೆ ಯಾವ್ದು ಗ್ರಾಂಟ್ ಆಗಿದ್ದು. Yes, Mr. Hegde.
Last but ಪ್ರಶ್ನಿತ ಭೂಮಿಯ ಸ್ವಾಧೀನತೆಯ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ಪುರಾವೆಗಳು ತಹಶೀಲ್ದಾರ್ ಕರ್ತವ್ಯವಿರುತ್ತದೆ. ಸ್ಥಳ ತನಿಖೆಯಲ್ಲೂ ಪ್ರತಿವಾದಿಗಳು ಪ್ರಶ್ನಿತ ಭೂಮಿಯನ್ನು ಸ್ವಾಧೀನ ಹೊಂದಿರುವುದಿಲ್ಲ ಮತ್ತು ಮೇಲ್ಮನವಿದ ಸ್ವಾಧೀನ ಇರುವ ವಿಷಯ ಮೈ ಲಾರ್ಡ್ಸ್ ಟು ಗ್ರಾಂಟ್ ಅಂಡ್ ಅಕ್ರಮ ಸಕ್ರಮ ನಾಟ್ ಓನ್ಲಿ ದಿಸ್ ದೇ ಶುಡ್ ಬಿ ಇಫ್ ಐ ಆಮ್ ಇನ್ ಪೊಸಿಷನ್ ದಟ್ cannot be granted to somebody else, my lord. ಸ್ವಾಧೀನತೆ and that date is required and the documents show that he is not in position. ಮೇಲ್ಮನವಿ ಸ್ವಾಧೀನ ಇದ್ದರೆ ಬಂದರೂ ಗಮನಕ್ಕೆ ಬಂದಿದ್ದರೂ ಸಹ ದಿಸ್ ಇಸ್ ಎ ಕೇಸ್ ಆಫ್ ಫ್ರಾಡ್ ಯಾವುದೋ ಒತ್ತಡಕ್ಕೆ ಮಾಡಿದ ತಹಶೀಲ್ದಾರ್ ಮಾಡಿದ ಆದೇಶವಾಗಿರುತ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಮೂಲ ಕಡತ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀಮತಿ ತುಂಗಮ್ಮ ಮತ್ತು ಸಚೀಂದ್ರ ಇಸ್ ದ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ಮೈ ಲಾರ್ಡ್. ಇವರ ನಮೂನೆ 50-53 ಅರ್ಜಿಗಳೇ ಇರುವುದಿಲ್ಲ. ಗ್ರಾಮ ವೈಗಳ ಯಥಾನಕಲು ಮಾತ್ರ ಲಭ್ಯವಿದೆ. ಈ ಬಗ್ಗೆ ಕೂಡ ಪರಿಶೀಲನೆ ಅಗತ್ಯತೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಮಂಜೂರಿ ಕಡತಗಳ ಪರಿಶೀಲಿಸಲಾಗಿ ನಮೂನಾ ವರದಿಯನ್ನು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಸ್ಪಷ್ಟವಾಗಿ ಜಮೀನಿನ ಆಕ್ರಮಿತ ಜಮೀನಿನ ಮಂಜೂರಾತಿಗೊಂಡ ಅರ್ಜಿದಾರ ಅರ್ಹತೆ ಬಗ್ಗೆ ತನಿಖಾಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯ ಎಂಬ ಕಾಲಂನಲ್ಲಿ ಹೀಗೆ ನಮೂದಿಸಲಾಗಿದೆ. ತುಂಗಮ್ಮ ಪ್ರಕರಣದಲ್ಲಿ ಆಕ್ರಮಣ ಜಮೀನು ದೇವಕುಮಾರ್ ಶೆಟ್ಟಿ 29(2)A, ಶೇಷಪ್ಪ ಗೌಡ 22B ಕದೀಂ ಜಮೀನಿನ ಕುಂಕಿ ರೀತಿಯಲ್ಲಿ ಇರುತ್ತದೆ. I also wish to canvas on that, my lord. ಈ ಜಮೀನಿನ ಆಕ್ಷೇಪದ ನಾಮಿನ 50 ಮತ್ತು 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು. My lords, your lords, please to direct me, my lords, that unless I hold on that property that the darkast is there, my lord. Two aspects. One, there is a darkast. Even if it is held, my lord, darkast is not confined as per survey numbers is concerned, my lords. Your lords may also take judicial notice. Many times survey number gets subdivided and now it becomes different survey number. Even if it's so, now as far as this land is concerned, we have also claimed, my lords, Kumki privileges. At one point of time, Kumki could not have been granted in Dakshakara district, my lord. Subsequently, that bar is removed. And after that, my lords, they have also claimed filed application for grant of the same land, even if it's held that that's not the land which is granted, that is different land. You have filed application. ಆಕ್ಷೇಪದ ನಮಗೆ 50 ಮತ್ತು 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ತನಿಖೆಗೆ ಬಾಕಿ ಇರುವುದು. And only submission that was also pending. Both should have heard together and decided our application should also be disposed of together. Not that one application is taken up and then decided. And ಸಚೀಂದ್ರ ಆ ಪ್ರಕರಣದಲ್ಲಿ ಆಕ್ರಮಣ ಸ್ವಾಧೀನದ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರಿಗೂ ಆಕ್ಷೇಪದಾರ ಅಬೂಬಕ್ಕರಿಗೂ ತೀವ್ರ ವಿವಾದ ಇದೆ. ಅರ್ಜಿದಾರ ಮತ್ತು ಆಕ್ಷೇಪದ ವರ್ಗ ಜಮೀನುಗಳಿಗೆ ಪ್ರತ್ಯೇಕ ಬೇಲಿ ಅಗಲುಗಳಿದ್ದು ಆಕ್ರಮಿತ ಜಮೀನು ಮಧ್ಯದಲ್ಲಿರುತ್ತದೆ. So what they claim is now is also the case how the piece of the village is lost. That entire other lands are ours. Some land is in our possession. He is coming and saying, I am claiming this land. Surrounded lands are ours. He claims the land is in the middle. That's what is observed, my lord. ಅರ್ಜಿದಾರ ಮತ್ತು ವರ್ಗಗಳು ಪ್ರತ್ಯೇಕ ಬೇಲಿಯಾಗಿತ್ತು. ಆಕ್ರಮಣ ಜಮೀನು ಮಧ್ಯೆ ಸ್ಥಳದ ಪರಿಶೀಲನೆಗೆ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದು. ಎಷ್ಟೇ ಕ್ರಮ ಇಸ್ ನಾಟ್ ಸ್ಟಾಪ್ ದೇರ್. ಮುಂದಿನ ಕ್ರಮ ಆಫ್ಟರ್ ಸ್ಥಳ ಪರಿಶೀಲನೆ 20 ರಾಜ್ಯ ಉದ್ದೇಶಗಳು ಈಗ ಪೂರಕವಾಗಿ ಮೂಲ ಕಳಸದ ಪುಟ 92ರಲ್ಲಿ ಫ್ರಾನ್ಸ್ಗೆ ದರಖಾಸ್ತುಗಳು ಕೊಡುವುದಕ್ಕೆ ಆಕ್ಷೇಪವನ್ನು ಅಬೂಬಕರ್ ಅವರ ಹೇಳಿಕೆ ರೂಪದಲ್ಲಿ ಲಿಖಿತವಾಗಿ ಸಲ್ಲಿಸುತ್ತಿರುತ್ತದೆ.
Continue tomorrow.
Day after, one day, so that I could look into it. Only one. I am thankful. And also, my lord, my kindly pardon me for this. These documents may be required to the 92. Only in this case, my lord, with the very board that Devakumar Shetty is no more, my lord. We do not have the files with us. No, they have to produce this 92. There may not be any problem. 92 only Akshep Abubakar did it. Then Abubakar has filed an objection. And he was also a party. He is not heard and because to place before the honorable court.
Yes, madam. Records ಯಾವಾಗ? Records ಎಲ್ಲಿದೆ? You tell them ಯಾರು ಮಾಡ್ತಿರೋದು ರೆಕಾರ್ಡ್ಸ್ ಹೆಂಗ್ ಪಾರ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್ ಹೇಗೆ ಅದು? No, ask them. You ask deputy commissioner to forthwith make arrangement and secure the records. ನಾವು ಕೇಳಿ ಆಮೇಲೆ ಮತ್ತೆ ಇದೆಲ್ಲ ಆಗಲ್ಲ. Day after tomorrow, 2:30. Please. Grateful. ಬಸವರಾಜ್ ಕಲ್ಬಿಡಿ. ಎಷ್ಟಿದೆ? Yes, sir.
My lord,
Copy
2
submitted.
acres. 2 acres of land, my lord, had been leased to the petitioner, my lord, to run an educational institution under Rule 19 of the Karnataka Land Grant Rules of 1969. My lord, the office memorandum is at Annexure A, page 17, my lord. Subsequently, a lease deed is also executed. At page 20, the lease deed is produced. My lord, 2 acres of land is situated at survey number 57 of Chikbanavara village. My lord, in the very same survey number,
Lease is cancelled. What is cancelled?
Lord, the lease had been granted in relation to 2 acres of property in survey number 57 of Chikbanavara village. Lord, in the very same survey number, there is also a lease granted in favor of another institution, my lord, to an extent of 13 acres. For me, there is a lease amount which is required to be paid at the rate of 50,000 per acre. 2 acres is granted in my favor. So far as the other land is concerned, only 5,000 is required to be paid per acre. My lord, that is 13 acres of land. My lord, in the year 2007 and 8, I've been issued this lease. 2008, I make a requisition to the revenue department saying that please revise the lease amount at par with the other institution. My lord, that was being considered. That was my lord, being considered up till 2020. 2020, there is an office memorandum in which they.
How much is the demand now?
My lord, the demand they've not specified, my lord. That is.
Even if we take it as 50,000 per acre.
Please. My lord,
annually.
My lord, the outstanding amount would be about 17 lakhs. 17 lakhs is the principal amount. The interest is to be calculated.
You will deposit 10 lakhs within 4 weeks. Otherwise, I'm not granting any.
Please, my lord. I bow down. I'll deposit.
Yes, madam. 10 lakhs.
It's an educational institution, my lord. There is also.
Is cancellation of grant at the lease cancel. Lease is what? For how many years?
Lease is for 30 years.
No. Your lease is not terminated or lease is terminated?
Lease is sought to be terminated under the impugned order.
Return haktira ನೀವು?
Lord, there is a preferential treatment, my lord, to the other institution. And there is.
Petitioner and educational institution has obtained a lease for a period of 30 years. The lease contemplates payment of 50,000 per acre annually towards rent to the respondent state. Petitioner has been submitting a representation to the government to revise the lease, to revise the rent at par with the adjoining educational institution, which is also awarded 13 acres of land with the rent at the rate of 5,000 per acre. Petitioner alleges that there is a discrimination. Since there is a default since 2008,
2008, 2009 and all. 2009.
The respondent state has passed the impugned order, thereby cancelling the lease. Having heard the counsel for petitioner and bearing in mind the interest of students who are pursuing in a school or college.
There are 3 colleges, my lord. There is.
For pursuing respective courses, this court deems it fit to grant some protection till next date of hearing, subject to petitioner depositing a sum of 10 lakhs before this court within a period of 4 weeks. Stay is granted.
Very well. Lord, sir, just make this. I've also advised him. 17 years in substance is not paid.
Correct.
It will be 1 lakh rupees per.
You can negotiate now. Granted time, stay, subject to deposit of 10 lakhs.
Very well.
Within 4 weeks, please negotiate.
Lots
Make out a case. Order. What about, yes, list it in preliminary. March.
Lots of.
And what about office objection now?
I'll
In
complete.
major area.
I'll complete.
Order.
In a
A week's time to remove office objection.
Great.
Next. Yes, Mr. Shastri.
Petitioner in this matter, ma'am.
Ah?
Petitioner in this. Annexure A, I'm challenging the annexure A, my lord.
What is the urgency, Shastri? You have moved it.
No, my lord.
Where in there?
Now, this order, it was not in my light at all because it has been passed, my lord, and now
Who has passed an order?
On Saturday, Tahsildar, Bangalore South, my lord. I have not even noticed of this order, my lord, and he says that I have to remove the encroachment. In the previous order at Annexure B, my lord, he says that he gives a direction to the revenue inspector that if at all I have done any encroachment over a tar road.
Without ascertaining now this order is passed?
Yes, without even noticing me, my lord,
Fine.
notifying me. And the backdrop of the case is that, my lord,
Madam, seek instruction, madam. ನೋಡ್ರಿ ಫೋಟೋ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ನೋಟಿಫೈ ಮಾಡಿರ್ತಾರೆ ನೋಡಿ ಬರ್ಕೊಡಿ
Block the Nakasha road.
ಆರ್ಡರ್ petitioner.
it is their own direction. I have left 5 guntas of land and the Pradhan Mantri Gram, this Sadak Yojana. Being a good Samaritan, I have left 5 guntas of land. They want to take away another now about 10 guntas of land now. ma'am.
Petitioner alleges that the impugned notice indicating that petitioner has encroached is not preceded by an inquiry, and this said order is also in violation of principles of natural justice. Petitioner, referring to the records, would point out that 5 guntas of land is already given up by petitioner without insisting for compensation
Please.
for having lost 5 guntas. Matter requires consideration. Learned AG shall secure instruction. Till then, respondent authorities, second respondent is hereby
Yes,
directed.
respondent number 2 and 3. Both
2 and 3 are hereby directed not to precipitate till next date of hearing. Leave this matter preliminary on so and so date.
Highly obliged.
Office objection to be removed within a week.
Grateful.
ಇದು ಯಾವುದು?
Parted matter. ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ
ಹಾ.
ಕಲ್ಯಾಣ ಬಸವರಾಜ್ ಸರ್.
Rest of the part head will be repeated and need not wait. Serial number 5. ಅವೆಲ್ಲ ನೋಡೋಣ, ಅದು ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Serial number 5 in the list too, my lords. Parted matter.
ಅವೆಲ್ಲ ಡೇಟ್ ಸರ್, ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಸರ್. You ask your instructing council to collect dates. Dates ಕೊಡ್ತಾರೆ ಆಮೇಲೆ. Wherever there is interim order, it will extend. Please don't trouble the court.
May I make my lord?
Ah.
Serial number 8, my lord. They have one applicant has moved an application. Let there be a direction, my lord, to serve the copy of that application to me. So that I may know what, who are the applicant, how they are necessary, all those.
Serial number?
8, my lord.
ನೀವಾ? You have to serve the respondent also. You can't say that since he's a respondent, co-respondent, I will not serve ಅಂತ ಅನ್ನಕ್ ಬರಲ್ಲ. ಕೊಡಿ, serve ಮಾಡಿ.
Next week sometime.
Yes, sir, date will be assigned, sir.
Number 8, records have come. My lords have perused the records. I have concluded my argument.
ಹೌದಾ? ನಮಗೆ ನೆನಪೇ ಇಲ್ಲಲ್ಲ ನೀವು ಯಾವಾಗ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರಿ. ಲಾಸ್ಟ್ ಪ್ರೀವಿಯಸ್ ರೋಸ್ಟರಾ? I have to just brief me. Some other day. It's a
That was
pattern.
only a preliminary hearing, my lord, not.
ಓ ಅದು ಇದು ಗ್ರಾಂಟ್.
Grant, ಆಮೇಲೆ subsequently we placed above
yes.
document.
Satish, twice ಅದು that release from party.
Now, my lord, it appears, my lord, he said.
ಈಗ ನಮ್ಮ ಮುಂದೆ ಬರುತ್ತಾ? Then I've heard, let me see some other day. Satish. ಆಯ್ತು, ಮೆನ್ಷನ್ ಮಾಡಿ ಹತ್ರ. I'll take it. I'll take it. You please mention at 2:30. You have to wait. ಇನ್ನು ಹೇರ್ ಮಾಡಿಲ್ಲ ಚಟ್ರೆ. ನೀವು ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ ನೋಡೋಣ. ಇನ್ನು ಹೌದಾ? ನೋಡೋಣ ಇರಿ. ಏನ್ರಿ ಹಾಸ್ಯಗಾರ, ಎಷ್ಟು ಮಾಡ್ಬೇಕು ಹೇಳಿ ಕೆಲಸ ಏನು? ಆಯ್ತು ನೋಡೋಣ.
Lordship, you have been directed me to produce a citation.
You got the judgment, full bench judgment? What's the name of that citation, madam?
Regarding CN Nagendra Singh versus Special D.
You read it? You went through the judgment?
Relevant to our.
You read the judgment? Very good. Give it, give it. Yes.
Serial number 9.
ಇಲ್ಲಿ
Serial number 9, madam. Entry ಮಾಡಕ್ಕೆ.
ಇಲ್ಲಿದೆ ತಗೊಳೋದ್ರ? ಗಿರಿ ನೀವೇ ಕೊಟ್ರ ಹುಡುಕ್ಬೇಕ್ರಿ ಅವರು, ನೀವು ಕೊಡ್ಬಾರ್ದು ಅವ್ರಿಗೆ. ಸೋ ಸ್ಮಾರ್ಟ್ ಅಲ್ವಾ? ಎಸ್ ಸರ್.
But in serial number 33 of list 2, Manoj, this is that case where land was granted to the society, short submission, Manoj.
Date will be assigned.
Please,
Date
Manoj,
will be
date.
assigned. There are too many parted matters. You wait and you collect the dates.
My
Collect
only
the-
submission is that the matter was.
Collect the dates, sir.
Please.
I've got around 35 parted matters are there.
Great.
You collect the dates. ಏನ್ರಿ ವಿಜಯ್ ನಿಮ್ದೇನು? ನಿಮ್ದು ಯಾವ್ದು ಪಾಠ ಇದೆಯಾ?
ಪಾರ್ಟರ್ಡ್ ಇಲ್ಲ, ಅದೊಂದು ಓಲ್ಡ್ ಮ್ಯಾಟರ್.
ಯಾವ್ದು ಓಲ್ಡಾ?
ಹೌದು.
2013 ಆರ್ಡರ್
12, ಇಟ್ಸ್ ವೆರಿ ಶಾರ್ಟ್, ಒಂದು 10 ನಿಮಿಷ ಸಾಕು.
ಒಂದ್ ಶಾರ್ಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ ನೋಡ.
ಹೌದು.
230 ಮೆನ್ಷನ್ ಮಾಡಿ.
ಹೌದು.
ಎಸ್ ಸರ್, ಎಸ್ ಸರ್, ಬಸವರಾಜ್ ಸರ್. ಬರೀ ಜಡ್ಮೆಂಟ್ ಸಿಗ.
A few exhibits, very, very relevant. Because the next year comes about writing up on these exhibits. Exhibit D1, madam. D1 to D3. If the document issued by the survey authority have taken up the survey work in the year 1970. Exhibit D3 grant. The survey authority speaks about the fact as to how my client has acquired the property. D3. Third sheet. which are allowed.
Exhibit
Exhibit D3. You will think about the, as to how my client father, the respondent, this is respondent has acquired the property, subject property, A property. Like the registered sale deed dated 23/1967. Hence ownership confirmed at the survey authority. Having looked into this document, the survey authority confirms that the ownership is conferred on the respondent under this document, that is registered sale deed dated 23/1967. The document, the measurements shall be in conformity with the measurement shown in the registered sale deed. There cannot be any sketch or any dimensions which the survey authorities can show, contrary to the one which is found at exhibit D3.
What is this exhibit D3?
That is, he has purchased through sale deed dated.
Exhibit D3. ಅದು ಯಾರು ಸೇಲ್ ಡೀಡ್ ಅದು? ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ವೆ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಏನು what you can gather from this document?
Purchased through sale deed dated so and so 23/1967 from Pushpa Kartamma to change word so and so. Hence ownership confirmed. That is the observation made by the survey.
ಅಲ್ಲ, they are admitting your title.
Yes.
They are disputing only that extent.
Yes. And in so far as there the documents also, it is only under the registered sale deed under which they have acquired the property in year 1936. And next document, exhibit their document, that is of the year 1936.
ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್?
D10. 10A. 10A is the type class.
10A. Yes.
Apparently, two properties were sold. East west 43, north to south 100 feet.
43 ಬಂತು ಒಂದು ಕಡೆ. ಇನ್ನೊಂದ್ರಲ್ಲಿ
ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ east west 30 feet, north to south 65 feet.
ಈಸ್ಟ್ ವೆಸ್ಟ್
30 feet, north to south 65 feet.
ಇದು ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿನಾ ಇರೋದು?
He purchased it in the year 1936. Both these properties are separate properties.
ಅವ್ರದ್ದು ಈಸ್ಟರ್ನ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಪೂರ್ವಕ್ಕೆ ಇರೋದು ಅವರು.
ಹೌದು.
ಒಂದರಲ್ಲಿ 43 ಇದೆ, ಒಂದರಲ್ಲಿ 30 ಇದೆ.
But ಇವೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಇವೆರಡು. They does not form one unit. What I am trying to say is, what was trying to contend on the last occasion when you were at CA council is, two properties were sold. We don't know in respect of which property the measurement was extended from 41st to 40th. That was the argument advanced. In that context, not
This is not a one block.
one block. In year 1961, Lord.
Yes.
Yeah, 1960, the person who has purchased the property and the exhibit given A. 1961, he sells it to one Ishwara Putri. And he refers to the earlier sale deed dated 31/1/1936. And
Right.
which he purchased the property.
1963 ಸೇಲ್ ಡೇಟ್
61 sale deed.
61. ಇದು ಯಾರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು?
Ishwar Putri. He is the Sanjeevappa, the father of the defendants, sells it to Ishwar Putri.
ಈಶ್ವರ್
Pattar.
ಈಶ್ವರ್ ಪತ್ತಾರ್ purchased from defendant's father.
Defendant's father. Apparently, kindly go to the schedule. Apparently, east to west, on the northern side 60 feet, southern side 50 feet. Immediately, 40 feet gets enhanced to 50 feet.
East west is
East to west, on the southern side 50 feet. In the place of 40 feet.
ಅದೊಂದು southern side 50 feet.
So how did Sanjeevaya, who acquired the property in year 1956, could sell the property which is measuring east to west, 50 place in the place of 40?
On northern side ಎಷ್ಟಿದೆ?
What?
Northern side ಎಷ್ಟಿದೆ?
Northern side 36 feet.
36.
From north to south 130 feet.
ಅದು
That is in between.
that is it.
Again, if he buys it back under D12A, same Sanjeevaya who sells it to Patta, he buys it back with the same measurement. ಪೂರ್ವ ಪಶ್ಚಿಮ ಉತ್ತರದ ಕಡೆ 36 ಅಡಿಗಳು.
ಅದು
ದಕ್ಷಿಣದ
ಡಿ
ಕಡೆ 50 ಅಡಿಗಳು.
ಅದ್ಯಾವುದು ಡಿ
D12A.
12A. One Sanjeeva repurchases.
It is repurchase.
Sanjeeva ಯಾರು?
Defendant's father.
Oh,
Oh, he holds it on the date of the suit. Same property.
ಇದು ಸೇಲು ರೀಪರ್ಚೇಸ್ ಅದನ್ನ ಬರೀ ಎಕ್ಸ್ಟೆಂಡ್ ಗೋಸ್ಕರ ಏನಾದ್ರು ಮಾಡಿದ್ದ?
Financial ಅಂತ. ಈಶ್ವರ್ ಪಪ್ಪ, we are supposed to be a financial.
ಒಂದು ಮೆಜರ್ಮೆಂಟ್ ಕೊಟ್ಟು ಸೇಲ್ ಮಾಡಿ ಮತ್ತೆ ತಗೊಂಡ್ಬಿಟ್ರೆ ಎರಡು ಸೇಲ್ ಡೀಡ್ ಆಯ್ತಲ್ಲ. All right, father repurchases.
So I have produced the synopsis as to how my client has acquired. P25A is the type copy of the title deed under which the plaintiff before the trial court acquired this property. The dimensions are not east to at 48 feet, north to 95. From one Putnanjamma. In turn, this lady Putnanjamma acquires it under exhibit P24.
ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ನೋಡಿದ್ವಿ ಅವೆಲ್ಲ ನೋಡಿದ್ವಿ.
So my respectful submission is, from east to west, the dimensions of the plaintiff's property never changed. Continue. I have produced the title deed.
They change it only while
Oral evidence not letting to dislodge the value of this document cannot be accepted in section 9 evidence.
Yes.
The exhibit, the title deed was produced, was marked, and nothing, no documentary evidence is produced to dislodge the evidence of this document, and as such, I have put issue number 1. In so far as speaking declaration of that. So there are two contentions. One submission was made that power attorney was examined, she was not conversant. Otherly,
ಎನ್ ಕುಮಾರ್ ಸಾಹೇಬ್ ಜಜ್ಮೆಂಟ್ ಇದೆ.
the power attorney herself is the party to the appeal now.
ಇದೆ?
Party to the appeal. If father is dead, she is not on record.
Oh.
And exhibit, one document is produced to show that her father was ailing from heart disease,
And one medical certificate was also produced, P47. No cross examination in that time. And she was a mechanical engineer, who was conversant with the facts based on the title deeds. She spoke about it. She diligently answered all the questions.
N. Kumar Sahib judgment is.
So that pension also cannot be accessed. In so far as law of limitations are already submitted, is the court we can find in so far as the suits which are the statutory suits, money suits, the court can look into it whether on the face of the record if it is barred by limitation, the court can reject it, right? In this case, no such contention was taken before the trial court and no issue was framed, and now at the tag end of the evening, they cannot make the submission in the air. I have relied upon some judgments.
ಕೊಟ್ಬಿಡಿ ನಾನು ನೋಡ್ಕೊತೀನಿ. ಹೇಳ್ಬೇಕಾ anything particular?
They bank upon the findings of the survey authorities, having regard to the fact that I am before the court seeking the relief of declaration, is subject to full bench judgment of the dishonor. So there is no.
ಕೊಡಿ ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ, ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. Order for the
Judgment and decree is well founded. The learned judge has gone into all these documents with regard to the measurements, particularly on the east to west side, and answered the issues accordingly and does not warrant any order
for dictating judgment. Next week. Yes.
May make one submission. Seal number 34 in list 2, my lord, sir. Lord, I have been, my lord, in the enjoyment of property. I have purchased the property, my lord, in action, government action. Lord, in the year 19.
ಯಾವ ವರ್ಷದದು?
ಅಲ್ಲ, suit decree ಆಗಿದೆ. I filed suit against the government, my lord. The government, my lord, that came to be, my lord, decreed. The preliminary hearing ಅಲ್ಲಿ ಯಾವ್ದೋ ನೋಡಿ date.
Seal number ಯಾವ್ದದು?
34 list 2.
ನೋಡ್ರಿ ಅದು based on decree ಇದೆ ಅಂತ ನೋಡಿ.
34, my lords.
ಯಾವ ವರ್ಷದದು?
ಅದು 2020
ಹಾಕಿ preliminary ಹಾಕಿ.
preliminary hearing. ಯಾವ date?
Call it.
24.
One small submission.
Yes, ಅವ್ರದ್ದು ನೋಡ್ರಿ ಯಾವ್ದು ಒಂದು.
One small submission. This was previously C number 33, man. Previously part heard ಆಗಿತ್ತು ಮುಂದೆ. And it was eventually released, man. ಮತ್ತೆ part heard ಮಾಡ್ಕೊಬೇಕಂತ.
ಅದು ಡೇಟ್ ಕೊಡಿ, I will hear you on that day.
With kind permission, review petition ಧಾರವಾಡ ಬೆಂಚ್ ಕೊಂಡು.
ಅದೊಂದು ಡೇಟ್ ಗಂಗಾಧರ್ ನೋಡೋಣ, ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಯಾವ್ದು ರಿವ್ಯೂ ನೋಡ್ರಿ. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಅದು ನೋಟಿಸ್ ಪೃಥ್ವಿ ಅವರು ಇದ್ದಾರೆ.
My lords, my lords, notice has to go to parties, my lords, because in contempt petition, my lords, Ramesh Misal has filed wakalat, my lords. So, my lords,
No respite for Gangadhar. Already issue emergency notice to respondents. He is also reserved with liberty to serve a copy of review petition on Ramesh Misale.
Please.
Please.
Yes, madam. ಯಾವ್ದ್ರಿ? ಶಟ್ರ್ ಬಿಡಲ್ಲ ನಮ್ಮನ್ನ. ನಾವೇನೋ ತಪ್ಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕಂತ ಮಾಡಿದ್ರೆ ಏನ್ರಿ ಶಟ್ರೆ ಏನು ಆಯ್ತಲ್ರಿ, ನಿಮ್ ಕೊಟ್ಟ ಎಲ್ಲ ಆಗಿದೆಯಲ್ರಿ, ಇನ್ಯಾರು ಕಾಡ್ಬೇಡ್ರಿ. ನಿಮ್ದು ಯಾವ್ದು ಪಾಠ ಆಡಿಲ್ಲ ಶಟ್ರೆ, ಏನ್ ಮಾಡ್ರಿ ಇದು?
ಇದರಲ್ಲಿ ಅಕ್ರಮ ಸಕ್ರಮದಲ್ಲಿ ಫಸ್ಟ್ 4
ಯಾರು ಹೂ ಇಸ್ ಅಪೋಸಿಂಗ್ ಯು?
ಗವರ್ಮೆಂಟ್ ಮ್ಯಾಟರ್.
ಹೌದಾ?
4 ಮ್ಯಾಟರ್ ಇದೆ ಸ್ವಾಮಿ. ಒಂದು ಮ್ಯಾಟರ್ ರಿಮಾಂಡ್ ಆಗ್ಬೇಕು, 3 ಮ್ಯಾಟರ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಮೈ ಲಾರ್ಡ್ ಕ್ವಾಶ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್, ಬಟ್ somebody's ನೇಮ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪಾಸ್ಡ್. ಸೀರಿಯಲ್ 28.
ಯಾವ ವರ್ಷದದು ಶಟ್ರ್ ಅದು?
ಅದು 2019 ಸ್ವಾಮಿ. 19 ಮತ್ತೆ 22 ಇದೆ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಮೈ ಲಾರ್ಡ್.
ಇಲ್ಲ ಬರೇ ಇದು ಜಸ್ಟ್ ಬ್ರೀಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ.
ಒಂದೇ ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾನೆ ಸ್ವಾಮಿ.
ಯಾವುದು
ಇದು? ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಮೈ ಲಾರ್ಡ್, ಚಂದ್ರಕಲಾ, ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 27 ಮೈ ಲಾರ್ಡ್. Annexure B.
ಪೇಜ್
27 27. ಸ್ವಾಮಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಚಂದ್ರಕಲಾ, ಅಪೀಲ್ದಾರರು ಸರ್ಕಾರ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮೈ ಲಾರ್ಡ್. ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು 1ನೇ ಪ್ರತಿವಾದಿಗಳಾದ ಶಂಭುಲಿಂಗಯ್ಯ, ಬಸವಣ್ಣ, ಅರೆದಾಳು ಹಾಗೂ ಗ್ರಾಮ. 2ನೇ ಪ್ರತಿವಾದಿಗಳ ಶ್ರೀಮತಿ ಪ್ರಭಾವತಿ, ವೈಫ್ ಆಫ್ AB ಶಂಭುಲಿಂಗಯ್ಯ ಅಂತ ಯಾರ ಹೆಸರಿಗೆ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡಿ.
ಇದು ಪಾರ್ಟಿನೇ ಅಲ್ಲ?
ಪಾರ್ಟಿನೇ ಅಲ್ಲ. ನಮ್ದು ಆಕ್ಚುಲಿ ನನ್ನ ಹೆಸರು ಚಂದ್ರಕಲಾ ಅಂತ ಕಾಸ್ಟೇಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾರೆ. ನಾವು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತೀವಿ, ಯಾರ್ದೋ ಆರ್ಡರ್ ತೆಗೆದು ಇಲ್ಲಿ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಎಂಟೈರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್. ನಮ್ಗೆ ಅಷ್ಟು ಪ್ರಾಪರ್ಟಿನೂ ಇಲ್ಲ, ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಗ್ರಾಂಟ್ ಆಗಿದ್ದು. ವೇಟ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮಲೋಡ್, ನೆಕ್ಸ್ಟ್ ಸಿ 1 ಎಕರೆ 84 ಸೆಂಟ್ಸ್.
This order does not pertain to you according to you.
According to me, it is not pertinent to me. And my lord, facts, my lord.
ಎಲ್ಲ cut and paste.
Sorry, my lord, I should not say. ಏನ್ ಮಾಡೋ ಸುಮಾರು. ಆಕ್ಚುಲಿ ನಂಗೆ ಗ್ರಾಂಟ್ ಆಗಿದ್ದು 1900.
ಅದು ರಿಮೈನಿಂಗ್ 3 ಮ್ಯಾಟರ್ಸ್ ನಾವು
ಅದ್ರದ್ದು ರಿಮೈನಿಂಗ್ 3 ಅಂತ ಹೇಳಿದ್ರೆ ಕಾಫಿ ಅಗ್ರಿಕಲ್ಚರ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಗ್ರಿಕಲ್ಚರ್, ಕಾಫಿ ಇಸ್ ಅಗ್ರಿಕಲ್ಚರ್ ಮೇಲೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿ ಕರ್ನಾಟಕ ಪ್ಲಾಂಟೇಶನ್ ಕ್ರಾಪ್ ಮೇಲೆ.
ಅಲ್ಲೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಮ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಅಲ್ಲ ನೀವು, ನಿಮ್ದು ಫಾರ್ಮ್ ನಂಬರ್ 53 ಇಲ್ಲ ಅಂತೇಳಿ ಎಲ್ಲ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ 3ರಲ್ಲೂ ಒಂದೇ ತರ ಆರ್ಡರ್.
ಆಯ್ತು ನೋಡ್ರಿ, ಎಲ್ಲ ಪಾಠ ಅಂತ ತಗೊಂಡ್ಬಿಡು.
Grateful, man.
ಏನ್ರಿ ಚಂದ್ರಚೂಡ್, ಏನ್ರಿ ನಿಮ್ದು?
Serial number 14 of the second list.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
The declaration suit is also decreed in my favor.
ಹೌದಾ?
Ah.
And it has attained finality, no appeal.
No, ಅಲ್ಲ, ಒಂದು 3 ದಿವಸ ಆಗಿದೆ ಹಾಗೆ. It's a declaration suit where it had filed.
ಅಲ್ಲ, only 3 ದಿವಸ ಆಯ್ತಾ? 3 ದಿವಸ ಆಯ್ತಾ?
I had filed a suit for declaring me as the absolute owner in possession. That has been decreed.
Decreed. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಅದು?
Serial number 14.
ಅದು ಬೇಸ್ಡ್ ಆನ್ ಡಿಗ್ರಿ ಅಗ್ರಿ. ಪ್ರಿಲಿಮಿನರಿ ಹಾಕ್ಬಿಡಿ ಅದು. ಪ್ರಿಲಿಮಿನರಿ. ಯಾರಿದ್ದಾರೆ? ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಇದಾರೆ ಅಲ್ಲಿ?
Private party, one contesting private party. all the-
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ, ಹೋಗಿದೆ, ಎಲ್ಲ ಹೋಗಿ ಸ್ಟೇ ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. The revenue officer had interfered with my possession title over the property, for which I had advised my client at the time when I filed the writ petition. The suit is now decreed.
Suit is decreed.
Suit is decreed.
Serial number
Older, army man, my lord. That's the only problem.
ಆರ್ಮಿ ಮ್ಯಾನ? ಈಗ ಅದು ಥರ್ಸ್ಡೇ ಹಾಕೊಡ್ರಿ ಅದು. ಅದು ಪ್ರಿಲಿಮಿನರಿ ಥರ್ಸ್ಡೇ ಹಾಕ್ರಿ. ಎಸ್ ಎಸ್.
Serial number 36 ಮುಲ್ಲ. Only Mandamus ಮುಲ್ಲ. Detail.
ಯಾವ್ದು ನೋಡ್ರಿ 36? ಎಲ್ಲಿ ಸರ್ಕಾರ ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ರಲ್ಲ. ಮ್ಯಾಂಡಮಸ್ ಅವ್ರ RF ತಗೊಂಡ ತಕ್ಷಣ ಹೋಗ್ಬಿಟ್ರು ಅವರು.
36.
ಯಾವ ವರ್ಷದದು?
25 ಮುಲ್ಲ. 25.
25.
ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿತ್ತು.
ಮ್ಯಾಂಡಮಸ್ ಚೆಕ್ ಮಾಡಿ ಶಾರ್ಟ್ ಡೇಟ್ ಪ್ರಿಲಿಮಿನರಿ.
ಪ್ಲೀಸ್.
ಮ್ಯಾಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಎಂಟ್ರಿ ಮಾಡ್ರಿತ್ತು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ನಂಬರ್ 1 ಹಾಕಿದೀವಿ.
ಇಲ್ಲ, Mandamus ಐತೆ.
ರೆಪ್ರೆಸೆಂಟೇಷನ್